Recording in progress. Recording stopped. Recording in progress.
Honorable members, good morning. It is 11 o'clock. I see that most of us have joined for today's meeting. You are welcome. Can I please check with the Secretariat if we have apologies?
Good morning, Chair. Advocate Brettenbach and Ms. Barnard indicated that they are traveling, but they've joined the meeting. They indicated that they might have some connectivity issues along the way, but they are trying to be. They've joined the meeting.
Yeah, I'm also traveling, but I'm going to stop somewhere in the next 20 to 30 minutes. Can you please slide the agenda and see if members agree with the agenda?
Chair, can I ask Babana to slide the agenda? I'm struggling with my laptop this side.
That is accepted. Honorable members, that is the agenda, the consideration and adoption of the draft terms of reference and the discussions thereof. Is there anyone moving for the adoption of the agenda?
I move, Chair. Honourable James.
Honorable
I
James.
second Ian Cameron.
Any seconder?
I second Honourable Cameron. Thank you, Chair.
Honorable Cameron, second. Can I check if there is any who wants to add an item on the agenda? Okay. In the absence of that, we will take this agenda as adopted as the agenda of today's meeting. We are going to move straight to item number 4, which is the consideration of draft terms of reference, we will do the item 4 and 5. The consideration and the discussion will be done jointly. The meeting will take this shape. We are going to take the draft terms of reference item by item. At each and every item, or at each item, the legal team will give us its impressions on the legal implications that the members of the legal implications of the proposals or submissions that members of the ad hoc committee would have made. And the reason why we take this route is that we must not discuss an item for a very long time, and later the legal team comes and say, but by law, this thing is not possible. So if they can take us through and say, on item 1, there are the following proposed additions which have been made, and those additions are legally permissible or legally impermissible. And then we go to discussions. Once we are done with that item, we will go to the next item, take the same procedure until the end of the meeting. So until the end of the item, each and every member is going to be given the right to speak the same way we did in the last meeting. And I think it has been very effective. I did not hear any of the members complaining that they were not afforded a chance to speak in the meeting. Can I check if we agree with the procedure as I outline it? Agreed?
Agreed. Agreed, Chair.
Thank you so much. Let's,
Agreed.
Andile, can we move to the terms of reference? If you can, the document or whoever is assisting you, if the document can be flighted on the screen, it's here, it's appearing on the screen. The last time when we were on item 1, which gives us the background to the terms of reference, there were 2 submissions which were made on 1.1 by the Action SA and 1.5 by the EFF. And can I check with the legal team on the 2 submissions made by the parties? Are there any legal implications on the submissions made by the 2 parties?
Good morning, Honorable Chairperson. Good morning to the members, and
Yes.
morning to my colleagues as well. I'm not sure if I'm audible, Chairperson.
We can hear you, but it's like you are a bit far from the microphone. I don't just find a way to adjust yourself.
Chairperson, I'll ask someone in the meantime to come and assist me. Chairperson,
Okay.
we have no issue. Chairperson, we have no issue with these 2 proposals. Thank you very much.
You have no issue, ne?
Yes, Chairperson.
And the submissions here remain 2. Is the Action SA and the EFF?
That's correct, Chairperson.
So let's start with the Action SA and allow them to speak to their submission if they want to motivate it, or if they say no, we are fine. Honorable James, whatever you may want to say on the submission that you have made.
We are fine with it, Chair.
You are fine with it?
Yes, thank you.
Okay, let's give chance to the EFF. Can I check with the EFF if they are fine with the submission that they have made, or they want to say anything regarding their submission? Do we have honorable members from the EFF in the meeting?
Yes, Chair. It's Honorable Matthys. I said that we are
happy with that
You
section.
are
We
okay.
agree.
Okay, it's
Yes.
fine now.
Oh,
The two parties that have made submission to item 1, we are dealing with item 1 as a whole because there were generally no issues except the 2 submissions. Can I then start the rotation? ANC, what is your comments on the submission made by the 2 parties? You agree or you disagree?
Thank you, Comrade Chair. Maybe let me just come in on the submission made by the EFF on 1.5. As the ANC chairperson, we are in agreement with that submission. We find it acceptable, and we would have no problem with that submission being approved. On 1.7, Chair, I'm not sure. You only asked Action SA and EFF, but there's a submission that's made on 1.7 by the MKP, which is speaking to the seriousness of the allegations, and therefore the terms of reference must meet higher standards of quality, legality, fairness, and safety. I'm not sure, Chair, if I should proceed on the MK submissions, or you want to ask if they want to speak to those submissions.
Yeah, let's come to it later. Let's deal with the 2 from the EFF and the Action SA.
Okay. Sorry, Chair, can I ask that the screen is moved down to the Action SA submission, because for some reason I don't seem to have it. 1.5 is the EFF submission that we have accepted, and then 1.7 is the MKP recommendations, which you are saying we must deal with later. I'm not sure, Chair, if the problem is on my side, but I'm not picking up the Action SA submission on the document before.
It must have been on 1.1.
Could I ask that perhaps the committee team can direct us to that submission?
Yeah, I think the way it looks is that it has been already effected to paragraph 1.1. Yeah, but the committee, the drafting team can take us through. Andile. There was one or two words that the Action SA has added on item 1.1.
Chair, my hand is up.
Honorable James. Yes, Honorable James.
Sorry, I muted myself. Chair, it was actually just MK and EFF that made submissions. What Action SA did, you actually covered me now, was just basically give input in terms of how, I think it was 1.1, the paragraph read. So instead of saying concerns, we said allegations.
That's exactly what I'm saying, because it was done, it was corrected and effected in that meeting last week, Thursday. So I just wanted to check if you are happy that the addition has been made to that paragraph.
No, it still hasn't been made. I'm reading 1.1 and it still says serious concerns instead of allegations.
Yes.
Thanks, Chair.
Do you get it, Andile?
Chair was cut off for the past 2 minutes. I'm sorry for that, but I'm back now. It seems as if my problems have been sorted out. So I think I might have missed one or two things. Could you pose?
Yeah,
could you please
Honorable
put
James, Honorable James, you can restate the matter.
Andile, I'm not sure why it
Yes.
has reverted back to the original reading that we basically fixed last week. I remember you were busy typing as we were speaking, and we changed the word in 1.1 concerns, just the way it reads. We changed concerns to allegations. When I'm looking at this week's the draft terms again, it's back to concerns. But I also want to say on 1.1, Action SA did not make a submission. It was only EFF and MK. Thank you.
You remember, Andile, when we left the last meeting, those that correction of Action SA was made to that paragraph 1.1.
Yes, Chairperson.
Okay. So ANC, what is your comment?
Chairperson, we accept the change of the word from concerns to allegations. We have no problem with that. And as I indicated earlier, we support the additions that have been made by the EFF. Thank you.
Oh, okay, the Action SA. Can we move to the MKP? What is your comment on the two paragraphs in question where proposals have been made by Action SA and the EFF? And remember, we said we're going to come to the proposals of the MKP later.
Yeah, Chairperson, thank you very much. We have no issue with the addition that has been made by the Action SA. And subsequently, we have got no issue with the submission made by the EFF because we think, in our view, that it broadens the scope, in particular with regards to the NPA, because we are of the view that the NPA must be looked at as an institution, not only the prosecutorial aspect, but as an institution, because it involves many role players. So for those reasons, we are happy with the additions made.
Thank you so much, DA.
Thank you, Chair. We are comfortable with it as it is written now.
Okay. The IFP.
Good morning, Chair, and good morning, colleagues. We, in the IFP, we don't seem to have any problem with the presentation and the amendment proposed by the EFF.
Thank you so much, Honorable Mngango. The PA.
Thank you, Chair, and good morning, colleagues. I think on 1.1, we should just add a comma after public so that it reads made media briefing and made public, comma, serious allegations.
False, but you agree with the additions that are being proposed.
On 1.1, yes, Chair. And then on the EFF proposal, it just sounds a bit repetitive. We'd like to suggest that it reads, we agree with the proposal, but want it to read in this way, with a view to improving policing and enhancing governance across SEPs, the NPA, Judiciary, Correctional Services, and Metro Police divisions.
Are you making additions? You agree and propose how it must be rephrased.
That is correct.
Okay. It's fine. Let me give the EFF to respond to your proposed additions.
Chair, he's saying exactly the same thing that is written there. I think it's just unnecessary. We're not dealing with wording here, but with the content.
Okay.
He said he doesn't object to the content, so we're not here to be playing with languaging, and it's properly actually written out properly because policing doesn't apply to the judiciary. That's why it's written the way that it is. He's been very unnecessary.
Chair, I think this is not good. You asked me for my opinion. I provided my opinion.
Honorable Matthews. Honorable Matthews.
Yes, Chair.
I don't think that it's fair to say it's unnecessary. Leave it to me as the chairperson to rule him out of order or in order if that is necessary.
Okay, thank you, Chair. I trust your judgment that you'll rule him out of order on fixing languaging.
Can we accept that you are happy with the inputs that honorable members have made?
Well, there's only one, it's the PA, and it's just restructuring a sentence to say exactly the same thing.
Yeah, what the drafting team knows is that we record what has been supported in the meeting.
No problem, Chair.
Yeah. If there is any grammar or some work that has to be done with regard to the linguistics, for as long as that does not dilute the essence of what was agreed upon.
Yes, Chair.
So where I stand as the chair is that the inputs of Action SA and EFF have been accepted in the meeting.
Yes. But the drafting team must note that it must include the NPA. It mustn't just be limited to policing in SAPS. It must include the NPA, the Judiciary Correction Services, and the Metro Police Divisions, which is even captured in the introduction of the terms of reference. Thank you, Chair.
Correct. That is taken. Can we then afford the MKP an opportunity to speak on its additions?
Chair, but is our submission noted when the drafting team goes back? It doesn't mean it needs to be taken, but I think we should be allowed to express our opinions without being said to be unnecessary. And we should also be clear to us. You should also be clear to us that when we comment on the draft, that we should only consider the substance, and the drafters will deal with a repetition of words and other things. You should be clear about that, because I thought we are assisting in how it is read. So I maintain that the substance of the input, we agree with it, but there is repetition, and the drafters can decide afterwards. That's all. It should be noted. It should be noted.
That's exactly what I'm saying, that the drafting team will be afforded an opportunity to clean the document and make sure that the language that is used is up to standard.
But you should state for the record.
The manner in which the document is organized as well. They will look into that. Where there is repetition, they will avoid that repetition. But the substance that has been agreed upon in the meeting. The substance of the content must remain.
But the input from the PA is noted, correct?
Hello, Honorable Sol.
Chair, you are saying that the input is noted?
Yes, the input is noted. Remember here,
Thank
we're
you.
dealing with the submissions that have been made by the EFF and the Action SA. But it does not mean that if you have not made an input, if you have not made a submission, you cannot input in the discussions.
Thank you, Chair.
Thank you so much. MKP.
Yeah, thank you very much, Chair. Chair, in a nutshell, I think let's just share our objective for this edition. That we just believe that this is a legal document. So in a legal document, there must be principles that are established, to which that document must adhere. So we're just setting a principle standard here to say this document at least must meet the highest standards, because maybe we don't know in future it can be used in a court of law. So this edition doesn't bear much weight to the substance of the terms of reference, other than the fact that it is just outlining a principle under which the terms of reference must be formulated. Thank you very much.
Thank you.
Chairperson, no, before you go to other speakers, I think maybe you have omitted the approach that you have espoused when we were dealing with the other two editions. You were checking from the legal team first, and then you moved to parties.
I'm going to Andile now to give us look. The MKP has spoken about their proposed additions. We now, before the parties speak, go to the legal team to hear their impression.
We have no issue with this, Chairperson. In our view, it is legally pending.
There are no legal implications.
We have no issues with it, Chairperson.
Oh, okay. Just sort yourself and delay closer to the microphone. Then, honorable members, we have had the inputs of the MKP and the legal team. I'm starting with the ANC.
Thank you very much, Chairperson. On the inputs of the MKP Chair, I mean, we hold a view that the issues that they are trying to, the issues that they are bringing in have been captured to a large extent on 1.7. We think that, they are a bit repetitive and redundant. But having said that, I don't think that this is something that we would vehemently object to. We do think that they're a bit repetitive. But on 1.7, Chair, given the fact that it's reopened now by the submission of the MKP on 1.7, we want to just raise a point there where it says on the original, the committee may vary or amend these terms of reference provided the principle of fairness is observed. Our view is that we can't have this committee, continuing just to amend the terms of reference. We would want to at least add a line that says in line with the objectives of the inquiry. Otherwise, we leave it very, very open-ended. I think our substantive submission, Chairperson, is that the issues that MKP is raising are covered in 1.7, and unless they feel that there's a serious omission in terms of legality, fairness, safety, which again, 1.6 and 1.7 speak to those issues. But it's not something that we are necessarily vehemently objecting, Chairperson. Thank you.
So your support there their submission to say the drafting team must look at how that can be integrated in 1.6 and 1.7.
Yes. Yes, Chairperson. I mean, those issues are really, they're statements. The principle has already been covered, but perhaps the drafting team can just look at how they incorporate anything that is missing. We just think that they're misplaced and repetitive, but we don't have fundamental objections, Chair. Thank you.
Okay. The Democratic Alliance.
Thank you, Chair. There's no real objection to it. I must just note that it seems to be more of a statement than anything. It's kind of logical. We would assume already that everything said there's the reason for the existence of the committee, but there's no objection in I guess emphasizing it. I do, although, feel the introduction of the committee is exactly for that reason. So no objection, Chair.
Thank you so much, Honorable Cameron. The Economic Freedom Fighters.
We have no objection, Chair.
Thank you so much, the Inkatha Freedom Party.
No objection.
Thank you, the Patriotic Alliance.
No objection, Chairperson, to the substance, but I would take that the drafters or the drafting team will consolidate it in terms of how it should read. So I will submit to you advice earlier and not comment on the structure of how it will now be combined, the MKP's submission and the original wording of 1.7. So I would leave it to the team to then consolidate that section, but I don't disagree with the substance. I also agree that it's repetitive, but I won't comment on it. We leave it to the drafters, as you said, it must be done earlier.
Okay. Are you done, Honorable Sol?
I'm done, Chair.
And please pardon me because there was at some point I interjected. I thought you were done. I'm very sorry for that.
No problem, Chair. Thanks.
The Action SA.
We support, Chair. Thank you.
The MKP. Honorable Skosana. Or Honorable. Yes. Did you hear the comments of the members?
Yes, I did. I did for it had to be.
We're struggling to hear you, Honorable Skosana.
Chair, can I come in because Honorable Kosana is struggling with the connection? Am I audible?
Honorable number.
Yes, Chair, can I come in?
Yes, you are allowed.
Yes, Chair. No, we've noted the submissions, Chair, and largely there is no objection. So we take it as though the addition has been accepted by the committee.
Thank you so much, Honorable Member. Andile, that must have been the last on item 1.
Yes, Chairperson, that was the last one.
So, honorable members, we now pass item 1. There are no further issues with item 1. We are going to item 2. Can we take the same procedure, Andile? what are the impressions of the legal team on the submissions? Okay, maybe let's start with the ANC on the submissions made by the ANC.
Thank you very much, Honorable Chairperson.
Honorable Sangoen.
Yes, sir.
Before you come in to speak to your submission, I want to check with Andile if they have issues as the legal team regarding your submissions. Are there any matters, Andile?
No, Chairperson, I'm not sure if you can hear me now, but you will recall that what Honorable Sangon said was that this section has got 4 subsections, I'm sorry, and all of them must be included. And that's why we added D. And of course, the 2.5, the same principle applies. It's because we didn't cite the entire section 14 of PIPLA. And I think Honorable Souls said we should do that. And that's exactly what we're doing. Thanks very much.
No, what we want to hear from you as the legal team. Do you have any matter with the submissions made by the ANC on item 2?
No, we have no issue, Chairperson. I mean, we have no issue. Thanks very much.
Do you have any matter with submissions made by the MKP?
Chairperson, the one at 2.5, it was made by Honorable Souls from the PA.
Hello, Andile?
Yes, Chair.
Do you have any matter with submissions made by the MKP? No.
No. I have no issues insofar as what they have already.
Do you have any matter with submissions made by the DA?
No.
Is it me or is Andy?
It's not you, it's Andy. We were struggling to hear him.
We cannot hear anything.
But we will raise them as
Andy, we can't hear you. We can't hear you.
In front of us, we have no issues. Let me ask someone, Chairperson, to come and assist me again. When I'm looking at activity, Chairperson, can you hear me? Can you hear me, Chairperson?
Yeah. No, I think there is a problem with
If I may come in.
Hi, Chairperson. Hi, Chairperson.
Chair.
Hi, Chairperson.
No,
Hi, Chairperson.
But is there somebody who work with you who can help us in the meeting?
Chair.
Hello.
Chair, Honorable James here.
Yes, who is speaking?
Chair, can I say something, please?
Yes, if you can say what you want to say.
But I think first and foremost, Nhlanhla, you just need I'm not sure if it's me or if it's Andile, but the sound is breaking. And Chair, I just want to put this on record that this is all the more reason why we should have these meetings in person, because we cannot afford to have these technical glitches going forward. Already we're lagging behind. This is completely unacceptable. Thank you, Chair.
Yeah, but I was checking if there is somebody from the legal team who is working with Andile who can help here. We just want to know what is the impression of the legal team on the submissions of the MKP. Yes.
Can you hear me now, Chairperson?
Yes, we can hear you.
Thank you very much, Chairperson. Chairperson, all that I was saying, Chairperson, was that if you look at the submission of the ANC in relation to Section 56D, that's the subsection that they said should be added. And Chairperson, we have no issue with that. Same applies to 2.5, Chairperson. You will see that, you'll recall that Honorable Souls said Section 14 of PIPA in its entirety should be cited under that subparagraph. And that's exactly what we're saying is legal. We have no issue with it. Thanks, Chairperson.
And then on the submission of the MKP.
Yes, Chairperson, I think we indicated earlier on, Chairperson, or you mean the one that is being flighted in front of us now? Yes, we have no issues, Chairperson, with this submission.
On the submissions of the DA.
I can only reflect, Chairperson, on the submission as it is flighted. Because what is in front of me now is, Bonani, can you go down a bit? That's actually the PA's one. This is MKP's one. No, we have no issue, Chairperson, with this. We have no issue.
And then on the submissions of the EFF.
On which particular section, Chairperson? Because I'm moving with I'm moving with Bonani.
We remember we have dealt with item 1. We are now on item 2.
Yes.
Yes. So the parties have made submissions on item 2. Yes.
We have on item 2, Chairperson, in its entirety, we have no issues.
And then the IFP.
Chair.
If the IFP has made a submission on item 2, do you have any impression?
No, Chairperson. All I'm saying, Chairperson, is that, remember, Chairperson, political parties last week inputted into this document. And of course, when I say paragraph 2, I'm referring to the legal framework in its entirety. So that's why I'm saying, insofar as paragraph 2 is concerned, Chairperson, we have no issues in its entirety.
Okay, fine. So can we now go back to, we're now going to take the parties one by one in that rotation order. So we will start with the ANC to speak on its submissions. If there is anything further, I know that the draft terms have been circulated. If without regurgitating what they would have said last week or what is contained, if there is anything further to say in motivation of their submission. ANC.
Thank you, Chair. We have nothing else to add on our submission. Thank you very much.
Okay. So now let's hear what the members are saying on your submission. The MKP.
No objection, Chairperson.
No objection. The DA.
No objection, Chair.
Thank you very much. The EFF.
Thank you, Chair. The EFF accepts the submissions. They're a bit administrative in nature, but they're positive, so acceptable.
Thank you so much, Honorable Matthys, the IFP.
No objection, Mr. Chairperson.
Thank you so much, Honorable Mwango, the PA.
No objection, Chair.
Thank you so much, Honorable Sols. Honorable James from Action SA.
We support the submission. Thank you, Chair.
Thank you so much, honorable members. Can we now go to the MKP to motivate their submission? Honorable Skosana or Honorable Nomvalo?
Chairperson, sorry. Chairperson, Honorable
Okay, before can I give an opportunity to Honorable Sols?
Thank you, Chair. I understood you to mean that we are just commenting on the submission by the ANC.
Yes.
And then we were going to come to the request I made around the section 14 that had to be included. I thought you're still going to come there, but it seems like you're moving past that. I just want to be sure.
No. We are still on item 2. So we are taking the submissions of the parties one by one. So we have just concluded the submission of the ANC, which the members of the ad hoc committee have accepted. So the second consideration we are making is the submission of the MKP. We will take the parties in rotational order, like I said.
Okay.
Yes. And Honorable Sangoni, I have not given you any chance to comment because you might have heard that there is no party that made a statement. They just said they accept all of them. So I don't think that it will be necessary to afford you any chance to make a comment. Can I move to the MKP to motivate their submission on item 2?
Yeah, Chairperson, there's nothing much to say, safe to say that we were just making an addition to the legal framework that guides the existence of this committee and that will guide its operations going forward. But subsequently, Chair, we also made a verbal request to one of the members of the legal team, parliamentary legal team, that they must also do some research on case law in this paragraph, for this paragraph in particular, because common law is one of the important aspects of our legal system, is one of the sources of our legal system. So it will be very important for them to also include case law here so that we can have an insight of how a case with similar merits was dealt with by a court of law. That is the request that we made, and we thought that it would not be proper for us to make that addition because it's legal work, so it falls within their scope of framework. Thank you very much.
Thank you so much. Can we then move to hear what the members are saying about your proposed additions? I'm starting with the ANC.
Yes, Comrade Chair, Mtumiseni.
You are welcome, Chief Whip.
No, thanks, Comrade Chair. Good morning to you and good morning to all members on the platform. No, I just want to comment on the proposals made by the MKP. I think the first thing that we would like to say is to draw the attention of the committee and particularly the MKP to the sections above, 2.2 as well as 2.3, which in our view are adequately addressing the concerns that are raised by the MKP. For instance, if you look at 2.3, it essentially sets out what the Constitution says, Section 55, subsection 2 of the Constitution, which in a way define the responsibilities or impose a particular duty to the National Assembly in terms of how it should provide a mechanism to hold the executive to account.
In the same breath, we are saying
James, James. Oh. And then the same is
Honorable James, may you please mute yourself.
I am muted, Chair.
The same as well, Chair, if I may proceed. If you look at 2.3, it's our considered view that that section thoroughly addresses the concerns that were raised by the MK party, particularly on the editions that are slightly up below 2.9. And we would like to persuade the meeting, and I was saying the MK party in particular, to reconsider their submission in this regard, because as I'm saying, we think that is properly attended to. The second issue related to the submission of the MK party, there, if you can go to the paragraphs where the MK party has made a submission on the screen, I want to draw the attention of the committee to the paragraph that says, firstly, I'm saying the first paragraph, the one that deals with the committee shall give effect to rights in the Constitution. I think that one is there's no problem with that, in a sense that is already addressed in 2.3 and 2.4. That is the point that we would like to make, and which was suggesting that the MKP should reconsider submission. The second one relating to the submission of the MKP as well, where it says the committee shall adopt a protocol on classified and sensitive information, balancing transparency under Section 59 of the Constitution with no prejudice to ongoing investigation. Now, we just want to, again, to draw your attention, Chair, and the meeting, to the fact that, as you may recall, at the time when the Speaker referred the matter to the joint committees on justice and constitutional development, as well as the portfolio committee on policy, she at the same simultaneously also referred this matter to the attention of the joint standing committee on intelligence. And the reason why that was done was essentially because ordinary committees of parliament, except that JSCI, do not have the authority to deal with classified information, because as you would know, Chair, it is only that committee whose members are taken through a very legally defined process to have them being cleared to be members of the Committee on Intelligence. And our own view is that we understand why the MK party is raising this point, the way in which it has been raised. But I think we should take comfort on the fact that some of these matters are naturally going to be falling or are falling within the jurisdiction of our sister committee in Parliament, which is the Committee on the Joint Standing Committee on Intelligence. And that is the basis upon which we would like to suggest that the issues relating to us adopting a protocol and how to handle sensitive information, the questions of transparent and Section 59 as raised by the MK part, we think that it will be accommodated in another process which belongs to the Joint Standing Committee on Intelligence, because that committee will not cease to do its own work merely because there is now an ad hoc committee of parliament that was set up following the decision of the National Assembly. So essentially, that is a proposal from the ANC's point of view that we would like to put on the table, is to propose that we operate within the proposed framework, legal framework above, which we believe that is going to be adequate to effectively address the concerns as raised by the MK party on their submissions. So, Chair, those are the comments that we would like to make at this stage. Thank you.
Thank you so much, Honorable Ntuli. The DA.
Do you hear me? Before the DA.
The DA.
Chair, I don't know if I may proceed. Honorable Skosana is unmuted. May I proceed?
Yes, I have recognized you to speak.
Thank you ever so much, Chair. Chair, we fundamentally don't have any problems with the submission by the MK. It is a little bit repetitive as some of these issues have been highlighted in different sections of this document. So we agree with the ANC with some of their submissions, but as a whole, we don't have a problem with the submission with the MK. We're happy for it to go as is. Thank you.
The EFF. Matthews, I don't know if there is a problem on my part, but I can't hear you. I don't know if that is the same with the other honorable members.
We cannot hear Honorable Matthys, Chair.
Yes, I cannot hear her.
Chair, can you hear me?
Yeah, I think now you are audible.
Thank you, Chair. The EFF, we understand that the MK's submission is just giving more detail to the sections mentioned on the top, but it's neither here or there. I don't think it's a deal breaker if it is included. So we support the submission.
Thank you so much, the IFP.
We have no problem, Mr. Chairperson. I mean, if the proposals are included.
Okay, Honorable Mngango, I assume you are done.
Yes, I'm done now. We have no problem with the inputs being actually accepted as they stand.
Okay. The Patriotic Alliance.
No objection, Chair.
No objection. The Action SA.
We support the submission. Thank you, Chair.
Okay. Honorable Skosana, you heard the comments of the members. What is your take? Or Honorable Nombalo, either of you may speak. Honorable Nombalo, it seems Honorable Skosana is struggling wherever he is.
Yes.
Can you please rescue him?
Yes,
I
Chairperson.
can hear you, Chair.
Yeah, can I come in, Chair?
Yeah, you can. Chair?
Yes, Honorable Nombalo, you can go ahead.
Okay. No, Chairperson, what we are noting is that the majority of committee members are in agreement with this submission. And just to give a brief clarification, Chairperson, in terms of our understanding, there is no repetition here because the sections highlighted above talk about the constitutional obligation of Parliament to do its oversight responsibility. And the sections that we have highlighted as a recommendation are sections which are dealing with the procedure to be adopted by the committee in terms of protecting, because Chairperson, the committee will receive, it will be a matter of how we deal with it, but will receive sensitive information. So we're trying to give a specific standard to which we must adhere to when we deal with that kind of information. But Chair, we're happy because the majority is in support of the addition. So there's no contention. Thank you very much.
And Chair, do you hear me now?
Yes, I can now hear you.
Yeah, just to because my colleague has already said it mouthfully, but that sentence as well, we just want to emphasize that, you know, there's not classified about stealing, that it needs a joint standing committee of intelligence. And remember that we still have, why we've put that in particular, is that when the report of Phala, the Minister Senzo Mkhunu classified that report, we cannot work like that. This committee should not be a talk shop. We are not here for optics. We are not here for optics, Chair, because Senzo Mkhunu, the suspended minister, classified that Phala report. And here we're talking about money. When somebody is steal or when there's money involved, there's nothing any foreign intelligence. It's not a sensitive matter. In short, that's what I'm saying. Hence, we are emphasizing that input. Thank you, Chair. I'm not trying to keep up a debate, but I'm just saying it comes from that.
The last part that you said is unfortunate because it does not have anything to do with the terms of reference. Let's confine ourselves to matters that deal with the terms of reference, and if there is any evidence or any information that you have, you can still apply to be a witness, and we will allow you to come and present whatever information you have about classification.
Yeah, hence, I'm saying
that part, I'm ruling it out because it's not part of your submission. Not part of your submission.
I understand you, Chair.
Yes, you have made substantive inputs on the terms of reference. Let us not bring other things that are not part of the terms of reference.
Yeah, I was just making an example, Chair, to say Senzo Mkhunu has classified the Phala report. It's a fact.
Is that what you are suggesting we must include in the terms of reference?
No. Hence, I'm saying to you why we've put that input. It derives from that we should not be told when we are deliberating matters that this matter is classified. It must go to a joint intelligence, whatever. No, it must be discussed in this committee, the ad hoc committee. There's many matters, but I was giving you an example that the suspended minister has done that already, and we must dig deep down to this matter and not be told that matters have been classified. There's matters classified, we know, But I was just emphasizing that we should not be told that, no, this matter is classified, the committee has no powers. Thank you, Chair.
Yes, what I'm saying is that as the committee chairperson, I hear what you are saying regarding your inputs, and that is accepted. What I do not hear is when you want to present evidence like matters here, when we are not at that stage. We are at a stage where we must refine our document, and that should be sufficient, correct?
Thank you, Chair.
Thank you so much. Can we then move to the submissions of the DA, the Democratic Alliance? Do you have any
Chair,
comment?
my apology, Chair. I don't know if your screen does indicate when their hands up. I have my hand up. If with your permission, if we proceed, you can allow me to come back.
Okay, Honorable Ntuli, let me give you a chance to speak.
Yeah, no. Thanks a lot, Chair. Much appreciated. And I would like the members of the committee properly to understand the context within which I'm raising this point, because we are not as well vehemently opposed to the proposals made by the MK party. Firstly, we were making an intervention to say some of the issues that they've raised are already covered. But there is one particular issue, but of course, it's not a matter that we're prepared to go to the war to deal with. But there's one issue that, Chair, we believe that if we don't address it properly in this committee, it's going to open us into a direction that does not belong to the scope of our work. And we would like the matter to be properly discussed in this committee so that we can persuade one another. I said earlier on, Chair, in Parliament, we all belong to various portfolio committees. But the portfolio committee on the Joint Standing Committee on Intelligence, members of that committee go through a particular exercise which is defined by law before they qualify to be members of that committee. It may very well be that you might be a member of Parliament but have a difficulty to get the clearance that is required for you to be a member of a Joint Standing Committee on Intelligence because of the exercise that they've got to go through, given the nature of the work that they do. I'm making this background, Chair, to lay the foundation on the point that I was raising. When the MK party says the committee should adopt a protocol on classified information, I want to stop there. The committee shall adopt a protocol on classified information. What do we mean by that? How do we interact with the classified information when we ourselves are not members of the Joint Standing Committee on Intelligence and therefore have not gone through a process that is required by law before you can interact with the classified information? So if the committee members are saying, we agree, let's proceed, it's just the proposal here is that we must adopt a protocol. What do we mean by the protocol? Let me conclude by saying, Chair, I was expecting as well that the legal team will intervene on this issue. Well, in my own view, it's very strange that the legal team doesn't see anything wrong with the fact that we are about to agree on adopting a protocol on how to deal with classified information. Never mind sensitive information, because what is sensitive to me may not be sensitive to Kusela, may be sensitive to Nomvalo. That we can handle is understood. But classified information is not our own imagination. It has to do with what the law defines as a classified information. And I'm arguing, Chair, that as an ad hoc committee, in terms of the law, we are not empowered to engage with classified information. And I'm saying I'm surprised that the legal team, when they were commenting, when you pose a question to them as to whether do they see anything problematic with their submission in its current form and formulation, they said nothing. Now, if they insist that there's nothing illegal, can we also have them making an input? What do they understand about this committee having to adopt protocols on classified information. What is meant by that? And what is required in terms of the law of our country and parliament before you can have access and deal with matters that are classified by the state? Thanks, Chair.
Yeah, Chair. I think you have raised a very valid point.
Chair?
Yes, I'm going to give you a chance to speak, Honorable Skhosana. Listen to what I'm saying. If there is a classified information in the Republic of South Africa, it means there is a law or national legislation that governs how that information is classified and how that information may be accessed. And then the legal team must then clarify what constitutional authority do we have ourselves as a committee to develop a protocol when in fact we should be subjecting ourselves to that national legislation than to develop a protocol. Can the legal team clarify that before you come in, Honorable Skhosana?
Thank you very much, Chairperson. Can you hear me, Chairperson?
Very much.
Chairperson, am I audible? Thank you very much, Chairperson. Chairperson, our understanding of the issue which is raised by Honorable Nomval is not to say this committee must deal with classified information. Our understanding is that in the course of this committee doing its work, you may find one person or another coming to the committee with classified information. Chairperson, let me raise just one point. Chairperson, on the 4th of December 1996, you will recall that Cabinet approved a document called Minimum Information Security Standards as National Information Security Policy. And of course, Chairperson, in the classification of documents, the first question you must ask is, who classifies the document? And of course, the person who classifies the document, Chairperson, is the author of the document. And of course, classifications have got different levels. You know, restricted, confidential, secret, top secret. Now, sometimes it happens, Chairperson, in the course of work that you have people who must necessarily have access to that classified information in the execution of their duties. In other words, on a need to know principle. But the condition is always that a suitable clearance has to be issued or authorization has to be granted. So, Chairperson, we are in no way saying that this committee must deal with classified information. That's not the point. In fact, even in the document which were formulated, we've exactly noted that. Note that on the 4th of December 1996, Cabinet approved the Minimum Information Security Standards document as National Information Security Policy. So, Chairperson, we are very clear. Honorable Ntuli is correct to say that some of the issues are outside the remit of this committee.
Yes, Andy, listen to what my question is.
Okay.
The question is, the advice that we seek from the legal team is whether the committee must subject itself to the established protocol or whether the committee must establish a protocol. That's what we want to hear.
Yes, but Chairperson, practically, if the holder of the information, Chairperson, unlawfully or whatever, gives the committee classified information, so there has to be a protocol, in my view, Chairperson, in the sense that even if it means that information must be given to the Speaker, and of course, the Speaker and the Secretary of Parliament are the people who must have access to the logs where that information is going to be stored. So a protocol does not necessarily mean, Chairperson, that this particular committee will deal with classified information. But we are just envisaging a situation where if we are confronted with a situation where, for instance, classified information is given to Parliament. And I think we have to have control mechanism. How are we going to relate to that? I'm not sure if that answers you, Chairperson.
No. I must now give the MK party to check if what your explanation, whether you are in the same frequency with them, because their submission is that the committee must establish a protocol. So that is why I was asking you whether it is legally permissible, whether we have a constitutional authority or any empowering legislation that allows us to establish a protocol, or whether we must subject ourselves to the already established protocols.
Yeah, thank you very much, Chairperson. Chairperson, if I may come in. One, this Chairperson comes from an apprehension of the allegations and the nature of the allegations which were tabled by General Nhlanhla Mkhwanazi, Chair. And amongst the allegations that he raised, or the concerns that he raised, is that there is an interference in the crime intelligence unit in South Africa. And our understanding, Chairperson, is that the crime intelligence unit at its heart deals with classified information. And therefore, at some point, this committee will have to deal with classified information in one way or the other, and whether we like it or not. Unless Chairperson was saying we are to a certain extent going to abdicate some of our responsibilities, because the terms of reference which were adopted in Parliament when the motion was tabled said that we must investigate allegations raised by General Nhlanhla Mkhwanazi. They did not say that except on issues of crime intelligence. So it means if we are saying here we're not going to deal with classified information, we are saying we're not going to investigate some of the allegations which were raised by General Nhlanhla Mkhwanazi. That's what we are saying. And what we're hoping to hear, Chairperson, from the legal team, we're hoping to hear them giving further clarification on different types of classification. That what kind of classification do we have? Because there are different levels, top secrets, sensitive, and so on. And to that kind of to those different categories of classification, to which classification can Parliament not have access, and to which it can have access? And for us to have access to that kind of classified information, then what process do we need to undergo, and what implications will arise from that process? That is what we're hoping to hear. But Chairperson, we are firm on the view that this clause needs to be added. This addition needs to be considered here as part of this document, because we believe that it's inevitable that we will deal with classified information as this committee, considering allegations and the nature of allegations that were raised by General Nhlanhla Mkhwanazi. Thank you very much.
Okay, maybe let me say, before I take the hands that are up in this order, Honorable Skosana, Honorable Sangoni, Honorable Cameron, maybe before you speak, because the question that Honorable Ntuli asks remains unanswered. And I try to simplify it for the legal team. I hear what Honorable Nombalo is saying, that the committee for it to do its work successfully, it should be able to access the information that it requires. And then the issue here at hand is whether the committee must establish a protocol, or the committee must follow the already existing protocol. And how does the already existing protocol if I have to add the input of Honorable Nomvalo, is how does the already existing protocol enhance the committee to access whatever information it may need in its hands? If the legal team can clarify that point, I think it's going to help us.
Chairperson, we do have a protocol
Chair,
already.
You are not fair to me. We are not fair to me, Chair.
Yeah.
Chairperson, can I be protected? Chairperson, can I come in?
Yes.
Yes. Chairperson, there is a protocol on handling classified information in the institution, but it's a question of this committee, of course, looking at it. And if Chairperson, you think that you can add a comma or a full stop and so on, but the fact of the matter is there is a protocol. I can share that information with you, Chairperson, maybe after the meeting, because I don't have access to it now. But I'm not sure if that answers your question.
Yes, I mean it's not for you to share it with me. It's to say there is a protocol, and the committee can agree to in the next meeting to be taken through the protocol, so that all of us understand. We must not have a situation where when we leave this meeting, we must be one in terms of understanding that whether this committee has the constitutional authority to generate a protocol, or if there is already an existing protocol which this committee can rely on. But furthermore, Honorable Nomvalo says we may need to have access to certain information. So does that existing protocol enhance the committee or makes it permissible for the committee or easy for the committee to access such information if it may be required?
Chairperson, the protocol outlines how the institution should deal with classified information.
Thank you so much. That is exactly the kind of the answer that this meeting wanted. So let me go back to the list. I ended with Honorable.
No, Chair. No, Chair. I've been here for some time. You are ignoring me again.
No. Listen,
No.
listen, Honorable
No,
Scosan. I read a list of 3 names. I said number 1 on the list is Honorable Scosana. Number 2 on the list is Honorable Sangoni. And the list ended with Honorable Cameron. There are 2 more hands, which will include the hand of Honorable Nduli and Honorable Matthys. Those are the 5 hands that I see now, which are going to speak in that order. And the first hand that I have rightfully and proudly recognized is the hand of Honorable Scosan.
Thank you, Chair. I thought that we have passed that until I've mentioned the issue of Phala, then things started. And now I agree with Honorable Member Malema when he said we need to sit on this meeting. I think Adam said so as well, that after that, perhaps some legal advice from lawyers or from wherever it comes from prompted Honorable Nduli to come back. The matter was done, Chair. The matter of our input was done. Now, because I invoke the issue of the minister, Senzo Mkhunu, classified Phala issue, then it started to come back. If we sit physically, we won't have this, Chair. That you will have a matter discussed, at a later stage, it comes back. When it comes back now, even the legal advice has changed. He has changed. It's been pushed to change what he told us earlier. The issue of protocols and the issue of General Mkhwanazi, when we're sitting at the joint, when we had a joint sitting, is very, very clear. Let's not beat about the bush. We are not only talking about law here. South Africa needs to see justice in this country. We cannot be told, like I said in the meeting, that when Solomon Mahlangu was hanged, we were told about the law of this country. We need to go further as a committee. South African people and the population in this country wants to see justice. I don't hear the word justice here. I'm only hearing about law this, law that. We need to be frank about this thing. This commission should not be like any other commission we ever had before in this country. Where were optics, where people are defending each other, where the people are closing ranks. I'm not saying we must break the law, but I'm saying to you, justice, Chair, has to be seen to be done in this matter. I cited that deliberately to say this so-called classify, if one person decides to classify a matter, we cannot be told that. In fact, I think it was a travesty of justice not to have some members of the joint intelligence, in fact, the joint intelligence with the justice and the police portfolio committee together in the SADC committee. I think we missed an opportunity in that. But my last parting choice, Chair, is that we should not, please, we should not defend illegal things in this country and hiding it behind the laws which we know that our constitution is not perfect. You know, all this PR thing that we've got the best constitution, that will be a debate for another day. But I'm still insisting that we should not be told in this ad hoc committee that we cannot discuss this matter. This matter is a classify. We know what is classified. I was talking about what General Mkhwanazi told us. Nothing else. I'm not deviating from that. I'm saying we are dealing with the matter here of the South African Police Service and justice. And if we want to see justice, justice must be seen to be done and should not be optics. We should not just come here and defend issues and say those matters are classified matters. If we have to, then we will have to know what is a classified matter, because those matters are going to come anyway. Thank you, Chair.
Honorable Sangoni.
Thank you very much, Chairperson, for the opportunity. Chair, I think that as we go through these terms of reference, obviously ours is to discuss and hopefully try and find one another on the issues that are raised. So I think it's a bit unfortunate that as we seek to engage with members of the committee, there are views held that we should not have an opportunity to engage them thoroughly. Chairperson, my input has changed, I think, given the disclosure by Mr. Degiana that there is a protocol on classified and sensitive information. But I want to propose that maybe what we want to do on that, what I think is a contentious a section that's proposed, like the MKP in the above, in the statements above, where it says the committee shall, where applicable, act in accordance, and then it mentions a particular act there. We should, in this section, also include that the committee shall, where applicable, act in accordance with the minimum information security standards. I think it's called MISS. Because to do that, it would then cover a lot of issues in terms of who is constitutionally empowered or legally empowered to deal with classified information. I think all of us want the same thing, which is ultimately to discover and understand the truth on these matters. But in doing so, we can't then be breaking the law. And I support your suggestion, Honorable Chairperson, that perhaps then we also get provided with that existing protocol on classified information, which will give us guidance in terms of what we can deal with or not. I hold the particular view that if you are not cleared to deal with classified information, regardless of what we may seek to achieve, you will not be able to deal with classified information in terms of the law. But the existing protocol of Parliament will guide us in that regard. So that is my submission of that edition of that we must act in accordance with national legislation. Thank you, Honorable Chairperson.
Okay, Honorable Sangweni, maybe before we take Honorable Cameron, Andile, what is the title of that protocol which you say it exists, so that
Chair, it's just that I can't multitask, otherwise I'll give you the document. Let me just. No, I'm saying I'll give you the document, Chairperson. It's just that I'm listening at the same time because there are questions that I'm fielding. Yeah, it's just that I can't multitask. That's just my weakness. Otherwise, it's not the first time, Chairperson, that the institution has had to deal with classified information.
yeah, that
So
is what I'm asking.
I'll give you that, Chairperson.
What is the title of that protocol?
Let me just.
So that if we are going to rely on that protocol, what powers does it confer on the committee?
Just a minute, Chairperson.
Okay, no, it's fine. When you are
just
still
a minute,
looking,
Chairperson. 1 minute. I'm just trying to.
When you are still looking for it, can I take Honorable Cameron?
Yes, Chair. Thank you very much, Chair. A very brief comment is just to say that I think we must stick to the existing protocol, just the input from us. I think the protocol has been tested before. If need be, I like the suggestion that you made that we can be, or the protocol can be shared with us and possibly very briefly presented in the next sitting. Everything that we're going to be discussing is somehow sensitive, and other parts may have been confidential before. I just think what's important, and this is the crux of what I want to say, is that whatever we decide on this, we need to make sure we clarify the difference between classified, confidential, and sensitive, because there is a difference, and we do already have the adequate platforms to handle these matters. Yeah, so just a short input with that. I like the idea of just using the existing protocol.
So Chairperson, oh, sorry.
Yes, before you come in, Andile, I hear what you say, Honorable Cameron, and look, I agree with you that we must rely on the existing protocol. The question that the MK party is asking is to what extent does that protocol allow the committee to have access to information? And I think it's a matter which this protocol that is there already should be able to clarify. I don't think we are far from each other. Whether there is a law or there is no law, the issue, remember when you develop the law, number one, is developed for the purpose of certainty and clarity. So that law, that protocol, if it exists, it must clarify the questions that the MKP is raising to say, is it going to help us to get the information? Let's say Nhlanhla appears before us and say, no, I'm not going to say anything to you as a committee because what I should be saying is classified. In terms of that protocol, what recourse does Parliament have in the event a witness comes and says exactly that? I think that is exactly, if I correctly understand the MKP, I mean, without doing what Honorable Skhosana is doing, mentioning names of cases or instances that he already knows. But just to say, how does it empower the committee to successfully do its work? Do you understand me, Honorable Cameron?
Yes, thank you, Chair, 100%.
Okay. Well, Andile, you wanted to clarify something. Can you come in before?
Yeah, no.
I give Honorable Ntuli a chance to speak.
Can you hear me, Chairperson?
And the last
Can you hear
will
me,
be
Chairperson?
Yeah, I hear you. I'm saying the last on the list will be Honorable Matthys. Yeah, Andile, you can come in.
So, Chairperson, I'm just going to read perhaps one or two paragraphs of this document. I don't want to waste your time and the members' time. So it says a process of handing classified documents was developed over time, in terms of which these documents are placed in the custody of Parliament with access to them controlled. The documents are placed in a safe set aside for this purpose, equipped with two different locks. The Speaker or her nominee and the Secretary to Parliament or his nominee ensure the safekeeping of the safe keys and its contents. My nominee, this is the Speaker now, in this instance is the Secretary to the National Assembly, and the Secretary to Parliament will announce his nominee in due course. In order to gain access to the documents, it will be necessary for both key bearers to unlock the safe, take the documents to a controlled venue, and there, in a formal way, you make them available to only full members of the committee. Members will require your permission to gain access, and on this basis, block times may be set aside during which the relevant members will have access to the documents. On entering the venue, members will have to identify themselves, sign a register, and record their time of entering and leaving the venue. Under no circumstances will these members disclose the contents of these documents, as that would be a breach of parliamentary privilege and contempt of Parliament. In terms of National Assembly Rule 2, this process has developed into a practice which forms part of sources of authority of the Assembly and must be followed in this case and other similar instances. Thank you very much, Chairperson.
So what you are saying is that this confirms that the protocol is there already.
Yes, Chairperson.
And then as the committee, when we do our work, we must subject ourselves to that protocol.
That's correct, Chairperson.
Okay. Then let me go back to the list. I think the matter is now very clear. Let me go back to the which is Honorable Ntuli and Honorable Matthys.
No, thanks, Chair. Let me not be long because in the light of what has been indicated here, I want to propose that we, rather than adopting the paragraph in its current formulation, we allow an opportunity, maybe at the end of this meeting, for the legal service to insert a paragraph that clarifies what he was reading. That's what I'm proposing. I'm still very firm on my understanding that of how classified information are handled in South Africa. But I have no problem with the protocol being inserted. But I suggest that let it be inserted so that when we end the meeting, he must present the protocol and the conditions under which the protocol is going to be applied so that we can be off the same page about it. Thanks.
Honorable Matthys.
Thank you, Chair. I think we largely covered after the reading from the legal team. What I would like, or what we would like to raise, is that there is a process for documents that are classified to be declassified legally. And I would like to think that we would like this committee to be able to unravel whatever criminality. I mean, we do know that documents pretty much get classified also to cover up criminality. So there is legislation available to us if needs be, and if anybody comes to the committee and says, I have classified information that is criminal, its contents is criminal, and we should be able to help speed up that process of getting those documents declassified, if obviously, if it is going to assist in us meeting our objective of this ad hoc committee. Also, we do have members of the Joint Standing Committee that are part of this, but I'd written down this point, but I think I'm largely covered. We also don't want to have a situation, Chair, that every time something comes up here, remember, we're trying to fix a very hectic problem here in this country about criminality, and that our entire law enforcement is in a horrific state where we're going to end up with mob justice here in this country. So if we want to do something serious here as a committee, as we are mandated to do when we took our oath of office, we need to make sure that we also don't allow documents to be automatically disclassified. So that whole classifying process is abused. So information cannot come here to the committee for us to be able to clean up the criminality that is happening in this country. So one of the things is us have been able to assist if information is classified and get it declassified. And on the second point is that also that we must also get information on when a particular document was classified. And this would speak to the issue of if documents are being classified now, given that we have set up this ad hoc committee to avoid us investigating further. And that's our input. Thank you, Chair.
Thank you so much, Honorable Matthijs. The list of speakers is exhausted. I'm now giving to the
my hand is up, Chair.
Chair, my hand has always been up.
My hand is up.
No, there is no way I won't give you a chance. I mean, you are the one who moved the proposal. So when everybody has spoken, you have the right to reply.
Okay.
Nhlanhla also
Noted, Chairperson.
is also up.
No, it's fine. Let's take the hand of Honorable Nhlanhla first, so that the MKP can be able to reply.
Thank you very much, Chair. Chair, I think we all share the same concern the MKP has raised, in that the nature of allegations that were leveled by General Mkhwanazi actually would at some point require us to deal with some sensitive information, classified and all those things, because the nature of the allegations include crime intelligence, as they say, IDEC and all that. Now, I'm also comfortable with the explanation that was done by the legal team, Chair, that we've got an established protocol that which directs us on how to deal with matters relating to classified information and all that. And I want to come and second the submission by the Chief Whip that there must be an addition of a paragraph, but the addition of the paragraph must speak on us when the time arrives for us to deal with classified information. We must use the established protocol of Parliament. We are just an ad hoc committee of Parliament when there are established protocols on how to deal with a certain information. I think we must use that already established protocol, and I think the addition the Chief Whip is talking about should actually speak about how we align ourselves with the established protocol. Thank you very much, Chair.
Honorable Nombalo.
Yeah, thank you very much, Chairperson. Chairperson, I do not understand where the bone of contention is here, because this is our understanding, firstly, as the MK Party. Our understanding is that this heading, which deals with the legal framework, the heading that we are currently under, is a heading that deals with the law or any piece of legislation that governs the framework or the scope of the ad hoc committee. I think that is a standard heading that should be there in the terms of reference, but in it, there should be no suggestive of any law that should be developed by this committee, but rather it deals with the law that is going to guide the operation of this committee. That is our understanding. Now, by saying, Chairperson, in this edition that we have made, by saying that the committee must adopt a protocol, we do not say that we must develop our own protocol. We're saying we must adopt the protocol that is already in existence. In this sense, Chairperson, there is no way that regarding these allegations made by General Mkhwanazi, there is no sensitive or classified information that will be submitted to this committee, whether through an invitation or voluntarily by any member of the public. Now, when that information is at hand, what is going to be expected of us as a committee? One, because we're going to have a legal advisor as the committee, a person who's going to advise this committee on a regular basis. That person will tender a legal advice and say, this information is classified. And if it is classified and the committee makes a determination that it is relevant to assist an inquiry, then we ask a question, which protocol can we follow if we want to use this information as part of an information that is going to assist our inquiry? And then it is then that this protocol, which is already in existence, will be applied to say, this is a process in terms of the protocol that is in existence that will be applied. So, Chair, my observation here is that Honorable Ntuli does not understand where we're coming from. I think he thinks we're saying we must develop our own protocol. We're not saying that. We're saying there is no way, it's inevitable regarding the nature of allegations and regarding the institutions that we are going to deal with as a committee, that we cannot receive an information that is sensitive. Now, when that information is before us, what are we going to do? We will be guided by the existing and the established protocol. And we'll be guided, obviously, by the legal advices that we'll be getting from a person who will be legally advising the committee. So here we're being understood from a wrong perspective. And that is why we've wasted so much time debating something that we actually do not disagree on here, Chairperson. We're saying here, we are putting a clause which ordinarily should have been put by the legal team when they were establishing this document. They have omitted putting it because under the legal framework, you put all the legal pieces or all the legal information or all the legal sources, rather the constitution and legislations that you think that will be relevant to the operations of the committee, the constitution, the pieces of legislations. So that's where we're coming from. There is no disagreement here, Chair. So I think we must chill a little bit. Thank you very much.
Thank you so much. Look,
Chair, my last parting shot as well from MKP. One sentence, if you allow me.
Will you say 1 second?
Yes.
No. Let me give you 1 minute because in a second you can't say anything.
Yes. No. What I wanted to say, Chair, I think Honorable Nomvalo has summed it up, and I guess that we were in this point for almost 12 or 15 minutes now. My last parting shot from MKP is that I think Honorable Matthias as well said it will declassify where the matter will follow the protocols like they are there. But when we were putting this, we were very clear and ambiguous, in terms of what we were doing. We know exactly what we're talking about. And this was adopted earlier. It just changed some way. We were past that. Unfortunately, you allowed members to bring it back because after what I said. But what I'm saying to you, Chair, we've seen in the past that, this issue of the law, this, law, that. I'm closing by saying, that we still have a sealed. We don't want anything to be sealed here or classified and being told, no, this one is untouchable. Then let's not even start this core committee. Then let's close shop. Because we will be told by people, we've got IDEC, which we still have to come, like NPA and others. Papa, thank you, Chair.
Your 1 minute. Your 1 minute has expired.
Thank you, Chair.
Honorable members, I'm no longer taking any further inputs on this matter. I'm summarizing it. Look, there has been a difficulty in terms of understanding this matter, and that is basically why it has taken us so long. Because the honorable members are right. If you listen to what Honorable Cameron have said, the submission of the MK party is written, establish a protocol. And that is basically why honorable members are saying that, are you establishing a new protocol, or you want to check if there is an existing protocol, or must we subject ourselves to the already existing protocol? And I think now, at the end, the matter is well clarified. Whatever complexity or ambiguity in terms of understanding could have been there has now been removed, and we are one in terms of understanding. But furthermore, Andile must then make that protocol available for members to study it. If we take it in light of what Honorable Mathais have said, so that in the event there are impediments, we should be able to discuss and get advice on how impediments can be dealt with. If there is a legally permissible process to declassify what is classified, we will know those things once we have gone through the protocol. If the legal team wants to take us through a workshop on the protocol, we can still agree on one night during the week and say between 20 hours and 22 hours, the legal team must take us through that protocol so that we have one understanding, all of us. And I hear Honorable Nomvalo say it that people must take cool chill pills. There is no need to be jittery here. All of us, I assume, like we said that in the opening statement, it is still my greatest feeling and my greatest hope that all of us are committed to getting to the bottom of this matter, not in the name of our political parties, but in the name of ordinary South Africans who cannot speak for themselves, but still have an iota of faith that we are capable of acting reasonably in fulfilling their aspirations. And if that becomes the spirit that runs in us, is going to help us to do the work that Parliament has said we must go and do. The ordinary person cannot speak for himself or herself. The ordinary person is listening at us to hear us speaking in their name. And let's go and do that. If you have listened to the matters that were raised, there are families that have lost people. And those families want to hear us as members of Parliament speaking on their behalf, helping them to have closures to the unfortunate experiences that might have gone through. And I want to plead with honorable members that this is the spirit that must lead us when we do our work, and also agree that it has unnecessarily taken us so long, this item. Can I move to the next, which will be the EFF, for them to motivate their inputs? Honorable Mathais, is there anything you want to say on the submissions that you've made on item 2?
On which item? I've been moved on, Chair, to 3.1.
Remember, we were still on item 2. We have dealt with the submissions. We have dealt with the submissions of the ANC and the MKP. Maybe even before we go to the EFF, let's take the DA. Be ready, Honorable Mathais, after the DA.
Yes, I'm here. So you said, I didn't hear you clearly. You sent me on 3.1 now.
No, we're still dealing with the submissions on item 2.
2.9. Yeah, on the whole section 2, the EFF is fine, provided we do those amendments, and it is circulated with us so we can check the wording clearly on the issue of the classification of documents. And we would really press for it to be noted in there that the committee should be able to be in position to assist in the declassifying of documents legally if it is going to assist the committee in meeting its objectives. Otherwise, we are fine with the rest of their proposals. Thank you, Chair.
Okay, thank you so much. The DA.
Thank you, Chair. No, we're also fine for the rest of 2. So we will obviously make input again when we get to the third part, which is the objectives of the inquiry. Thank you, Chair.
Okay. Can I check, is there anyone who still wants to make input on item 2?
Yes, Chair.
Yeah. You can mention your name.
Nomvalo.
Okay. Honorable
Yes.
Nomvalo.
Yes, Chair. We had made a request, Chair. I don't know if they are entertaining it, the legal team, that they must look for a case law and put it here under the legal framework.
Okay. I hear that.
I don't understand that request, Chairperson. Chairperson, we don't want to proceed without understanding each other. We know that case law, Chairperson, is part of our law. I just want to understand how Honorable Nomvalo wants us to do this. Thanks.
Yes, Chairperson, no, the case law is part of the sources of our laws through common law. So we're hoping that a case maybe of with similar merits will be researched and be put here to see how the court adjudicated. A case law, for instance, which favored the establishment of the ad hoc committee to deal with allegations from the executive. Did you make a research maybe in that regard?
No, the thing is, as you would know, Honorable Nomvalo, on each and every legal principle, possibly, we could have a case law on that. But the thing is, if you look at the legal framework, it just sets out the parameters legally. As you say, Constitution, Powers and Privileges Act, this and that, and so on. And even with the other ad hoc committees, we have had similar, not necessarily identical issues with this committee. The legal framework we're relying on covers in a greater degree what this committee must do.
Honorable Sols.
Honorable Chair, are you able to hear me?
Honorable Sols, I can hear you loudly.
Thank you, Chair. On 2.5, the legal team said that they included the entire section 14 of the PUPLA. That's not the entire section 14. And the subsection of section 14 that they did include, they recorded it as subsection 2. And it's not subsection 2. What they did record is actually subsection 3 of section 14 of the Act. Thank you, Chair.
Andile, what is your comment on that one?
Yes, Honorable Source is right, Chairperson. That was
So
a typo.
you will
Honorable Source
correct
is
it.
right. Yes, Chairperson.
Yeah. Can we just record it that it will be corrected? Okay. Who else wanted to speak before we leave this item? I just want to be certain that we're not leaving anybody out.
It's me, Chair. My hand has been up.
Honorable Ngola, okay. I'm sorry.
Thank you very much, Chair. I think, Chair, I want to first agree with Honorable Nomvalo on the importance of legal precedences that have throughout time helped us to build our jurisprudence. But I think they are not for purposes of the terms of reference. The legal team is still going to work on each and every aspect on how then has courts been able to adjudicate in some of the matters that we'll be dealing with. So I'm saying, Chair, understanding and agreeing on the importance of the legal precedences, but they are not for the purposes of developing a terms of reference, which must be a guiding document that we have. There's still going to be research work that is going to be done. There's still going to be a lot of work that is going to be done. We are still going there. Thank you very much, sir.
Skosana, is this a legacy hand or is it an old hand? Okay, we can't get Honorable Skosana. So, honorable members, this will conclude our discussions on this item. I think the parties are happy with the matters that have been clarified on item 2, that the inputs are correctly captured, and where there was clarity needed, that clarity has been provided. And I still insist that the protocol will be made available for members to study it and understand what it provides for. Can we then move to the next item, Andile?
You mean, Chairperson, paragraph 3? Aye, Chairperson.
Item 3, Andile.
Yes, no, Chairperson, we have no issue with what the EFF has proposed. Chairperson, if you go to the House resolution, which was, of course, adopted on the 23rd of July, you will see that paragraph 7A, it says that investigate the veracity and implications of the allegations made by Lieutenant General Mkhwanazi. Of course, the EFF has added extent, including the evidence of collusion between any state officials and criminal syndicates. We have no issue with that. Thanks very much. I'm not sure if you want me to also deal with the submissions of the Democratic Alliance. Are you still there, Chairperson?
Oh, sorry, I was muted. I say we wanted to hear the impressions of the legal team.
Yes. So I think, Chairperson,
with
so
the
that
EFF, you are fine. Can we go to the DA?
Chair, just to make the process less painful, I think, Chairperson, my proposal is that as legal services, I mean, let me give our view insofar as paragraph 3 is concerned. So that once I do that, Chairperson, I then write into the sunset. In other words, allow members to persuade one another. So, Chairperson, we've picked up 3 areas of concern. The first one, Chairperson, is a submission by the Democratic Alliance, which is 3.9, where they say, report to the National Assembly on its findings and recommendations by no later than 31st October 2025, with monthly reports to be tabled throughout the duration of the inquiry. And the point we're making, Chairperson, is a simple one. We're simply saying the House resolution is silent on the submission of monthly reports to the House by the committee. So we're not saying that is not legally permissible, Chairperson, but we're merely saying that the House resolution is silent. All we're expected to do, Chairperson, is to report back to the House by the 31st of October 2025. So that's the first point. The second point, Chairperson, is a point which the DA makes, which says police misconduct, evaluating the extent of misconduct, human rights abuses, and unethical behavior by members of SEPS and any other relevant individuals or institutions. And I think the point we're making, Chairperson, is that if you look at the House resolution, the House resolution, Chairperson, does not include human rights abuses by members of SEPS. And of course, our view is that this may require a scope extension, by the House. And the last one, Chairperson, is when they speak about assess the role of the unions, e.g. hip-hop crew, in undermining disciplinary processes and shielding compromised officers from accountability. And of course, the point we're making, Chairperson, is that our assessment is that this falls outside of the scope of the House resolution. This may require scope extension by the House. Thanks, Chairperson. Other than that, Chairperson, other submissions, we have no legal issues in respect of paragraph 3. Thanks,
Yes. So you are saying that in the whole of paragraph 3,
yes,
where you have issue is on those 2 matters of human rights and 3 matters of human rights and the
those were
union
submissions by the Democratic Alliance.
and the monthly reports.
Yes, Chairperson.
Yeah. So your view is that we may not necessarily include them in the terms of reference.
Our issue, Chairperson, is just the scope, Chairperson, is that we must be very careful in the sense that, Chairperson, we only have 2.5 months, Chairperson.
You are saying that you are saying that they fall outside the boundaries of the resolution.
That's our submission, Chairperson. Thanks very much.
Okay, it's fine, but the rest is okay.
In our view, Chairperson, yes.
Then I'm going to start with the DA to hear what their view is on those 3 matters. And then from there, allow the parties to speak, and then we conclude the item. Democratic Alliance.
Thank you, Chair. Chair, just in terms of the monthly feedback, I think the idea is that we constantly keep the House updated as to what we are busy with. It's a good principle to have consistent feedback, especially when there might be a frustration due to previous inquiries, commissions, whatever we would like to call it, whether inside or out of Parliament, that people sometimes, especially in terms of the public, feels that they are not taken into confidence. So the monthly feedback is purely for that, to give feedback to the House. And so obviously that would mean that the relevant feedback would go back to the relevant constituencies that Parliament is giving the relevant attention to the said investigation. In terms of human rights abuses, I don't agree with what the legal advisor says, because there are different types of abuses that might link to what General Mkhwanazi said. There could be indications of disciplinary wrongdoing. That's where the unions touch. I'll come to that now. The point is just that something might not necessarily be directly a criminal offence, but might touch on some kind of a labor discrepancy, something that may not have been done correctly in terms of, let's say, a disciplinary hearing, or it might be an outright human rights or questionable human rights infringement of some kind. We know that there have been complaints with regards to the way that the expeditious process in the South African Police Service has been used over the years. And while I'm not the one to decide whether the specific policy is wrong or right, I think it is important that we give fair chance that anything that indicates some kind of a transgression can be looked at by the committee when it comes to anything that General Mkhwanazi allegedly exposed or outlined in any way. In terms of the union involvement, again, I disagree. I think it's very, very important. In fact, I would go as far as saying of the 3 points that legal services have questioned, that specific one is the most critical. In fact, it is even more critical because some of the officers that General Mkhwanazi mentioned were previously defended by some of the different unions in the South African Police Service. And one would need to consider the role that they played when people were found guilty or possibly found not guilty in terms of labor disputes or something else. So there are, for example, people that have been on suspension for many, many years and are still getting a full salary that would likely also be able to be linked to some of the allegations that General Mkhwanazi made. We can mention as a good example the family members of Richard Mkhwanazi that still serve inside crime intelligence. Some of them were previously represented by some of these unions. So I cannot stress enough how important it is because it seems to me that sometimes unions play an incredibly important and positive role. And then unfortunately, in other times, it seems that the role or the difference between being a criminal defense lawyer and being a fair labor representative is confused. Thank you, Chair.
Okay. No, thank you so much, Honorable Cameron. Let's hear the ANC. Honorable members, we are discussing the 3 matters that the legal team has commented on, and we had your input, Honorable, and motivation, Honorable Cameron. Can we move to the ANC?
Thank you very much, Honorable Chairperson. I think on the 3 issues, as the ANC, we share the view of the legal team that there is a bit of a scope creep in this matter, and in which case then we would want, perhaps if it is the contention of the committee, that we discuss how we handle the issue of us expanding the scope, because I don't think that the committee can do that unilaterally, especially given the fact that the report had been adopted by the National Assembly. On the issue of the labor union in particular, Chairperson, if you look at the submissions of the DA, I know that I'm only referring to them in the context of the 3 issues that you speak about. There is a submission there, which I'm just trying to find, which speaks about assessing the internal mechanisms, assess the adequacy of internal mechanism for dealing with, it's point 5 on their submission. I think we do feel that to a large extent, this covers their issue relating to their issue around the unions. We don't think that it's necessarily correct to seek to expand the scope by focusing on POP crew in particular. There could be many other issues that relate to internal mechanisms within the SAPS without then wanting to highlight the issue of POP crew. Perhaps that matter can be adequately dealt with in their their proposal around mechanisms for dealing with misconduct and so forth. Thank you very much, Chairperson.
Thank you, Honorable Sangoni. Can we go to the MKP?
Yeah, thank you very much, Chair. Chair, we align ourselves with the perspective of the legal team, in particular on human rights violations or possible human rights violations. I think that will extend Chairperson in our time, and given the time that we have set for ourselves, that a report must be tendered. I mean, the inquiry must be concluded on or before the end of October. That time is very limited. So, Chairperson, our view is that let's just solely focus on the terms of reference which are arising from the allegations made by General Nhlanhla Mkhwanazi. Because if we take this route, we will have to invite many institutions which are dealing with human rights in South Africa, like the Human Rights Commission, and considering the scourge of human rights violation, it requires a very lot of time, Chairperson. It can't be that exercise concluded within this period that we are left with. And then with regards to monthly accountability to Parliament, I think, Chair, maybe what can happen is that from time to time, the committee can give updates, maybe in writing, to the Speaker of Parliament to update her about progress that we have made as the committee. I do not think, Chair, that it will be feasible for us to account on a monthly basis to the House. We can do it, we can account, or we can account to Parliament through accounting to the head of Parliament, which is the Speaker of Parliament. That is our submission. Thank you very much.
EFF.
Thank you, Chair. Are we going to deal with the inputs of the DA? In terms of the monthly report, I get the point of us having to be able to report to the National Assembly, but that would be in the absence of the ad hoc committee proceedings not being broadcast live. So the public will be privy to what's going on in the committee. So us having to sit in the National Assembly and present a report, I think it's just going to add to an already heavy workload. I think we can concur that we can submit a report without necessarily to the Speaker, without us necessarily presenting it in the National Assembly. In terms of the DA submissions on human rights abuses and getting the unions and stuff involved, I mean, the DA's drafting style is just extremely expansive in its nature. I think what it is that we're wanting to achieve, it would be uncovered. So, for example, if there is something human rights abused related in a matter, we're not going to say, no, we're not going to cover it, or we're not going to bring the witness in to talk about it. But I don't think it's necessary for us to capture it in the terms of reference, that we must look particularly into that. But when those matters do and as arise, I don't see us as a committee disregarding such things. That's our input in that regard. And then in terms of the EFF, I think we were covered. Our proposal is that we must be 3.1. There were proposals from other parties that we removed the word investigate. And we used the word inquiry. I think that was what the ANC was proposing. And then the Action SA was proposing that we use the word interrogating question. But for number one, the National Assembly that was presented by the Chief Whip of the ANC, the resolution was very clear on using the word investigate. So that is something that should have been raised in the National Assembly. Also, it's not unconstitutional to do so. So the arguments put forth both by the ANC or the Action SA on why we must use the word inquire or interrogate or hear, it's not unconstitutional to use the word investigate. So I think we must move with what it was adopted in the National Assembly and the motion that was presented by the majority party. And also, if you look at the SABC terms of reference, it also stated that there must be an investigation. So there's nothing that we are doing that is out of the ordinary. Thank you, Chair.
IFP.
Thank you, Honorable Chairperson. I think with regard to the issue of the monthly reports, I think we would like to align ourselves with those, with a sentiment that it might not actually be necessary to do so through Parliament, but we may actually, report from time to time through the Speaker. Because at any rate, at the end of the process, we are going to be actually tabling a comprehensive report to Parliament, which will actually enable all other parties to actually interrogate the report. As for the issue around the human rights abuse or misconduct, I think it makes sense to us that, we will deal with those obviously as they arise without shunning away from them, but we will find a way to actually deal with them because we cannot ignore, submissions of alleged misconduct on issues of human rights by steps. But I'm not too sure whether we should actually put it on the document because that would seem to be wanting to expand the scope of this committee, which is not actually part of the original motion of establishment, which was actually the motion adopted in Parliament. Thank you.
Honorable Sauls.
Honorable Chair, thank you. On the DA submissions, we agree with the input by legal on all three counts. And then on 3.1, on the use of inquire or investigate, we agree with the word investigate. We know that this is an inquiry, but if we use the words inquire, it's almost to water down and limit the committee's approach just to sort of a surface level addressing of matters. But the word investigate aligns with the words used in the Constitution, Section 42, subsection 3, that empowers Parliament to scrutinize. And I think investigate aligns with an in-depth. And yes, we do know that there are different agencies that does investigations, but we are clear what investigation the committee will do. For an example, there's different types of investigation. You can have investigative journalism, for example. It is not investigation like the police, but it highlights that that form of journalism is more in-depth. It's more zoomed in. And I think that's the intention of the Constitution when speaking about what we are empowered to do with the use of scrutinize. It's a more in-depth look rather than what inquire does. It gives sort of a high-level view. So we agree with the use of the word investigate, the veracity, extent, and implications of the allegations. Thank you, Chair.
Honorable James.
Thank you so much, Chair. We reject the submission made by the ANC, as we believe the word inquire does not give the public the assurance that we will leave no stone unturned as the ad hoc committee. We support the submission by the EFF, and we'd like to suggest that we merge what Action SA has suggested here, interrogate and question, and also just to include there during his media briefing on the 6th of July, 2025. On the human rights abuses, we agree with the legal input. And then also on the issue of monthly reporting, I'm covered by Honorable Mates when she said earlier on that the public will have access to the progress via, watching the meetings. So there's actually no need for us to report on a monthly basis. Thank you, Chair. Was that captured, Chair?
Yes, I see there are 3 hands here from Honorable Skosana, Honorable Shikelen, and Honorable Sangon. Can we take the hands in that order? Honorable Skosana, I see the hand has now lowered. Honorable Sangon. Honorable Shikelen.
Thank you so much, Chairperson. I appreciate the opportunity. Chair, on the reporting back, I understand what the committee says, but Chair, if I look at the time that we're on today already, and we haven't even finalized these terms of reference, I don't think I'm the only one that foresees that we may not finish or complete this investigation by the end of October. And the reason for the report back is also obviously for the relevant political parties and the speaker to know how far we are and if we need extra time. And that is the reason for the feedback. Chair, on including the human rights issues, there's already been evidence that's been presented and emails that have been sent to the police committee, of which many of the other members of here are on, that do indicate that there are issues of human rights. So we have to be cognizant of the fact that the human rights issues are going to come up quite drastically, and we must make sure that we do have some form to cover them. And then, Chair, the unions play a very big role in this. And a lot of the SAPS officers that are implicated have been cleared by the unions on their side or have been protected by the union. And they've often stepped in to block or delay disciplinary action against members that are facing corruption or misconduct charges, and this undermines accountability. And we really think that this should be included, Chair, to have a look at it. Some unions have acted as political actors. They've aligned themselves with different factions in political parties, and there has been union pressure that has fostered an environment where officers believe they can escape consequences. And I think part of this committee's job is to make sure that nobody escapes consequences, and know that they will definitely fight, and we will fight them, and we will make sure that the full might of the law is taken place and is adhered to when we find that these issues of misconduct have taken place. So it's just something we would like to add. Thank you, Chairperson.
Thank you so much, Honorable Shikelen. Honorable Sangon.
My apologies, Chair. I was struggling to unmute. Chairperson, I think I've been covered by the inputs that have been made by Honorable Mates and a number of other honorable members who spoke, which says that we are not saying that anything will not be investigated as and when it arises. And we do continue to hold the view that the terms of reference as they currently are do cover the unions, but I do also, do cover the issues that the DA is raising. Chairperson, also, another reason why we are motivating perhaps that we look at the issue of the unions. POPCRU is not the only police union, for example, in South Africa. We know that there's the South African Policing Union and so forth. So to go out and want to single out POPCRU for us remains problematic. But even without that specific focus on it, we think that the terms of reference will cover human rights abuses, will cover police. But the reason I came back, Chairperson, was that I was not aware that we were discussing the issue of investigate. As the African National Congress, the use of the word is not a hill that should be removed from it. As I was saying, Chairperson, the use of the word is not a hill that we are prepared to die on, but what we are saying, and Honorable Souls refers to the Constitution insofar as the mandate and the authority of Parliament. And I think in section 4, in chapter 4 of the Constitution, as well as section 55, it's very clear the roles of Parliament. We are concerned about this point, Chair, and as I've said, we are willing to step down on it, but we are concerned that further down in the document, there are parties that then make submissions and proposals for forensic investigators to be brought in. So we need to be very clear in terms of the scope of this investigation. If it is to be called an investigation, we do not have the authority as Parliament to delve into the issues of criminal investigations. It is not our mandate and we don't have the capabilities to do it. And we would accept that we're saying that the committee investigates as long as the parameters are defined, because you cannot, I think in legal interpretation, just take a word literally and assume that you don't have to look at the context in which it arises. Thank you, Chairperson.
Honorable Cameron, Honorable Ntuli, Honorable Nomvalo is the last.
Thank you, Chair. Just a point of clarity, Chair. You'll see we don't say just POPCRU. It just says POPCRU as an example. It would include IPUSA, it would include SAPU and POPCRU. We just didn't list them. It was just an example of one of the unions. It says EG in brackets before. So just a point of clarity. We're not zooming in on one specific part. Again, I just want to emphasize we really have a massive problem. We've picked it up in the police committee as well. Almost all of the members have raised that we constantly see that members, whether senior or junior in the South African Police Service, end up back at the station or back at a unit, despite having been found guilty of serious transgression, things like armed robbery even. So it is therefore that it's important if it should come up after the expose by General Mkhwanazi. Thank you, Chair. That's it for us.
Honorable Ntuli.
No, thanks, Chair. I think, Chair, the first observation I want to make is that when you initially invited comments, you were very particular that we must comment on the 3 areas where the legal services has disagreed with the proposal of the DA. But what has then happened, and I would imagine you've allowed it to proceed in that way for a particular reason, is that the comments went beyond item 3. They are now in item 4. Now, let me tell you what is my difficulty with that. Is that now that we did not deal with the areas you wanted us to confine our comments on, what should I do? Because I have another issue that I want to deal with, which was not part of what you had said we must consider. So that's the first thing where I need your guidance on. The second one is that I want to align myself. Of course, it's very creative for the DA to use POPCRU as the example on the matter. But I align myself with the point that is saying I don't think that we should make it our own decision to assess the role of the unions. In an event where in the quest of ourselves getting information from various sources, a union or unions are cited, let's deal with that issue as it arises from the submissions and evidence presented before the portfolio committee, as opposed to us setting for ourselves a specific target. That part of what we want to do is to assess the role of the unions. And as I'm saying, the creativity of the DA, of course, I understand what it meant by choosing POPCRU. And the example made earlier on about how the unions are understood or seen to be somehow intertwined with political parties and their factional dynamics. But notwithstanding all of those, I still think that let's not define it as our own specific mandate, tasks that we want to undertake. Let it arise if it does in the context of our work, and from which we will then decide how to handle it, as it will be the case with many other issues that may not be accommodated in our terms of reference. But I want to go back to the point I was saying, we need your guidance, because this issue, for instance, about POPCRU is on paragraph 4, and we're not done with paragraph 3. So I don't know what to do. I agree with Honorable.
Let's talk to the three matters that were isolated by the legal team on item 3.
Okay, then on that, I'm done. I will come back when we come to other issues, not ring fence.
The next item is going to be item number 4. I'm going to recognize you again to speak on that item. Agreed? Can Honorable Nomvalo, is your hand still up?
Yes, Chairperson.
You can speak.
Yes. So, Chairperson, we just wanted to say that in our view, there is no problem with using the word investigation. Yeah, because in terms of Rule 227 of the National Assembly rules, it says, and I know that it talks about the portfolio committee, but the ad hoc committee as well is a committee of parliament. But it says that a portfolio committee may monitor, investigate, inquire into, and make recommendations concerning any such executive organ of state, constitutional institution, including the legislative program, budget, rationalization, restructuring, functioning, and organization, policies such as organ of state, institution, or any other body or institution. That's what it says. We know that maybe a sentiment that powers to investigate are only vested in the South African police, in the SAPS, may emanate from Section 205 of the Criminal Procedure Act. But insofar as the rules of parliament, there is nothing wrong, Chairperson, when we use the term investigate in our terms of reference. There is no clause, there is no provision that precludes us from doing such. Thank you very much.
Chairperson, I'm so sorry to interject, because I hate it also when people interject, but I also wanted to respect Comrade Nomba. You are confusing us, Chair, because you said that we must only deal with the 3 issues that were raised in relation to the DA submission. As I've said, this issue of investigate, which came from an ANC submission, is one that we just need clarification on. We're not fighting for the word investigate. I do apologize, Chairperson, for interjecting, but can we then follow what you said we would do, which is just to deal with the DA submission, and then we come back to other issues? Thank you, Chair.
Yeah, I think that everybody who wanted to speak on the DA submission has spoken on the 3 items that the 3 matters that the legal team has isolated. I see your hand is still up, Honorable Cameron.
Apologies, Chair. It's a legacy hand from earlier. Sorry about that.
Okay. Thank you so much. Honorable members, The majority view here agrees with the legal team. That does not mean that the matters that have been raised by the DA will not be given consideration by the committee. If as a starting point, let's play within the resolution of Parliament, which is to investigate the allegations that have been made by General Mkhwanazi. I think that is a boundary defined for us. But in the event, during the proceedings, or whenever General Mkhwanazi comes to present before the committee, and then in his presentation, he further alleges that there are alleged certain matters that will need to be given consideration. We should be able to do that as a committee. If issues of human rights abuse come to the fore or come to light, we should be able to follow them up for as long as there are perpetrators who are being mentioned, who will then have to appear before the committee to account on the allegations that would have been made. So, and with regard to the monthly reporting, I think members have also covered it. The public is allowed to participate in our hearings. We will also encourage our communication section is what they've been doing so far. After every meeting of the committee, they issue statements on key decisions that the committee would have taken. And for sure, if there is a way in which they can also publish meetings or proceedings of the committee, we will also advise them updated on the work of the committee. I think at some stage, if the committee runs over the period that would have been decided by the National Assembly, we can at that stage make a decision whether we want to release an updated report. But I think it's a matter which we'll come and look at. But for now, let's go along with what is here before us. Thank you so much. Andile, can we move?
Yes, Chairperson. I'm assuming, Chairperson, when you say can we move, you are saying we must move to paragraph 4, which is the objectives of the inquiry. Am I correct, Chairperson?
Before we go there, where do we locate the way to investigate?
Oh, okay. That's paragraph 3, Chair, at the beginning.
Okay, before we leave paragraph 3, the ANC, do you still want to pursue the way to investigate?
Chairperson, I don't think that we are fundamental on the word investigate being removed. We have no problem with retaining investigate, but I do want to reiterate the point that we had made, that ours is not a criminal investigation, but rather we are investigating in the ordinary course of the use of the word of an investigation, an inquiry, an interrogation, scrutinizing, and so forth. But Chair, with your guidance, can I check that if there are other issues on paragraph 3 that we will still get an opportunity to come back, because there are 1 or 2 other matters that we would like to raise in relation to paragraph 3, but we can stand down on the use of the word investigate. Thank you, Chair.
Okay, fine. You can then go.
I may proceed, Chair?
On and raise the matters that, yes, you are allowed.
Thank you very much. Chairperson, on 3.2, there's a submission by the DA that minority parties must be permitted to submit dissenting or supplementary reports as part of the record. I think there again we need clarity, like Honorable Nomvalo had referred us to the rules of the National Assembly in relation to the word investigate. We also want to refer the committee to the rules of the National Assembly, specifically 166 and 166.4 in particular, which reads that a committee may not submit a minority report. It goes so far as to say if a report is not unanimous, it must specify in which respects there was no consensus. In addition to the views representative of the majority, express any views of a minority in the committee. So the rules of the National Assembly explicitly disallow the submission of minority or dissenting supplementary reports as part of the record, but rather propose how such reports should be handled. Thank you very much, Chair.
Is that the only matter that you wanted to raise at number 3?
Chairperson, I'm not sure. Yes, I believe it may be Chairperson. Oh, no. Sorry. I focused on that one. Chair, there is the issue also on the DA submission towards the bottom. There's an issue of the establishment, it's point 10, that Parliament must establish an oversight mechanism to track implementation and reform progress for at least a 12 months post-report. Now, again, if you read the rules of the National Assembly, 253.6, it says that once an ad hoc committee has completed its work, it is dissolved. Our submission is that there are portfolio committees in Parliament that have oversight of the areas that we will be investigating, and that we believe that this particular ad hoc committee should submit its report, and the portfolio committees, for example, on police and on justice and constitutional affairs, can then be left to track the implementation of those recommendations. We don't believe that it is a work of this ad hoc committee to do that. The other issues, Chair, I think we believe that they're really very presumptive in nature, in the sense that it's already speaking to the recommendations that may come out. It's not fundamental for us, but we do think, for example, point 6, point 7, point 8 in the DA submission may be issues that fall as part of the submissions. Similarly, I think on the submission of MKP, again, we are already presuming what the reports or the recommendations will look like. They are not fundamental matters for us, Chair, as we are saying, but we don't think they necessarily belong in the terms of reference, but we can leave them. But the matter that I raised on the oversight mechanism, I think that's a serious issue for us, as well as the minority or dissenting supplementary reports. Thank you, Chairperson.
Thank you so much. Can we get the Democratic Alliance to motivate their submission on minority reports and oversight mechanism committee?
Thank you, Chair. I think the comment regarding the oversight mechanism is we are comfortable if it is then established that the follow-up must be done by the relevant parliamentary committees. The point is just that we need to make sure that whatever report or recommendation comes out of this process doesn't just gather dust. So it's not for us to say that they necessarily must be something brand new. Again, like I said earlier about the relevant protocol regarding classified information, we are more than happy to use the existing protocol as needed. The point is just, I think it's important to explicitly say then that it will be referred for follow-up, and that we when we get to the point where we have to complete the final report, we can say where that reference is going to go, to which committees, and what is expected within what time period, or what is recommended within which time period. And then it also gives a guideline to those relevant committees. Regarding the point about the minority parties, I think the question is just to make sure there is the relevant, parties or stakeholders are able to make the supplementary reports and have solid representation. But we are open to discuss this and also hear the input from other parties should there be any as such. I'm not sure if my colleague, Honourable Schikkerling, would like to add something to that, Chair, but that's it from me.
Okay, Honourable Cameron. Honourable Skellen, is there anything you want to add?
Thank you, Chairperson. No, I'm covered by Honourable Cameron. Thank you very much. I just think that if it is going to go back to the relevant committees, there must just be some recommendation of how we must make sure that if necessary, the reforms and disciplinary actions are put into place. Thank you.
Okay. The MKP, what is your comment?
No, Chair, we are not going to waste time. We just agree with the observations and sentiments made by Honorable Kusela, because I think to a certain extent they relate to the rules of Parliament. So we agree with them on oversight, and also on oversight that it must be done by relevant committees, police and the portfolio committee on justice and constitutional development. And what we can say is that the report, but we know that we will deal with it when we get to that stage. The report will have to, of course, identify and give details to areas of disagreements if maybe it is not unanimous. That is our submission, Chair. Thank you.
The EFF.
Chair, largely we support the input. The rules speak to the issue of allowing minority parties to give supplementary reports, so we will align ourselves with that. Also on the issue of point 10 about establishing an oversight mechanism, we'll align ourselves with the established rules of the National Assembly. But obviously, we do think that it is important that the committee doesn't just close shop and matters are not implemented. So, for example, if a matter is we refer a matter to the police for criminal investigation, we must be able to have a mechanism in place to make sure that that has been acted on and report back. Otherwise, we are going to be wasting a lot of our time, our money, and our efforts as a portfolio committee. And otherwise, we are fine with the inputs on Section 3, Chair. Thank you.
The IFP.
Well, Chair, we are actually largely covered by the speakers before me, especially the very last one on the issue of, for instance, point number 10 of the DA submission, where we are actually in agreement that relevant portfolio committees should actually be the ones who actually deal with the recommendations emanating from the activities of this ad hoc committee, and also the fact that we should also have a built-in mechanism to ensure that even the portfolio committees actually do what we recommend in our reports. Thank you.
The PA.
Thank you, Chair. We think that the words investigate the veracity, extent, and implications of the allegations covers what the DA has submitted in point form. And then the issues of contention of the DA submissions, we too align with what the NA rules says concerning those. Thank you, Chair.
Honorable Sauls.
Yes,
Honorable Sauls, did you comment on the minority reports and the oversight mechanism?
Yes, my response to that was we align with what the NA rules says concerning that.
Okay, thank you so much. Honorable James.
Chair, we've made our remarks on section 3. We are fine with the input given, and we too align with the rules.
Oh, okay. Thank you so much. Honorable members.
Chair.
Okay.
Chair.
Yes, Honorable Skosana.
I'm sorry, Chair, to do this to you. I'm not sure whether you hear me.
Yes, I hear you.
Thank you, Chair. I'm sorry, Chair. I was just wanted to make a remark, perhaps, before you close this matter. That if all these matters are being referred to portfolio committees or to SAPs or whatever the recommendations we're going to do, hopefully we are not going to spit on South Africans like what happened in the past, because we have experience now of what happened in the past. So we hope that whatever matter we are referring to these institutions, is beyond reproach, that you will find, that these other institutions covered, they close ranks as well to come up with, which leads much to be desired. I know that in terms of the law, we might not have the tools to bite,
Sure.
But
Can I call a point of order, Chair? Can I call a point of order?
But I'm making a remark, Chair. Protect me, Chair. I don't know what's wrong with that. What's wrong about what I'm saying?
No, honorable members.
What's wrong? Why people are catching feelings when I'm making my remark? I listen to people, whatever I agree or I don't agree, but I listen to them.
Honorable
and I'm
members,
I'm not saying anything wrong here, Chair. Please protect me. Because I can do that as well. I can stop people speaking and say, please order. But let's not degenerate this committee into that. Let's respect each other. I'm making a comment here, and I'm allowed to do so as a member. Thank you, Chair.
Honorable Skosana, you must not be triggered. When you speak and somebody intrudes, wait for the chair to make a ruling and don't be agitated. That will make you to lose focus. I think what Honorable Nhlanhla did was incorrect. But equally, I don't think that you were supposed to have taken it to the level that you did, Honorable Skosa. What matters here is that we are discussing the terms of reference. We're not discussing the report that must go to Parliament. The time for the report will come, and if there are recommendations that honorable members will want to make on how their findings can be processed, they will be given an opportunity to table recommendations that will be incorporated in the final report to Parliament. And Parliament will make a consideration of the report and decide. Parties are still going to debate this report in Parliament. So I think we must leave it here and agree
Chair.
that.
Thank you, Chair, for protecting me in that matter. But I was saying, because people were saying some matters will be sent to portfolio committees where it's relevant and others. So I was just making that remark to say it doesn't matter, but we must make sure that we don't spit on the face of South Africans, because we are representing South Africans here. We are not representing our parties here only. So hence I was saying, I hope that there won't be anything, because we've seen this thing in the past. And there's nothing wrong with me saying that. I'm not accusing anybody. I'm just saying, here as members. Thank you, Chair.
Yeah, because you are doing exactly what Honorable Nhlanhla did. When you spoke, he interjected. And now when I speak, you do the same thing.
Chair, it's not me, it's the Chief Whip.
No, it's fine. Yeah, for the respect of the Chief Whip, the king is never wrong. We then point
I can
fingers.
take the fall, Chair, it's fine.
You must take for the fall for your chief. Look, what we are saying, honorable members, is that let's not discuss the report of the committee now. Let's confine ourselves to the terms of reference, and I think we have adequately dealt with this matter. We must now leave it. The rules of the National Assembly are very clear. Yeah, the rules are very clear on how, on the suggestions that have been made here. If there is a minority view in the committee, or the committee is not unanimous, like Honorable Nombala has said, all those will be noted in the report. That will go to the report will be comprehensive. Where there is unanimity, the report will indicate that on the following matters, the committee is unanimous. And where there is there is a split, the report will accordingly capture that to say there is no sufficient agreement on the recommendations on the following matters. And then it will be for Parliament to apply itself to the recommendations of to the report and the recommendations of the committee, including the oversight mechanism. We may not recommend something outside the rules, but we can still make recommendations to Parliament to say, if there are past unpleasant experiences, the committee can make recommendations and say there will be a need for these matters to be followed up and ensure that there is a consequence management. There are the following options that Parliament can consider. Yeah, but for now, let's deal with the terms of reference, because I can see that we are debating the finishing line now. The race has not started. Let's get our outfits first to prepare for the race. Thank you. Honorable Sangoen, what was the other matter that you raised regarding the submission of the MKP?
Thank you, Honorable Chairperson. No, I just said that it follows the comments that we had made on the DA, that the issues are presumptive in terms of issues that should go into recommendations, but it's not something that we are arguing strongly about, that they should be removed, Chairperson. Thank you.
So we can leave it?
Yes, we can, Honorable Chairperson. Thank you.
Okay. So in this case, honorable members, this would have been the last item for discussion at item 3. Am I correct? Or is there anybody who still feels that there is a matter at item 3 which has not been discussed? going on. So we are done with item 3. Can we move to the next item? Andy, let me check. Let me first check with honorable members whether they will want a 30 minutes break or we continue and conclude the work. ANC.
I don't know. We don't have a position on this one, Chairperson.
Okay, what
You
is
must
the
take a
amount?
position, Andy.
What is the amount of work left, Andy?
Chairperson, we are on paragraph 4 now, and the document I think has got 11 paragraphs. So we're left with we're left with about 7. Yeah,
7 paragraphs.
that's correct, Chairperson.
Okay. Let's take paragraph 4 and then we will break here after.
Okay, paragraph 4, Chairperson, deals with the scope of the inquiry. And Chairperson, in actual fact, the 2 points which the committee has already deliberated on, Chairperson, regarding what was raised by the DA in respect of human rights abuses and the role of unions belong exactly in this territory in paragraph 4. So that has already been traced out, Chairperson. Other than that, Chairperson, we have no issues.
So can I hear the voices of the members saying pass?
No, Chair, not pass. There are comments that we would like to make from the ANC.
Okay.
Paragraph 4.
Yeah.
Should I proceed?
You are allowed, Chief Whip. You can proceed.
Thank you very much, Chair. I think the first point that is what we submitted as the ANC, which we would like the parties to consider and support, where we say the evidence of Lieutenant General Nhlanhla Mkhwanazi before the committee shall be used as the basis to establish the approach the committee will take on the appropriate witnesses to be invited. What we mean by that? We mean that we are of the view that the first witness to appear before the committee should be Lieutenant General Mkhwanazi, as a consequence of which his evidence before the committee should also serve as a compass for us in terms of who else to look for to respond to the allegations that he would have, allegations and evidence that he would present before the committee. So that is the proposal we want to put before the committee. That doesn't mean we have anybody in mind that should be excluded, but we're of the view that the one who began the process, his contribution to the committee should be the first thing that helps us to determine who else do we want, whether he mentions them or he doesn't mention them. But based on what he has reported to us, who else must be invited by the committee? So that is the point we would like to make, Chair. I don't know whether you want the meeting to deal with that first or before, or I should proceed to comment on the DA submission. So let me stop there.
Is that the only point the ANC is making?
Yes, that's the only ANC proposal, but there are proposals of others which to comment on.
Can I check with the parties if there is anyone disagreeing with what you are saying? The MKP.
Chairperson, no, Chair, we don't agree. We don't disagree, Chair, because if there was no person on the 6th of July, Chairperson, may I
so they want us to only base it on what so they're trying to limit it and they're being smart about it. So we're saying that his allegations have triggered the establishment of the committee, but the mandate and consequences of the committee must extend beyond just his submission. Yeah.
Who is speaking? Because the MK party is the one that is on the platform.
Honorable Mates is consulting.
Manje is consulting on the platform.
Can I carry on, Chairperson?
Can we first check if Honorable Matthias has muted?
Yeah, and I think Honorable Mvalo must carry on from that briefing arrangement.
Which briefing now?
The one of Honorable Matthias.
I did not even hear what he was saying.
Okay, if she's
Yes,
done
Chairperson.
with the, can we now hear Honorable Nombalo? The ANC is suggesting that number one, that what do you call Lieutenant General Mkhwanazi, in terms of the scope, is ideally the first witness that must be called before the committee, and that further to what he has said at the press briefing, he may come and say other things more, which will then extend or expand the scope of the committee. If he comes here and mention the name of Nhlanhla, which was not mentioned before, so it means Nhlanhla will then be added to the names of the people that the committee may want to invite. I think I understand him to be saying that. Is that the correct understanding, Chief Whip?
That's correct, Chair. It doesn't stop anybody. I was just suggesting that we start with the man who started.
Yeah, it doesn't. Yeah, it doesn't stop anybody or any matter from being included in the scope of our terms of reference. MKP, Honorable Nomvalo.
Yeah, thank you very much, Chair. No, Chair, I was saying we support that to the extent that it is not going to limit the committee from inviting any other person which the committee deems to be relevant for its investigation. So we support it, Chair, because had it not been for a press briefing that was held on the 6th of July, we would not be here. And it's fair that when you conduct an investigation, you call a person who made allegations first to give you more insight of his allegations and to adduce more evidence, which is necessary for our inquiry or for our investigation. So we support each Chair, but our support is that it should not be a limitation to invite other relevant witnesses. We believe that as we continue to do our work as the committee, from time to time, when there's information or when there are witnesses who want to come, the committee will sit down and make a scrutiny of the potential evidence that they want to tender and see if it is relevant or it will assist the committee in doing its work. So we support it, Chair, under that qualification. Thank you.
And the elasticity of it may be that another witness outside of Mkhwanazi may also come and mention others. Is that the same understanding?
Yes, Chair.
That is the ripple effect of what you are saying?
Yes, Chair.
Okay. Okay. The DA?
Thank you, Chair. We don't necessarily have a issue with it. The problem is, we have to broaden the scope. And what General Mkhwanazi spoke about was more in depth of corruption and police conduct. So the additions that that we've made there, expand the scope beyond political interference to cover systemic corruption, bribery and abuse within SAPS and other justice institutions. And given his allegations of widespread infiltration and unethical conduct, ignoring financial corruption and misconduct would undermine the credibility of this chair. So we have to make sure we include that. And then we must ensure that Parliament addresses both executive interference and internal rot in the in the SAPS. Thank you, Chair.
Honorable members, you are exhausted now.
What do you mean, Chair?
Yeah, you are exhausted, honorable member. I
No,
wanted
our hands are up. How can we be exhausted when our hands are up?
I wanted the DA to comment on the proposal that has been made by the ANC exactly the same way that the MKP has commented.
Okay, if I may come in, I did say that we don't fundamentally have an issue with it. However, we cannot only say that we're going to base everything on one person because other information is going to come out. So perhaps we should change the wording of the sentence. Thank you.
What is your proposal? What do you propose the sentence? How can it be written?
The evidence of Lieutenant General Nhlanhla Mkhwanazi and any other submissions before the committee shall be used as the basis to establish the approach the committee will take on the appropriate witnesses to be invited.
Oh, okay. The next party to speak is the EFF.
We don't agree with this sentence because it's not saying exactly what you said when you are trying to interpret what is being said. It was effectively limiting us. And you, in a way, tried to rescue the situation by saying no one will be left out. So you need a complete rewriting of that sentence so that when we leave, we are all of a similar understanding. So if the understanding is that we call Lieutenant General Nhlanhla because he's the first one to say these things, that will not be correct. Because the first person who exposes the rot in the NPA is Batoi. She said that in Parliament. And then she was made to withdraw. And we were told that it was overusage of language. So there are so many other people that can be called and who can come and share a lot of light. So I only became comfortable once you tried to, clean it up in a way. But as is now, it's very dangerous. And we're going to be told we agree to it. We don't agree with this. It must be changed.
Are you done? And maybe let me greet you and welcome you, Honorable Malem. Are you done?
I'm done. Yeah.
Okay.
I've
Thank
been
you so
here.
much.
I started with.
Your line is breaking.
Chair?
Your line was interrupted.
No, I was saying I've been here. I started
Okay.
with the meeting.
No, thank you so much.
We're actually in the same office with Matthias. At some point, she was even using my phone. I don't know who this one was talking about consultations. He's talking about what?
No, it's okay. It's okay. Can we move to the IFP?
Yes, Chair. I think the formulation as it actually stands, it presupposes that we would like to confine ourselves to General Mkhwanazi, but I also would like to support a reformulation of this presentation to actually make it clear that we are actually not confining ourselves to Lieutenant General Mkhwanazi, notwithstanding the fact that he actually is the one who started the whole thing.
Okay, Honorable Mnango, thank you so much. The Patriotic Alliance.
Honorable Chair, I must express firstly my dissatisfaction with the consistency in your approach to how we deal with matters. What we have now is contributions and inputs around the formulation and the wording used of the submission by the ANC. You advised me earlier that we will not deal with the structure and the wording used. We must deal with the substance of the input. And you haven't told anyone the same that you've told me. I would just want to register that. But my contribution is when dealing with the substance of what the submission says, the substance of it does not restrict, it does not restrict any appropriate witnesses from being invited. But it does say that because this whole ad hoc committee, this whole process is directed and has started by what Lieutenant General Nhlanhla Mkhwanazi has said. So therefore, it's only right that General Mkhwanazi and what he puts before the committee serves as the basis, the launch pad of how we're going to approach appropriate witnesses that will be invited, linked to what General Mkhwanazi has said and will be saying. That doesn't sound restrictive to me. So in the substance of the submission, we support, Chair. The wording can be dealt with, but you advise that we shouldn't deal with wording and grammar and structure. But now it seems like we're going that direction. Please remain consistent, Chair, and let's stick to the substance of the submission. Thank you.
Honorable James.
Thank you so much, Chair. Looking at my notes, initially we had rejected the submission because it was too vague. But after listening to the explanation, it is more acceptable that it is purely for General Mkhwanazi to be the first witness with his evidence. But it is the wording that leaves a little bit too much to be interpreted. But then also, Chair, after having listened to Honorable Malema now, what General Mkhwanazi has said and mentioned was not new to South Africans. It is not like Honorable Saul said, the launch pad. South Africans has known about the corruption that has been happening in SAPS. I think what was shocking to South Africans was the approach and the precedence in terms of not following protocol and in terms of just having a media briefing. That is what was new to South Africans. So I think that this statement, the submission, needs to be, we agree with it, but I think it needs to be reworded so that it doesn't leave too much to be interpreted. Thank you.
Chairperson, just for clarity, please, on the statement that I've made so that there's no confusion. When I used the word launch pad, I did not mean that it was the first time that these things comes about. What I meant by launch pad is to use it synonymous with the word basis. It's the starting point in terms of what the committee will deal with regard to the evidence and the allegations. Not that it was the very first time that it came about. So just for clarity there, Chair. Thank you.
Okay, can I give to the ANC to reply?
No, thanks, Chair. We look, we're of the view that the meeting agrees with the substance, and maybe just to make it much more clearer, the intended message here is that the first witness has to be Lieutenant General Nhlanhla Mkhwanazi. And subsequent to him, the committee will determine who has to follow on the basis of the information established following the presentation by Mr. Mkhwanazi. So that is essentially the point that we're making. What we don't dispute, and I think nobody dispute the fact that allegations of corruption of one form or another have been spoken about by many people, even beyond Batoi. But the basis upon which we were set up as an ad hoc committee was because of what Mr. Mkhwanazi said on that day in July. So that is the reason why it's only logical, in our view, that the point of departure must be to invite him. After him, we can invite anyone else, or we can allow anyone else that invites themselves to us. But we can't start from anywhere else except with the person who is the initiator, who is the reasons. For instance, he is the main reasons why we exist as the ad hoc committee. So that was the thrust of what we may have not worded it nicely to accommodate the concerns that honorable members have raised. But I hope that in the clarification we're providing, it becomes much more easier what we intended to communicate about this paragraph. Thanks, Chair.
Chair.
The information that Honorable Mkhwanazi presents before the committee and the witnesses that come after him lay a basis for the committee to determine who can be invited. Is that what you are saying, Chief Whip?
Yes.
Okay. Honorable members, can I check
Chair.
if there is any other speaker
Chair.
who still wants to comment?
Yes, I'm here.
Honorable
Chair.
Malem.
Yes. Why are you not writing what you are saying down? Because we can only trust it when it's written down. We don't want to hear stories as this committee proceed that no, you guys had a misunderstanding. Why are you not simply writing it down the way you have written this one with all of these inputs made, restructure it so that you get all of us moving in the same direction? Why is it difficult to write it down?
No, Honorable Malema, there is nothing difficult. You know, we want to ascertain what the member is saying and concretize it after we were certain that what is going into the record is exactly what he said. And I think the Honorable Member Nduli has now confirmed that Lieutenant General Mkhwanazi and any other witness that will come after him, whatever information or evidence they deposit before the committee will lay a basis for the committee to determine who will be the next witnesses to be invited.
Exactly. Why is that not written down?
No, it's okay. I mean, for as long as we agree on this one, it will be put on the committee record, like we did with the previous decisions that we have taken on preceding items. So, Andile. Hello, Andile.
Yes, Chairperson.
You can confirm that you have that on record.
Yeah, Bonani is described, Chairperson. But look, I can hear what the members are saying. Thanks.
Okay. Is the Honorable Skosana, your hand was up. Are you still there?
Chair, I'm still here. In fact, I've raised my hand some time ago, but I just wanted to say, I wanted to find out, because it looks like we only have Andy today here. Is the chief legal advice, because I saw whether it's her name, I'm not sure. Is the chief legal advice in here?
Honorable Skosana, do you have any input to make on on the decision that we are about to take now?
No, I'm fine. I'm fine on that, Chair. My only worry is this one, which I've raised. Hence, I was raising my hand long ago. It was not about this anyway. Hence, I would have asked, because I'm saying Andile is the only person who's responding to these matters.
Honorable
So I was
members,
just asking. Yeah. Thank you.
Let me reiterate substantively. We agree that Honorable Mkhwanazi is the first witness that we are going to invite before the committee. In his presentation, Honorable Mkhwanazi may mention matters or names of people that may expand the list that we have. And then there are also witnesses that are going to come before this committee after Lieutenant Mkhwanazi would have made a presentation. Equally, the matters that they raise, including the names of people that they may mention, will lay a basis for the committee to determine how those people are invited to appear before it. I see there are two hands here from MKP, Honorable Shongwe and Honorable Skosana, and Honorable Nomvalo as well.
Yes, Chair. Thank you, Chair. Just a quick one, Chair. It's Honorable Shongwe. I just want clarity on this matter of legal representatives. Just for standard practice, are we going to have one person all the time, or are they going to attend our committees in regard to this matter? Because this matter is very sensitive, and you know the issue of legal issues in this committee, that we really need them. So I just want to know, are they going to attend
Which one is that? Which one is that? Honorable Shongwe?
Yes, sir, it's Honorable Shongwe. Thank you.
Yeah, which matter are you talking on?
No, I was talking on what Honorable Skosana was asking about say that he sees, we only see Andile here. So I'm asking, in going forward, are we also going to see Andile only from the legal, or going to have other people? Sorry to interject on your iteration on the other things.
Okay, let me hear. Skosana, your hand is up again.
Chair, my hair was up because I hear you say now that we have a list. So I'm not sure which list we are talking about. After Mkhwanazi, because we have the list. So I wanted to find out which list are you talking
about. No. What I'm saying is that Honorable Mkhwanazi, after presenting before the committee, obviously there are people who are going to come after him, who would be witnesses determined from the presentation that he would have made. And then I'm saying that those witnesses, whatever they will be saying before us as a committee, if it requires, or if they introduce new matters which would not have been introduced from the onset, or they mention new names of people who would not have been mentioned before, such people may be invited as the committee pleases.
Chair, because I'm still on the floor, I'm saying, you said we have the list. Hence, I'm asking that. Maybe you've made a mistake. Because that's your exact way. I'm quoting you. You said, after Mkhwanazi, we have the list. Hence, I'm asking the question, do we have the list? Which list are you talking about?
Which list?
Yes, Chair. It's yourself who said so. It's not me.
No.
If you said after, I'll understand that. But you said we have the list. That's your word, Chair. You might have made a mistake. Yes. Thank you, Chair.
Chair?
Chair.
Hey, you are too far. We can hear you, but very far.
Oh, Chair.
Hello?
You can hear me now.
Yes,
No,
I can.
No, the chair is far.
Can you hear me? Can you
No,
hear
I
me?
can hear you
Honorable?
very well. I can
We
hear
can
you
hear
very
you
well.
now, Chair, yes.
Yes, yes. Let me check with Honorable Honorable Skosana. Are you done?
Yes, Chair. I mean, for me, I was correcting you, Chair, because the way you put it is like already we have the list. Hence, I was saying to you, maybe you made a mistake. If you said after Mkhwanazi, we will have the list, yes, Alana, but you said after Mkhwanazi, we have the list.
No, we don't have the list, Honorable.
Thank you, Chair.
Honorable.
Thank
you.
you, Chair.
Honorable Nomvalo.
Yeah,
No,
thank you, Chair.
Oh, sorry.
No, thank you, Chair. Chair, I don't know, man. I thought I'm following you, but now, again, I'm getting confused because the first interpretation and correction that you made after I made my submission left me with satisfaction. But now, Chair, when you say Honorable Mkhwanazi will come and out of his testimony, if there are names that come out, then they will be invited to the committee. And if such people mention other people, then they will be invited. That goes back to what we were concerned about, to say you want to make General Mkhwanazi the only basis of this committee because all those names will be flowing from his testimony. Chair, I think what we must include here is that the committee should not be precluded from sitting down from time to time and identify potential and relevant witnesses that are going to assist the investigation, because some people will not necessarily come from or from Mkhwanazi's testimony, and they would not be coming necessarily from a testimony that has been made by people who were mentioned by General Mkhwanazi. Some will be coming voluntarily to the committee through different committee members, and some will come from an analysis that we make as a committee when we analyze different testimonies and say, even though they were not mentioned, but they are still relevant to the committee. So the explanation that you have just given, lastly, Chair, I think is giving more confusion. I thought we were on the same page, but seemingly now we are far apart from each other.
No, Honorable Nomval, you are the one who is ahead of me. You are moving the cart before the horse. You know, honorable members, when we started here, we took an approach that says we rotate inputs between the parties. We will give the party a chance to make its input. And the ANC has made an input on the scope. Is what we are debating. After the ANC, we will go to the DA. We will come to the MKP. We will go to the EFF. If there is anything that you want to say, you are going to make that input and the meeting will accept it. So I don't know if we want Honorable Nduli to say, because I had thought that we have agreed with the substance of what Honorable Nduli has said, and to say this is how it must be recoined and read into the record of the meeting. And so if there is going to be another member or another party that says the committee may also invite any other person it deems fit, that is not wrong. Do you understand me, Honorable Nomval? We are dealing with the scope here. So the scope does not end with what the ANC is suggesting. Is it very clear? Honorable Nomval, are you still there? Okay. I'm going to take it that we have rounded the comments on what Honorable Ntuli has suggested, and then we will rewrite the input the way it has been refined, that it will include any other witness that would still come, any other person as a witness emanating from any evidence that would have been mentioned by General Mkhwanazi and witnesses that would have come after him. Can I then move, Honorable?
Sorry, I lost the meeting.
Hello, Honorable Nomvala.
Yes, Chairperson.
Yes, I was addressing the matter that you have raised to say you are ahead of us in the meeting because we were still coming. We were dealing with an input that the ANC has suggested, and the scope of the committee, or the scope in the terms of reference, does not end with the inputs of the ANC. We have adopted a rotational approach in this meeting. So, for instance, if you, as a member of the committee, want to suggest, and I think it is there in the scope to say the committee may invite any other witness before it. This was just an input, a proposal that the ANC has made for addition in the terms of reference. And you have agreed with that proposal. But that does not preclude the fact that the committee may still invite any other witness before it.
If that is the approach, Chair, I agree.
Not if, that is the approach.
No, I'm saying I agree, Chair. We don't differ if that is the approach.
Yes.
Yeah.
But I want to satisfy myself that you understand. Remember, we released the draft terms of reference, and in the draft terms of reference, the initial draft provides for the committee to invite any other person that it deems fit. And so now the ANC has proposed an addition. And that is the addition that we were dealing with. And that is why I'm saying that even after the ANC has made an addition, it does not mean, the scope does not end with what the ANC says. The other parties are also given a chance to speak on the scope, and their proposals will also be debated in the rotational approach that we have taken.
Chair.
Agreed.
Chair.
Honorable Malema.
I thought we were going to finish this thing today. Then we agree about how are we starting to roll. So it looks like you're creating an impression that there will be a stand down today and then we'll come on a particular day to come and finalize it once everything else is integrated.
No, that is not the approach that we are taking. But what we should do is to make sure that every member of the committee has a proper understanding of what we are agreeing to. Yes. The reason why we take the approach that we are taking, where we allow every member to speak, is to make sure that members are satisfied that they understand what they exactly agree to.
Am I allowed to suggest something on that paragraph?
It's very tedious and laborious. Yes, we will come to you because now the next party is the MKP, which must make
on the same ANC input.
No, with the ANC input, we were done because we have agreed that it must be refined, and the chief whip has acceded to that to say that the inputs that have been made by members are accepted.
Okay, so you'll write it and then send it to us.
Yeah, it will be in the terms of reference. Yeah, the terms of reference will still be made available to members after this meeting, okay, including all those other matters that we agreed on since this morning.
All right. Okay, yeah. Thank you.
Can we then move to the MKP?
Please flight our input, Chair.
Andile?
It's not me, Chairperson, who was driving.
No, it's fine. When I call you, I'm essentially calling the person who must fly.
It's the Secretariat.
Yeah, we are on item for Honorable Nomval. I just want to hear if you have any motivation to make for your inputs, or you are satisfied with those inputs. There are no issues from the legal team on your submissions.
No, Chairperson, it's a reflection of what we submitted. It's a pure reflection of what we submitted. So there's no further addition.
Oh, okay. Then let's take the rotational approach and hear the comments of the parties on your submission, starting with the ANC.
No, thanks, Chair. Chair, I see we're dealing with the MKP. I'm fine. Let's do that. But we had not exhausted our comments on the DA, but we can tolerate that we start with the MK party where we may want to comment. Now, on the first issue where it says assess any threat, intimidation, reprisal directed at potential or actual witnesses, whistleblowers, and their association in relation to the allegation. Well, I think we need clarity more than disagreeing here, Chair, because our own understanding is that the assessment of any threat in South Africa is the responsibility of the police service. Now, when the proposal is that as a committee, part of what we should do is to assess any threats, any intimidation. We would like to get clarification what is meant by that. Is the committee going to have to hire a capacity that would discharge that responsibility, or what we mean by that? Because as a committee, we were here now, we don't have a capacity to do an assessment of the threat as well as intimidation. So that is our difficulty in either taking a position of agreeing or disagreeing, because we are not very clear what kind of capacity will be required as envisaged by the MK party on this matter, and how will it be utilized at the disposal of the portfolio of the ad hoc committee. So it's more of a clarification that we need on that one. The second one, Chair, on the same, because there's just 3 or 4 paragraphs that the MK party has contributed under 4.9. The second one talks about established protocols for handling, redaction, and secure storage of classified sensitive material to avoid prejudice to ongoing cases. I would imagine that this matter has been dealt with in the earlier discussion that we have. I hope it's covered there. If it's not covered there, we will also be very interested to understand what is meant by, if it's not covered by the earlier discussion we had about protocol on classified information and classified and sensitive information. We would like to get clarity if it's not covered there, and maybe something else that is being proposed here. The last one we wish to comment on, well, the other ones are there's no major issue there, because some of the, for instance, they scrutinize inter-agents coordination among SAPs, criminal intelligence, IDEC and NPA, all of those ones. We believe that is going to be a deduction that is made subject to the evidence presented before the committee. So we don't want to have any issue with that, because whether it's there or not there, the conclusion should still lead us into that kind of information. The last one on the MKP submission, Chair, has to do with the last sentence. Review the legality and reasonableness of directives such as the disbandment of the political killing task team or moratoria on post assessing them for that one. Now, the question that arises there for us, Chair, is that we are being asked to determine rationality and reasonableness of the disbandment of the political killing task team, which is obviously, I would imagine, is going to arise from the presented evidence. Our view is that you can live with this sentence or you can remove it, because what will ultimately become findings and recommendations will inevitably, among others, respond to the issue that is raised on that last sentence. So that those are the comments we wish to make. It's not areas where we say we've got to take them out, but it's areas that, in our view, we can live with or without, given the fact that the potential conclusion of our work is going to have to address those issues. But the one where we really would like to get a clarification, Chair, is the first one. What kind of capability, in the opinion of the MK Party, we should have as this committee in order to determine threats and intimidation, or to assess any threats as well as intimidation? Thanks.
Okay, can we have the MKP clarifying that aspect?
Chair, do you hear me? Chair?
Yes, Honorable Skosana,
do you hear me?
We can hear you.
On this matter, because I've got a problem. My phone is giving me trouble on it. In fact, not the phone. It's a network problem. I hope you still hear me very well.
Yes, we can hear you, Honorable Skosana.
Yeah, first shame. I didn't want to go to that matter now, but I have to. Let me tell you, Chair, already there's people who are being threatened, whistleblowers who are being kept somewhere, but they are being threatened. That's number one. Some of them are being killed. I don't want to make examples here, but I can. I can substantiate that. Why as MK Party we put that clause? Myself as well. Already there's threats, Chair. But I don't want us to go there, because I can protect myself. I'm not sure about other people, whether they'll be able to protect themselves. For being in that committee as well, with being at SCOPA, being at the Police Portfolio Committee, there's already, I think one of my colleague, Nhlanhla, said it one day in the committee, on the other committee. But that, why it's so important? Remember, we'll be dealing with a very sensitive issues there. Mkhwanazi himself is threatened, the general himself. Now, I'm not saying the other committee we have powers, but we can discuss these matters to see how can we help those who will be threatened, for them to give us the facts. The corruption, as you know, 121 been removed. And that alone tells you the of them are going to be talking about in this committee. Hence, we've put that, some of the witnesses would like perhaps to go on camera. Not in public. Because we are going to deal with sensitive matters of national interest, of national security. I think let me leave it there. But as the chief whip said, that we can live with that. But I think if you want me to go on and on, I can go on and on with this matter. But it's very important that we don't lose that sense that people are going to be intimidated. Like I've made an example by me. Thank you,
Yeah.
Chair.
No. We agree with you on that matter, Honorable Skhosana. Maybe what you should say is, if there is a way the committee can help to rephrase the proposal, please help us. Is that what you are saying? Honorable Skhosana.
I'm saying, is the ANC chief whip who had the problem with that? For us as MK party, that input has to remain as it is.
Yes, but the what is sticky here is that the matter must be clarified to say, if we put it in our terms of reference like this, how are we going to do it?
We must come as a committee to devise means. It can't be me alone. I can, if you want me to do that alone, I can put conditions. But it's not fair. This is not my committee. It's the committee of all of us. I've put that, as I said, as I've explained here, that there's threat against me.
Okay, no, it's fine. Let me go back to, because the chief whip sought clarity on this one. Let me go back to the comment of the parties. Chief whip, you had the comment of the response of the MKP on the matter you have raised.
Yes, Chair. No. I perfectly understand the concern. Let me just say what I understand Honorable Skhosana to be saying is that there would be people, including himself, and maybe those that may want to appear before the committee, who, out of fear of their own lives, might have a difficulty to appear and be seen by the public. And the committee will have to apply its mind on how, within the available legal means, the evidence of those people must still be sourced so that the committee's work is not disadvantaged. Now, if that is the overall thrust of what the MK party means on this matter, I'm with them. But when you say in the scope of your work, remember, this is not a paragraph in isolation. It's under the subheading, scope of my work. If you say in the scope of your work, I'm going to do an assessment of threat, I'm going to do an assessment, the document has just disappeared on our screen. I'm going to do an assessment of any threat and intimidation. You then have to say, the clarification I wanted was, what exactly do we need as a committee in order to discharge that responsibility? But if the context is what I've understood, which I've just mentioned to be what Skhosana is saying, we can reword the paragraph to address the concerns that he's raising, not to give us the authority, which I think would require additional assistance, because this is the work of the police to do the threat analysis and intimidation. That was the point I was making, Chair. Otherwise, I'm not opposed to a rewording that may accommodate witnesses who are willing to appear before us, but under certain conditions in order to conceal their identity for security reasons. Thanks.
Okay. Can I then move to hear what the DA is saying on the submission of the MKP?
Chair, sorry, Honourable Chair, we don't have any opposition to it for now. We will say if something does come up.
Okay. The EFF?
Chair, I don't think we have anything against it. It is properly capturing what needs to be captured, and I don't see why the chief whip will have a problem with that kind of wording. For every committee, you must be concerned about the security of your people, and from time to time, you ought to assess if there is any threat thereof, including that of witnesses. It's important that we make it our duty, but we know that we may not have the tools. So we are able to say, but we looked at this thing and we realize it's becoming a problem for us. And then we can go to relevant authorities. So many things we're going to be doing, so many things will not have power over them. We'll still have to refer to relevant authorities. So I think the spirit and the letter of this MK submission is acceptable. Thank you, Chair.
And then, Honorable Malema, you agree that writing it into the terms of reference, it may need to be refined because it may not be us doing that assessment.
Go and redesign it and then mess it up. We won't keep quiet. We're going to have a problem. If it comes here and it's not in the spirit, we see it now here, we'll have a problem. Because there's nothing wrong with it. I don't, even within a scope, I don't see anything wrong with it. But you guys have got the power to want to change that, make it look good and all of that. As long as the spirit is still there, we're fine.
Yeah. Remember, the terms of reference become a legal document that guide us. It does not have to be ambiguous.
Yes.
And that is why we say, for the purpose of certainty, it must be written in such a way that it essentially carries, like you say, the spirit of the submission, but without being onerous on our part as the committee.
Let's go, Chair.
The PA.
Is it not IFP before us, Chair?
Oh, yeah, the IFP. I'm sorry. Honorable Mkhwanazi. The PA.
Chair, we agree with the substance of the statement. Thank you. Witnesses.
The action. Okay, Honorable Sals.
Witnesses needs to be protected and so on. And we understand the context to say that we are limited in our ability as the committee to assess any threats. So we must make use of the agencies that are able to and are empowered to do so. And I hear from the submissions that the statement would be reworked so that the wording includes who does the assessment, because the committee, we can decide already. We don't need to wait for later to determine whether we have the tools or not. We know we don't have the tools to assess any threats. So the wording will be changed and then brought back to us. So we agree with the substance. Thank you, Chair.
Thank you so much. The Action SA.
Thank you so much, Chair. Now, looking at the history of how South Africa has left key witnesses in important cases out to dry, this is a very, very important submission. So it is important that we find ways and it gets redefined. But as Action SA, we fully support it. Thank you.
MKP, any comment? I think I've rotated all the parties. Can I check if you have any reply?
Yeah, thank you very much, Chair. Chair, we think there's nothing much to say because the majority of members are saying they agree with the addition that we're proposing. And I think, Chair, it's important to put an emphasis to a point that it will be very insensitive of us as a committee to ignore and overlook threats, concerns which will be raised to the committee by either members of the committee or members of the public, because the nature of the investigations that we're going to deal with or that we're dealing with are sensitive, and it's inevitable that from time to time there will be security threats and they will be raised and submitted to this committee. So we can't, being members of parliament, when we come across such, say, no, we don't have competency to do so, go to the police. We will have to, from time to time, assist members. Maybe we can even do it through an oversight responsibility of saying the police must do it and oversee the process so that there will be no one who will be cheated on during the process. So, Chairperson, I think it was raised in that spirit. We know that the chief whip of the ANC has appetite of disputing everything we're raising here. Thank you very much.
It's for the purpose of clarity in the terms of reference. I think the spirit within which the matter has been raised is unanimously accepted. There is nobody who has qualms with that. The only issue is with the manner in which the submission has been written, because it has been written in such a way that on appearance, because I must also be careful and guarded on the word that I use, on appearance is the committee that has to do that, but it has emerged from the deliberations that we all of us appreciate that the committee will not have the capacity and the technical know-how to execute such matters. So it is understood, honorable members, and I don't think that it's a problem. I have noticed that we enjoy sniping at each other, but anyway, let's move forward. The next party is the DA. DA, do you have any motivation or comment that you want to make on your submissions on item 4?
Thank you, Chairperson. We have a few. Would you like me to do them all in one go?
Yes, you have submitted. You don't have to regurgitate, just to check if you want to motivate them or you are fine with them captured on the draft terms.
We're fine with them captured like they are, Chair. I just want to say that we're obviously motivating to ensure that corruption and police misconduct is addressed. We have to evaluate the Provincial Killings Task Team effectiveness to make sure why it was disbanded. And I mean that it is quite controversial. Without assessing the PKTT's effectiveness, we cannot decide whether its disbandment was justified or not. Oversight mechanisms and leadership failures. Obviously, there seems to be a bit of a paralysis in the system, and we would like to know who the enablers of this corruption are, which I'm sure everybody on this platform would like to know. And we need to make sure that there's a reform. And then, Chair, obviously the procurement irregularities in the 360 million rand healthcare contract. It's very important to put that in because it links systemic corruption to specific cases, as alluded to by the General, especially with the 360 million rand healthcare of Babita Deokaran, which is important, Chair. And then 4.8 prosecutorial conduct. Allegations implicate not just SAPs, but prosecutors and effective figures. So we have to make sure that we put that in. And then public trust Chair. We have to make sure that we restore the public trust. That is my submission. Thank you.
Okay, let me then take the comments of the parties on your submission, the ANC.
No, thanks, Chair. We just wish to comment on two areas. The first one is an addition of the DA under paragraph 4.5. No, 4 point, not 4.5, 4. Just hold on for me. I think my notes are DA 4 point. Yeah, DA 4.1. 4.1. If you look at the DA's submission under 4.1, if you go up on the scope, not where you are. If you go up on the scope, it's before the comments that we're dealing with on the MK submission. You've left it now. It's the one that says DA 12, that one, yes. I want to start off there, Chair. It says allegations of corruption, semicolon, any claim made by Provincial Commissioner Mkhwanazi regarding financial corruption, bribery, misuse of public resources within SAPS or any other relevant institution. We have no problem with this being part of the areas to be investigated, but we have a problem when it's appropriated to Mkhwanazi. Because Mkhwanazi did not make any allegations about bribery, misuse of funds. It might have been implicit in his statement, but he didn't make it like that. But if the DA proposes that we should look at that as well, it's no problem. But let's not appropriate it to Mkhwanazi, because we all listen to Mkhwanazi. So now we can't distort him on our own terms of references. That is the first point that we would like to make. The second point that we would like to make on the DA, if you go down now, on the one about the procurement and 360 million, that big figure that has been mentioned there. The only issue we would like to raise on this matter is that we are now putting in a name of a person. For instance, we're saying with reference to the concerns previously flagged by Babita. Now, Mkhwanazi did not mention anything that has to do with Babita as a person. It may very well be that, Chair, in the course of our investigation or as we listen to evidence presented before the committee, Babita and other people whose names are not mentioned here emerges as areas of interest and focus for us. We will support that we must deal with those issues. But when we flag it and we choose one name out of many other names that I suppose we're going to be having to deal with before the committee, and we choose a specific name and say as flagged by so and so. I want to give an example why I think we may have to remove the name but leave the rest of what the sentence is saying. The Honorable Malima here was saying the NPA director, Batoy, at some point also made certain statements relating to corruption in one of the state institutions. But he did not propose that therefore we must mention her name. But my understanding is that in the course of our work, we may have to deal with either through the same Batoy or somebody else, statements relating to what Batoy had said in Parliament or wherever she said it. So, but my view is that if we put the name of a person as flagged by so and so, how many people have flagged issues that we're going to have to deal with? I think let's deal with the substance and not deal with the flag, because Mkhwanazi did not tell the people of South Africa that part of the concerns that he's raising are as a consequence of what was said by Babita. Of course, I'm sure we are all familiar with the fact that there were 6 people who were accused of that, and I think if I'm not mistaken, those people were convicted for the murder of Babita. So why should, in our terms of references, cite her name in particular? It's not very clear to me. And I would suggest that we leave the sentence as it is in terms of other issues, but that name be excluded for the reasons that I'm advancing, if the committee agrees. Thanks, Chair.
Thank you so much, Honorable Ntuli. The MKP.
Thank you very much, Chair. Chair, we have no issue with the submission by the DA.
Okay, the EFF.
The DA submission is better with those names must stay.
The IFP. The PA.
Chairperson, we have no problem with the submissions. 4.6 perhaps should include, but not limited to, because if it's under scope and what is mentioned would then give the impression that we will just deal with that procurement, possible procurement irregularity in SEPs, yet there are others. So it mustn't look like it's limited to, but we don't see any problem with mentioning, but maybe it should be added, not limited to. Thank you.
Okay, the HNSA.
We support the submission, Chair.
Okay. The submission. Okay. The DA. What is your reply?
Thank you, Chair. No, I just wanted to emphasize the reason for us adding that, but I think the majority agrees, so no need. Thank you, Chair.
Okay. The submission, your submission is going to be included, but the matters that do not emanate from the statements of Mkhwanazi should be stated that I mean, they should be separated from Mkhwanazi's statements, but they should stay in the terms of reference, as that is the wish of the majority of members in the committee, so that there must not be a misrepresentation of what Mkhwanazi has said. Can we then move to...
Sorry, Chair. Apologies, Chair. I did put up my hand again. May I quickly be recognized for 30 seconds?
Okay. It's fine,
Chair,
Honorable.
yeah, I just want to give clarity, Chair. I feel it is necessary. Chair, the reason for this is not just to flag specifically Babita Deokaran, but it's to also show the bigger link regarding this corruption. General Mkhwanazi specifically raised a 360 million rand SAPS healthcare contract, and the link with Mr. Kat Nhlanhla. And the reason why Babita Deokaran is specifically mentioned there is because she uncovered some links with regards to dodgy deals done with Mr. Nhlanhla and the Gauteng Health Department. So the reason is just there's a bigger threat out of the over 200 irregularities that she flagged. It actually links up or draws a much bigger detailed picture of significant alleged corruption. So that's the reason for that. It's not just a random whistleblower. There's something much bigger here. And some of the stakeholders that General Mkhwanazi mentioned are directly linked to some of the matters that she uncovered. And I don't think it was necessarily deliberately done that way. I just think it is an important part, and I think it will give this committee a lot of content to be able to work with. So I just wanted to give that as clarity, Chair. Thank you.
Yes, no, I agree with you, Honorable Cameron. What we are saying, and you are explaining it very well, that this is inferential. You are drawing an inference from what Honorable Mkhwanazi has said. And so in the terms of reference, it must not appear like he's the one who said that. We agree with the inclusion, but it must be written in such a way that anybody can understand that it's a decision that the committee made, that the matter must be included, not because it has been said by Mkhwanazi. Is that understood?
100%. Thank you, Chair.
Thank you so much. Let's then move to the submissions of the EFF.
Sorry, Honorable Chairperson, can I just get clarity on your summary, please? I'm trying to reconcile your summary around. Okay, the first point is understood, the one that you just explained to Honorable Cameron. On this issue of the possible procurement regularities, there was a suggestion that was made by Honorable Sauls, and I just want to ensure or get clarity whether it is then in the resolution of the meeting, where he was saying, and I think it would address the concerns raised by the ANC, where he is saying that let's not limit it only to this contract, and let's not only limit it to concerns previously raised by Bita Decoran. I'm saying that, Chair, because if you listen to what the Chief Whip had been saying, we were saying if you are going to mention people, given the fact that there are other more people, we can keep the name, but let's be very clear that it is expansive. So we're not trying to narrow it, but just to make sure that it covers all the concerns as they would arise during the course of the investigation. Thank you, Chair.
That is the spirit. It must be understood as such, that it covers a wide range.
Thank you very much, Chair.
The economic freedom fighters.
Chair.
Honorable Malema, we would like to check if you have any comment.
No, we're fine. It's well captured there.
Yes, your submission. Are you fine?
Yeah. Yes.
Okay, then let's take the rotation. ANC on the EFF submission.
Chair, I take it is the one that is that is under 4.8. Alleged failure, organ state, blah blah blah. Is that one?
Yes.
We are fine with that.
Let me leave it for them to confirm so that I don't misrepresent them.
No, my problem is that this person has put something, show comments or something on the screen.
The one I'm referring to, it should be under 4.8, Comrade Chair.
4.8.
Yes. 4.8, there's an insertion by the EFF, this one. Alleged failure of any organ of state or member of the executive to comply with legal obligations. That one.
It's also not on the screen.
It is.
No, it's on the screen is 4.7.
It is, Honorable Malem. Through you, Chair. It's even it's bolded now, red bolded.
Oh, okay. Yeah.
Yeah, EFF process in session. That is the one you were commenting on, Chief Whip. You are happy with it?
Yes, I was saying we support that proposal. If that is what we are, if we're at that point, that's one we support that one. Agreed.
Okay.
Agreed, Chair.
Yeah, EFF has confirmed that you are spot on. Can we hear the comment of the MKP?
Agreed, Chair.
DA?
Agreed, Chair.
IFP? PA.
Agreed, Chair.
Action SA.
Agreed, Chair.
Any reply from the EFF? There were no statements made.
Covered. Thank you, Chair.
Thank you so much. Can we move to the next party, which will be the IFP? Do we have a submission from the IFP, Andile?
No, not that I know of. No,
Okay. PA, do we have a submission?
No submission, Chair.
Thank you so much. Action SA, submission?
None, Chair.
Thank you so much. And then I assume that should be the end of our deliberations on item 4, unless if there is any other matter outstanding which would have left out. Can I see?
No, Chair, the Action SA is confusing us because
No.
unless they don't understand what we're asking for, because there is a submission they've made on the screen and you are asking them if there's a submission and they say no. Now we don't know how we should proceed because we would like clarification on that submission. That is 4.9. Under 4.9, you've got the DA, you've got the Action SA.
Yes,
Chair.
yes. The
Chair,
Action SA is
yes, Chair.
written in a orange.
Chair, earlier on when you spoke, you said that we conclude now on section 4. And I was going through and thinking, okay, are you saying the entire section or a specific point? And that's where the confusion came in.
Okay, no, we pardon you for that misunderstanding, but
Okay.
but that is the understanding that cuts across the parties.
All right. So on section 4.9 specifically, Action SA has made a submission there with regards to addressing the involvement of MPs as alleged by General Mkhwanazi in scope of the inquiry. In light of the commission of the inquiry established by the President conducting its own process concerning the same allegations within its terms of reference, it is important that this committee addresses the omission of the allegations made by General Mkhwanazi, specifically his reference to members, plural, of parliament allegedly linked to the criminal syndicates.
Yeah, maybe you need to explain what that means so that we have the same understanding with you.
I think we need to add on to 4.9 simply says allegations against members of parliament. So we have broadened that, Chair, by making that submission.
Okay. It's
Thank
fine.
you.
Let's. So you have said what you wanted to say adequately.
Yes, thank you, Chair. And it states there.
Okay. Can we hear the comments of the parties? ANC.
Chair, I was going to propose that we leave the formulation done by the DA above this one. The one that says allegations against all implicated members of parliament and the classified information released to them. My view is that suffices to address the issues relating to members of parliament. We are unable to understand what the intervention of the Action SA expands on, which is not covered by that. We think that DA one should be the one we support. Thanks.
So the two submissions are one.
Yes, Chair, they speak on one issue, but I think the Action SA one is more elaborate. But my sense is that
in different ways.
Yes, but my sense is that that should be covered by the proposed DA one above.
Okay, before we move to the next party, let me hear Action SA if they agree that the two proposals can be fused.
Definitely, Chair. It must merge with the F and Action SA paragraph.
Okay. Thank you so much.
Thanks.
Can we then go to the MKP? What is your comment on the submissions?
Yeah, we agree with what they are proposing as the solution, Chair.
Thank you so much.
Yeah.
EFF?
We agree, Chair.
IFP? PA?
We agree with the DA's version of 4.9, Chair. Thank you.
Or Action SA, you have spoken already, so can we?
Yes, Chair.
Yeah, can we then move to the next item? Where have you stopped, Andile?
Chairperson, whilst we are waiting for Andile, can you confirm whether IFP is still in the meeting? Because for several times now you've called upon them before us and there was no response.
When we started, we were with them. My assumption is that they are in the meeting.
I'm asking you to confirm, Chair.
They have not apologized that they were going to leave the meeting at some stage. But it's fine, we will confirm with them. Yes.
Yeah. I'm just trying to assist because every time you ask IFP, then they...
Okay, Honorable Sole, let me come back to the meeting. Andile, are we done with item 4? Or are there still matters outstanding at 4?
I think there are 3 proposals, Chairperson, and I think Bonani has cited them. And once we're done with them, then we should proceed to paragraph 5.
Yes, the ones in blue. Ne?
Correct, Chairperson.
Can I? This is the last on item 4. Can I hear the DA if they want to make a motivation?
Thank you, Chair. Chair, this is an addition that we'd like to make. A new section, legal and institutional reform considerations. The reason behind this, Chair, is because without a reform mandate, this inquiry just risks being yet another fact-finding exercise with no systemic change. So the section will ensure that the inquiry's findings lead to actionable reforms, restructuring of IPID, protecting of whistleblowers, insulating crime intelligence, and reforming procurement, Chair. And that is the reason why we have asked for the inclusion of this section. Thank you very much.
Okay. Comments, ANC?
Chair, I would like us to have a discussion. Firstly, let me say this is a new section altogether. The DA is making an intervention to create a new section. And I fully understand as the member is motivated, what has given rise to that position. But let me tell you what are my concerns about it. Right from the beginning, it says the committee must consider and make recommendations in the following areas: reform of SAP's internal disciplinary architecture, including the possible creation of an independent body to adjudicate or oversee misconduct proceedings. Establish a politically insulated crime intelligence command structure. Legal protections for whistleblowers within SAPs, and let me not read all of them. My difficulty here, Chairperson, is that now the DA is already making recommendations before we hear evidence. it may very well be that at the end of the evidence we're going to acquire, certain changes must be implemented with regard to the institutions they are pointing to. But it might not be the same kind of recommendations that we are made to adopt even before we hear the evidence. I was going to propose that we persuade the DA to keep this as their own private notes. When we've listened to everybody involved, including how they believe and feel about the various institutions of the state that they've mentioned here, we then have the DA making, as we will all do, proposals about what kind of changes and reforms are required to affect the various institutions. But I have a very serious difficulty, Chair, that even before we hear any kind of evidence, as a committee, we communicate a message to the public that we know what needs to be fixed. And then the people are going to ask the question, why are you still going to ask for evidence? Because we already have a set of recommendations about where the problem lies. So my sense is that the presentation of our work as part of the scope of our work in this following manner, it does create a problem for me in terms of what then becomes the legitimacy of our own recommendations. I wouldn't be opposed to anyone who has concerns about all these structures, crime intelligence and IP, but I don't think that we must make recommendations before we hear them or before we hear anyone who presents before us evidence from which we must depart to decide our position on each of these institutions. That is the only concern I have, Chair, is us agreeing on recommendations before we hear the evidence. Otherwise, I don't have a problem with them if we were at a stage where we've had the evidence. And the evidence tells us that there is a need for the restructuring of IPID to ensure full independence, because we've identified that IPID is not fully independent and that IPID is not insulated from political influence. Now, to adopt them in the current form, I don't even know what is meant by lack of independence in IPID and lack of and them not being insulated from political influence. And that is why I'm saying if this information was coming at the end, I would have understood. But at this point in time, I would like to suggest that the DA reconsider this kind of recommendations before we start our work. Thanks.
MKP.
Thank you very much, Chair. I'll try not to be long because. Am I audible?
Yes, now we can hear you.
Yes, I'll try not to be long, Chair, because I'm on the road. Chair, we don't have an issue with this. We just think that maybe to address the concerns that have been raised by the latter speaker, maybe we can just amend the wording by saying institutional reforms, that the committee must be empowered to make recommendations on institutional reforms where necessary. That is our submission, but we agree in principle with the submission made by the DA. Thank
you. Chair. Chair.
Honorable Skosana.
Yes, what can be perhaps be not be included? You know, if you remember well, I just want to make an example, and I hope I'm not going to touch other people. You know, we have that in this country that some people said somewhere wanted to create another body, a Chapter 9 institution, and that was rejected. You know, and as well here, I think the Chief Whip as well is correct to say we can't, before catch the horse, you know, we can't do that now before we sit as a committee and have recommendations. I think the wording itself that we must, then we don't need to have this committee. I think it's correct of saying that now, to say we can't have recommendation before the horse. In other words, it might be in good intention, but we have to deliberate these matters in the committee But I think as well, from what I'm seeing here, which is lighted, and as well, I was not even aware that we still have that latitude to add some inputs. Otherwise we will have others. But be that as it may, for me, I think it's premature for us to reach the conclusion, of having another body. And all these bodies are costly, and we are crying about the budget in this country.
Your input is sufficient, Honorable Skhosana.
Thank you, Chair. Thank you.
The EFF.
No, I think the ANC's input is correct. And instead of fighting with the DA, we need to persuade them not to proceed with this. This comes much later, because we shouldn't go into this inquiry with a predetermined outcome. And if people know that you have already written a judgment even before you hear a matter before you, that is not justice. So the best thing, let's go and listen. We might think we know, and we might think these are the possible outcomes after the hearing, only to find that things are different. So we must go with an open mind and listen to the facts and take decisions after. But to take recommendations now is really premature, and we'll appeal to the DA to withdraw them. Thanks, Chair.
Thank you so much, Honorable Member. Can we go to the IFP? The PA.
Chair, we've said from the beginning of this process, we've given a very clear caution to say, as a committee, we must not come across as having chosen a side before we've even started our investigation. I think the objective that's listed or recorded within the draft is clear, that we are going to investigate. And we are going to investigate the veracity, I love the words, extent, and implications. And this exercise will then inform the recommendations. So to do it now is to give the wrong impression that a side has been chosen. So we agree. So we agree with the submission as explained by the ANC. Thank you.
Okay, I was trying to check who is not muted, because there was a sound when you were. Okay, no, it's fine. I see all the mics are now muted. Can I move to the Action SA?
Thank you, Chair. No, I think the DA right here is a bit voorbewaar. They need to hold their horses. While their suggestion is noble, we haven't even concluded the committee's investigation, and they're already proposing reforms. I think that's a bit way ahead. So we reject that submission. Thank you.
Okay. We are reply DA.
Thank you, Chair. No, we respect the decision of the committee. I just want to say that the specific reform areas and why we wanted them to be included in the terms of reference from the outset is to ensure that they aren't somehow missed later on. I don't think the idea is to put them forward as recommendations right now. But it is always good to kind of understand where we are headed and what the bigger picture is. Remember, as we said earlier, and that's why this is exactly not choosing sides, but as Honourable James said earlier, we are all aware of a lot of the issues and institutional issues within the South African Police Service. And I think it's an opportunity for Parliament to assist in correcting some of those, and therefore it's important to indicate how we can assist in fixing some of those problems. So the idea is just to show that Parliament from the beginning has already identified the potential stakeholders that need to be held accountable. But we respect the decision of the committee, Chair, and appreciate the feedback.
Okay, thank you so much for your understanding, Honorable Cameron. So, Andile, that part, the last part that we have dealt with, will not be part of the terms of reference. For sure, the DA will come back when we deal with the structure of the report and make those suggestions and see if they are accepted. Honorable members, we have come to the end of item 4. And I'm going to suggest that we break for 30 minutes. It's now 4:15. So we will come back at 4:15. Can we break, please?
We agree, Chair. We've been sitting like this from 11 o'clock.
Yeah. I don't hear any dissenting voice. So it means the 30 minutes break is acceded to. Thank you so much. Let's come back at 4:15.
We can continue, Chair. Thank you.
You have not been you have not been in the meeting. Your phone was giving you a problem. You have just fixed it now, and then you say no, we can continue.
Angisakuzwa-ke mhlambe kuphuma mina. Bonani sakhona?
Can you please mute Noval?
Recording stopped. Recording in progress.
Honorable members, good afternoon once more. Can I check if all of us are back in the meeting? Okay. Andile. Andile, are you back? Can somebody flight item number 5 on the screen?
Chair, it is on the screen. I don't know if you can see it.
Yeah, I see it. Honorable Skosana.
Oh, whilst you were checking, Andile, I just wanted to find out because there was an issue which I've raised, and I'm not sure whether you've answered because
I'm back, sir.
The network comes, it breaks now and then. The issue of the chief legal advisor, maybe you responded on it. I'm not sure whether are we with her here or not. Thank you, Chair.
Okay.
Can I respond to that, Chair?
Yeah.
Yes, the chief legal advisor has been here with me, Chair, throughout this morning. Yes, she started here the meeting, which was about 10 minutes. So I think she left us for 10 minutes and came back. So no, Honorable Skosana, you must, yeah, the chief legal advisor is here.
Okay. Yeah. We are on item 5, Andile, and what is the impression of the legal team on the submissions made by the parties?
Yes, Chairperson, there's just one issue, and of course, the committee has already dealt with that. Because you will see that MK 8577 speaks about that provision shall be made for minority reports by members. And of course, Chairperson, we say in terms of Rule 1664A of the Assembly Rules, a committee may not submit a minority report. However, minority views may be captured in the main report. And I think one of the things, Chairperson, which last week the AFF also added was about the issue of legal aid in relation to legal representation. All we just want to caution, Chair, is the fact that legal aid is for the individuals, and of course they've got their own means test and so on. So if, for instance, you say Andile must go and ask for assistance from the legal aid board, that assessment will be made. They might say, look, given that you get paid X number of money, we feel that we can't offer assistance to you. Those are the only two, Chairperson, points that we want to. Thanks, Chairperson.
So we're left with the point of the legal aid because the other point we decided already.
Correct, Chairperson.
Okay, so then let's then go to the individual parties, starting with the ANC. ANC, your submissions on item 5. Any comment?
Yes, Chair, thank you very much. Chair, we're taking from the spirit of the inaugural meeting of the ad hoc committee that we must strive all we can to curb costs. Remember, there was a discussion when the chief whip of the ANC actually suggested that we must have some of our meetings in August in Gauteng. And there was a suggestion, I think it was from Honorable Malema, that even so, we must ensure that we utilize public venues so that we cap costs. So we propose, Chair, in that spirit that we cap costs with all that we can. So we propose that there must be a complete overhaul of 5.2. And that we must not utilize the services of external legal practitioners or whatever we may call it, but rather utilize the services of the parliamentary legal and constitutional services. So, Chair, we propose 5.2 to read as follows. That the committee shall utilize the services of legal counsel located in the Constitutional and Legal Services Office of the National Assembly in an advisory capacity to assist the committee to carry out its work, subject to adherence to the principles of transparency and public participation where necessary. So, Chair, we propose that we completely change the context of clause 5.2, we utilize the services of the parliamentary, legal and constitutional services instead of an external council. Thank you very much, Chair.
Thank you so much, Honorable Nhlanhla. Let's take comments, MKP, on the submission of the ANC.
Yeah, thank you very much, Chair. We
hear
want
me?
clarity.
Oh.
We want
sorry,
clarity.
sorry.
We want clarity, Chair, before we make a comment on this one from the ANC, that when they say we must utilize the internal legal team, then to what extent is it going to provide legal advices for us? I'm asking because in this same document, there is a proposal that we must outsource a legal person who is going to be the evidence leader and who from time to time will advise the committee on legal aspects. Now, we do not want to engage this from a wrong perspective. We want to come from the perspective that the ANC is advancing. So to what extent are they making this proposal, Chair, before we make our submission? Thank you.
Okay, ANC.
Thank you very much, Chair. You'll recall that we've got different forms of legal services that the committee work will require. And amongst those, Novolo is correct, that is leading evidence. And amongst those is providing legal opinions to assist the work of the committee. And in our view, that we've got a capable team in the parliamentary legal services that can perform all the work that is required in terms of legal services. So it's upon the chief legal advisor where we'll say, on this particular matter, we need on this particular aspect, we need a legal advice. Then there is a person they are going to dedicate themselves to ensure that evidence is led properly for the work of the ad hoc committee. So it's a team, Chair. It's not one person. They can perform both roles, of course, having been allocated that work by their leader. Thank you very much, Chair.
MKP.
Yeah, no, Chair. If it is raised in that context, then we completely and vehemently disagree with this proposal for various reasons, Chair, and namely, the internal legal team has demonstrated on numerous occasions, Chair, that they lack capacity to a certain extent. I don't want to go back. We have expressed our concerns here on the quality of the work that they give this committee. Number two, Chairperson, we need here an experienced and senior legal person with a demonstrable experience and skills, because the work that we are going because it can be even be taken to a court of law. The recommendations, for instance, if we make recommendations, they can be taken to a court of law for scrutiny, for judicial scrutiny. So we must never miss an opportunity of ensuring that the work that we do meets high quality standards, Chairperson. So, Chair, we really do not agree with this. We must look for a person who's going to advise the committee on a regular basis. We don't have confidence in the internal legal team. With the greatest respect, we are not undermining them, but it's them who are making us to arrive to that conclusion through some of the advices that they have tendered to this committee, and we arrived to a determination that they themselves need to be legally advised on some of the issues. So we don't want to be a joke here, a national joke, which does its work relying on wrong legal advices. We're not supporting this as the MK party. Thank you.
DA?
No, Chair. I'm still in the MK party.
Okay, of course, I know.
Yeah, Chair. I just want to say that as MK party, we want to make it very clear, like my colleagues has already articulated, our views about this issue of legal advice. You'll remember, Chair, that even in our courts, most judges in our high courts were drawn from attorneys profession and never argue in the high court where they preside over complex issues or complex matters. Hence, our stand when it comes to the legal service from Parliament, that with due respect, we are not undermining them like my colleague is saying. But remember, as I said, that we've seen that in other committees, in other judicial service commission, even in the High Court or courts for that matter, because even those who were advocates never practiced in the highest level of advocates. Some of them were junior attorneys when the time they applied for their job. So we don't even know in terms of what is the how do they get employed in Parliament. Hence, I'm doing an example in terms of judges, not undermining judges as well. But the reality is that even some of the judges in the High Court never argued in the High Court, where they are now judges themselves. Now this generalization, of the bench as well has compromised our judicial system. Hence, we have to make sure on this ad hoc committee that we must get things right from the word-go. I can tell you, we need somebody, or we need people who are highly experienced, and I can tell you, you can ask anyone, you can ask members who sit in the Judicial Service Committee. They will tell you about what I'm doing about. Hence, at this ad hoc committee, we must not compromise, because the judiciary itself attracts legal practitioners whose practices were never practice of a significant or on the highest level. Now, we need people seasoned a legal mind to make sure that errors will be made. It's natural, but not a school errors. Now, inverted commas, Chair, I'm not undermining anybody, but I'm saying to you, we need to make sure that we cover all the legal aspects, because some are going to take us to court. I think you, Chair.
The DA.
Yeah. No. Lastly, Chair. Chair. We're worried, Chair, that this admission has just been made without having done any skills audit within the legal advice team that is in Parliament. We're just advising people to do such a critical work without even doing a skills committee to check if they've ever done any job of this kind before, and without even motivating it with the experience they have and with the qualifications they have. You are just telling us that the parliamentary legal team must do this. We're really not taking that lightly, Chairperson. This is a very serious issue, and we must not start to play here by compromising the services that are tendered to this committee. We must be very serious, Chairperson. Thank you.
The DA.
Thank you, Chair. Chair, just briefly, from the DA side, we don't think that Parliament's own legal services can be expected to advise on allegations that, to a certain extent, they've even been, when General Mkhwanazi spoke, it implicated members of Parliament, ministers, whether it's staff or MPs, regardless. I think there's a certain conflict of interest. So we must also not, or just be cautious of misunderstanding the role of parliamentary legal services. External counsel, in my opinion, or in our opinion, is not there to represent witnesses, but to lead evidence and to advise the committee. Witnesses should be free to bring their own lawyers if they need so, and Parliament legal services cannot act for them. So I think that's important. Just in terms of credibility, Chair, The public confidence, I think, is critical with this whole process. I think all the members have reiterated this over and over. And I think it's important for us to, for that reason, pull in the relevant capacity from outside, because I honestly don't think that Parliament has the capacity at the moment to give the relevant skill set and attention to this matter. And then just in terms of potential expertise gap, I don't think that in terms of Parliament, we have senior counsel that can specifically say or definitely say that they can specialize in criminal law, organized crime, or police accountability for that matter. So it's important that we make sure we use the principle of having horses for courses, and that we don't just pass it on because it's the easier thing to do. And in terms of cost cutting, chances are that by the time we've completed terms of reference, we wouldn't even have time to go to Gauteng, but we will likely be able to save money on instead of flying all the parliamentary staff apart from the members, not even mentioning the members, to Gauteng. We'd likely be able to cover some of the legal costs if we were to appoint external counsel. So yeah, I think lastly, Chair, it's important that we understand that our task to a certain extent would be to consider evidence, and that it's important that Parliament's own lawyers could have a conflict of interest of some kind, because it serves some of the same officers that we would need to interrogate. Thank you, Chair.
The economic freedom fighters.
Thank you, Chair. The proposal that parliamentary legal services should serve as evidence leaders, the statement is deeply flawed. The credibility of this process requires independence, and parliamentary staff are structurally subjected to the authority of the Speaker and also the Chief Whip of the ANC. So the lack of institutional independency has already been demonstrated in the recent proceedings, such as the adoption of the appropriation bill, where rules were altered to suit the demands and the fears of the ANC. And furthermore, the parliamentary legal advisors, they have multiple competing responsibilities, and it's going to make it impossible for them to dedicate undivided attention to the work of the ad hoc committee. Allowing them to lead evidence would not only compromise impartiality, but it will also invite accusations of bias and undermine the integrity of the process. So the way forward here is to appoint an independent and a seasoned evidence leader whose sole responsibility for the duration of the committee's work is to guide the process with full impartiality. And this person must have prior experience, as some of the colleagues have mentioned here, of a similar nature, and must not be drawn into a parliament's internal administration. And in line with the principles of fairness and transparency, the committee should be allowed to make recommendations on suitable candidates, with the appointment process conducted through an established chain or supply chain rules, rather. And this is going to safeguard both the credibility and the independence of the committee's work. The argument of costs this is not where we need to be looking at cutting costs, and primarily because of the gravity and the implications of the matters that is before this committee. Chair, if there are resources available for that national dialogue, then Parliament must be equally ensured that we have adequate resources that are allocated here to be able to carry out our work effectively. This ad hoc committee is not inferior to the Commission of Inquiry, and its work must be supported at the same standard of professionalism and rigor. So no, we definitely are not supporting the ANC's input here. Thank you, Chair.
IFP. the PA.
Jefferson, how long would the SCM process take for the appointment of legal counsel, an external legal counsel?
Are you done, Honorable Thol, with your comment?
Yes, my response depends on clarity on the question.
Okay.
How long will it take to appoint an external, if you have to go through all the SCM process, the entire SCM process, how long will it take?
Okay. I get your question. Let's put it in abeyance and hear the input of Action SA.
Thank you, Chairperson. Now, with the objective of restoring public trust, I want to say that no reassurance has been given to this committee regarding the skill set of the legal counsel. No reassurance has been given to us in terms of the expertise they hold. Previous remarks that rattled this committee, where utterances were made, such as, what was it? The allegations made by General Mkhwanazi cannot be seen as evidence. Things such as that. We don't know this legal team. We've never been given their CVs. We don't know their capabilities, and we are expected to appoint them. As Action SA, and in recognizing the extensive and the complex scope of the committee's work, and this is our submission, it is our submission that an evidence leader with demonstrable expertise in criminal law and prosecutorial experience be appointed to effectively guide the evidentiary process. Alternatively, the committee may consider sourcing counsel with proven experience in handling complex interconnected evidence such as that demonstrated during the State Capture Commission of Inquiry. Having said that, Chair, Action SA rejects the proposal by the ANC. Thank you.
Honorable Sol has asked a question here. I don't know who is going to be the appropriate person, but because we have members of staff here from the legal team, they can advise us, Honorable Sol, if we were going to source out that legal expertise, how long do they think it will take us to have the person or the persons we want?
May I, Chairperson?
Yes.
Thank you very much, Chairperson, and thank you. I've noted all the comments from the members in respect to the independence and the perception of the public. And indeed, there's merit in the fact that the capacity of the Constitutional and Legal Services Office is primarily in drafting, providing written advice, and so on. And I understand that public trust is very important. So having said that, to answer the question of the honourable member, the procurement process will take approximately 3 to 4 days. Thank you.
Well, if it takes
3 to 4 days, what do you mean? What is the process? Are we going to advertise, or do we have those companies or those individuals in our database, and we're just going to make a selection? Or let me not say we, whoever is responsible is going to make a selection, or is the committee going to be expected to conduct interviews? Yeah, can we have that process properly explained?
Yeah, well, it does. Yes, thank you, Chairperson. Thank you. Sorry to have interrupted you. It does depend on what process the committee envisages, but from our side, it will take approximately 3 to 4 days. What we do is we identify people with this kind of advocacy skills, as the members have articulated, and we go through the state law advisors, the state attorney's office, They are our procuring attorneys. They have a process in place and they go in turn to the Solicitor General to get approval for a number of names that we submit, and this can be in consultation with the committee. I'm saying 3 or 4 days. That is if it's a process that's driven by myself as the head of the Legal Services Office. If the committee wants any involvement, then of course it could take as long as the committee's process it takes, but from our side, we need 3 days. Thank you.
Okay. Honorable Salt, are you covered?
I'm covered. Is that legal advice 100% sure that the length of appointing an external legal service is going to take a maximum of 4 days? If that is 100% accurate, then we agree that we need to have legal support that's independent, so that we ensure that the public has confidence in this process. So we would support then with that condition that it won't take long, because I was thinking if it is the normal process, the normal SCM process, which usually takes over 3 months, then it would obviously hamper our goal to finish at the end of October. But if it is accurate that it will only take 4 days to do so, then we support external legal service. Thank you.
Thank you so much. African National Congress, you have heard the input of the members. What is your reply?
No, thanks, Chair. Let me just indicate that what was primary for us was that, one, we should avoid a situation where we have further delays to our work. That's number one. Because our understanding was that if you go and sort an external legal support, you are going to have to go through a particular process whose a time frame we're not familiar with, and I've heard now that the legal service division is saying it can take them a maximum of 4 days. The second issue, of course, was our concern about the cost, and I think they would need to come back, Chair, and tell us, because when you sort the legal services of a senior counsel, as an example, I have no experience of a senior counsel that works alone. You are likely to have one senior counsel, an advocate, and an attorney, or a senior counsel and an attorney, or an advocate and an attorney. So I think we will need to be clarified about that, because, and maybe where possible also to be given projections in terms of the cost that are likely to be associated with that, so that we don't take a blind decision. The fourth point I want to make, Chair, and I must say I'm very disappointed with the legal services of Parliament. I'm really very disappointed, because a few years back, before some of us were members of Parliament, there were 2 ad hoc committees. I think it was SAPC and the other one was ESCOM, if I'm not mistaken. On both occasions, the legal services that were utilized by Parliament, by those committees, were internal from the institution. Now, I don't know, because like other members were saying, none of us had an opportunity to audit the standing of that legal service of Parliament. Maybe some of those legal minds have since left the institution. But it's very disappointing for the legal department not even to mention the fact that at some point they've carried this work, and what is it in their opinion that have made them to come to the conclusion that they are not fit and proper to carry this work. And by the way, what assurance do we have that the guidance we are receiving as we craft the terms of references is going to be a legally sound guidance? which will not be overturned by an external senior council that we are deciding we're going to have. It worries me that a state institution will behave the way in which this legal division of parliament is behaving. Lastly, Chair, and maybe this must be a caution to us as members of parliament, I seem to get a sense that everybody except members of this committee, and maybe not even all members of this committee, is without credibility in South Africa, including in parliament. And I would like us to be very circumspect to take a position like that. That anything and everything that we have not had a sight of, we're not aware of, we've not evaluated. I would have accepted if the proposal was saying, can we get a sense of what we have in Parliament? Get a presentation as this committee. What capacity do we have? And then we look at that against the kind of capacity we envisage as we discharge our responsibilities. And then we come to a conclusion that no. Either because of time or because of capacity, these ones are not going to help us. But I understand why also members of the committee are worried the way they are, Chair, because I mean, the legal team itself is completely without confidence. One person made a comment in one of our meetings, which did not sit well with some of us in the committee. But I don't think on the basis of that comment, all of us have come to the conclusion that that person in particular is incompetent or the division in its entirety is incompetent. I'm just making this observation because I'm worried. I've never been in a situation where a division of an institution will behave so helplessly on a discussion like this, without even telling us what is our situation internally. Okay, if we go outside, what kind of skill are we looking at outside? Or we're looking at everything. I mean, I've never seen such a helpless situation. So in the context of that, Chair, maybe the honorable members have every reason then to be supported who are saying it's correct. Let's go outside and get a capacity that is going to help us to discharge our responsibility in this committee. But I thought it's important as a proposer of this item that we should also make an observation about what, in my own view, is a very disturbing conduct on the part of the legal division of parliament. Thanks.
Thank you so much. The matter has been concluded, so it means the legal team will then have to come back and deal with specifications. How many people are we going to need? What must be the competencies of those people? And what is the work that they are going to do? And how much are they going to be paid? And do we have that money to pay them? So that at the time the committee must start its work, we must not have any issue where we'll be told that there is no money or we are not getting the requisite skills or the specifications were improperly drawn. We don't want those things. Everything must be spot on, exceptionally good. Can we then move to...
Chair?
Yes.
Chair?
Hello?
Am I allowed to yes, I know that you've spoken to the chief whip of the ANC, when he made his closing remark on this matter. But just before we pass this, I think the chief legal advice has said it clearly as well. Whether the 3 days or 4 days will work. For me, it would be proper if we have, if we can guarantee us that for 3 days will work wonders. Because remember, Chair, that our terms of reference, we have allowed, because Parliament, we have allowed, to call heads of institutions who are highly qualified. Perhaps even judges and the former chief justice will be called. So we need competent people, not that we are undermining anyone. That has to be taken into consideration, Chair. Please, on this matter, we must, we have money, we've seen there's money on national dialogue. There's money. If we have to, this is a national dialogue. This matter, South Africans are waiting for. What Mkhwanazi has done cannot be done. We could not afford not to done, justice to our people. This is the only opportunity we'll ever had for South Africans, and not for us to sit in Parliament and do things which are unbecoming and protect and whatever. But I'm not there. I'm just saying, let's make sure whatever happens on this matter, let's go all out. I thank you, Chair.
No, yeah, Honorable Skosana, you must not leave it there, because it is still incomplete. As a committee, we need to satisfy ourselves. That's why I said the legal team will then have to circulate the specifications of the kind of services that they are going to procure, including the competencies required and the work that is going to be done by the persons that we will be contracting. Isn't that they're coming to do work here? So we can't just say, because they say this can happen within 3 to 4 days, and then, yeah, that is it. Let them go and do it.
Chairperson.
Hello, Honorable Nomval.
Yeah, Chair, I've got a problem with your summary because it is reflective of one member's version of Comrade Mtumzeni's version. The majority of members here, Chairperson, is saying that we agree that we must outsource legal skills, the evidence leader. And in your summary, you are not making that reflection. The only reflection we are making is a reflection of Honorable Mtumzeni's input. We are not here to rubber stamp perspectives of the ANC. We are here to contribute also as members of this committee. Please, Chair, make a conclusive summary that reflects the sentiments of all members in a meeting. We are not agreeing with using the internal legal service, and the position that we are taking as a committee, as the majority, 90% of this committee, is that we must outsource. And there is money in this country, Chair. We must not use this thing of saving cost at the expense of the quality legal services that we require as this committee. There is money. Money is wasted every day in this country.
Honorable Nomvala, you are picking an unnecessary fight, because the issue of the external legal service is home and dry. There is no opposition to it. Nobody is opposing that. I mean, honorable members have spoken in a chapter and a verse in support of external legal services. And that is why I am saying that even before we go to do that, the legal team must then circulate draft specification for the committee members to see it and satisfy themselves that the draft specifications for the procurement of external legal services is what we are happy with as the committee. Do you understand what I'm saying? Because as the chair, I want to avoid a situation where after 3 or 4 days we meet here and members say, this is not what we wanted. Listen here. When we say we will get an external person in 3 to 4 days, how are we going to get that? How is that going to be done? I mean, the legal team has not explained how that is going to be done. And I am taking the process further to say, all of us, when we leave this meeting, having taken this decision, we must be very clear on how that is going to be done.
Yeah, I hear you, Chairperson.
Chairperson, point of order. Chairperson, I've got a point of order.
Honorable Kusela, let's allow.
It's on you, Chair. The point of order is on you. You are not protecting us, Chairperson, from abuse of MKP. Since this meeting started, we have been quiet. They know the process. Parties comment, you give an opportunity for response. But every time MKP comes in and interjects, they want to preach to us about this and the other thing. And I think, Chairperson, you are doing a disservice to us. Nobody is barred from speaking, but we can't as parties agree on a process. Then every time after you either finish summarizing or after somebody speaks, then you have the MKP wanting to interject. We can also do that, Chair. And I think that you need to help us by protecting us from this abuse of the MKP. It can't be correct. Thank you, Chair.
That is a fair point of order. I accept it. I will tighten the belt. Honorable Nomval, you wanted to speak. Do you now understand what I have explained? Honorable Nomvala.
Chair?
Honorable Skosan.
Chairperson,
Yeah, I'm taking.
Chairperson.
Oh, he's back. Thank you.
Chair.
Honorable Nomvala.
Am I audible?
Yes.
Chair, I'm saying what triggered this whole confusion on my part is your last remark. You said that we will allow the Parliamentary Legal Service to go and do specifications and come back to this committee to present so that we can make a determination of whether we do afford the external legal service or not. That's where we differ with your summary, Chair. We do afford the legal service, the external legal service, and the position that we're taking as this committee is that we will outsource. That must be clear. And it has not been reflected in your summary. That's what I'm disputing. I don't know this point of orders that are coming now. What motivates them?
You mentioned one of the 5 things that I said. Because where I started when I spoke on the specifications, I said that they must go and deal with the competencies that we require. And I mentioned all those other aspects, 5 of them. Because if we take a decision, like we have taken a decision now, to say we want external legal services, unanimous decision, and then from there, the legal team of Parliament says we are going to, this process can take us 3 or 4 days. And then on Friday, they come back and say, no, we have appointed Soviet Nhlanhla. And then one committee member stands up and say, how was that process run? We don't accept this appointment. That is why it's very important that consequential to the decision that has been taken, there should be a draft specifications which are circulated to the committee members for them to agree in the same way as we dealt with the terms of reference. And it must be explained how the selection is going to be done so that we do not find ourselves fighting over something that should not make us to fight when the work of this committee is to run proceedings. So there is no person here who is opposed, either vehemently or inveterately, to the appointment of the external legal team. Nobody. All of us agree.
Chair.
Honorable Mali.
I've raised my hand, Chair.
Chair?
Yes, Honorable Mali.
No, there can be a new criteria to appoint a person from outside who's about to provide legal services. That thing called Parliament is an established institution. They know very well when they want an external legal practitioner, what are the procedures to be followed. They get represented every day in court, not by Parliament internal staff. And when they say a court is meeting tomorrow or a day after tomorrow on agent basis, there is a lawyer there. So they must follow what they normally follow to procure a lawyer, those services. And we don't have a headache of trying to write whatever we want to write. We're not talking about some different kind of procurement. Here we're talking about a lawyer. And you know how lawyers are. They don't come looking for jobs. You go to them and say, hey, we want this person. Are you available to take this or what? So let's not have a headache. Let's just give it back to them. The legal service is telling you guys we need outside legal person to deal with these matters. And if you insist on them, then they'll disappoint you. And then the next thing, it will be that we told you we should have received a person from outside. They will still be there as a legal service of Parliament. They will be working together with whoever we're appointing from outside. So we, as parliamentarians, like councillors, we must not be concerned about the processes of procurement. That's the day we're going to get ourselves into trouble. We just establish a principle and then the administration knows how to take that process forward. Thanks.
So, Honorable Malema, your suggestion is that, no, wait. Your suggestion is that let them go and appoint.
My suggestion is that they appoint, following the same procedure they do all the time when they appoint legal practitioners.
Okay. I'm now rotating the parties. I want to check if the proposal that Honorable Malema makes that the legal team of Parliament must go and appoint following the established procedures is supported. ANC?
ANC agreed.
MKP?
Thank you, Chair. As I've raised my hand, I just wanted to say this. One, as long as they don't use state attorneys. Two, it was very offending to hear our honorable member, Sandoni, saying MKP is doing that. Chair, you must really try to protect us. Otherwise, as he said, he can do the same. I can do 10 times better than what he was telling our members here. It's really uncalled for. To say it's
No,
like
but
we
Chair,
are
don't
disruptive.
Don't
No, Chair. Chair, protect me.
Don't
Chair,
allow.
protect me. If you have,
Actually, we can do it 100 times.
Let us be protected against the ANC bullies.
A million times.
We're not going to be
I can
bullied
make
by the
it a
ANC
million
here.
times.
Never
If
bully us.
Sandoni can be allowed to talk about us, and then Nhlanhla never said anything because he's a comrade. It doesn't work like that here. He must respect me here. I'm the member of this committee. And I'm saying, Chair, I'm responding to what the member said about MKP. He said MKP is coming here disrupting you, Chair, which is not true. We are not disrupting anybody here.
Honorable Skosana.
It must be clear. It must be recorded. We can't be told by Sangani as if we are not his grandchildren. She must respect us. If he's got a problem with MK, you must swallow a pill. Thank you.
You are not going anywhere. We're here to stay, whether she likes it or not. She must stomach that.
Are you done, honorable members?
Yes, I'm done. You know, we can't be told how to respond on this committee. She's been doing that, and we've been quiet.
But
now she's taking it into another level. It's personal about MKP.
Can I check if the MKP supports the proposal that Honorable Malema has made before this committee?
Yes, we do, Chair.
Yeah. Can we go to the next party, the DA? Can we check if the DA supports?
We support, Chair. Thank you.
The IFP?
Excuse me, Mr. Chairman, for disappearing from the platform. I experienced some technical glitches here, but I'm back.
Yeah.
We support the proposals.
The apology is accepted. The support is recorded. The PA?
Chairperson, with the understanding that the appointment will not hamper in any way the time frame set for the committee to conduct its business or complete its business, we support the appointment.
The Action SA?
We support. Thank you, Chair.
The decision is taken. Before we move to the next item, let me remind you, honorable members who are here, from the ANC and the MKP. When you have said what you have said, come back to your consciousness and remember that you are the representatives of the people of South Africa. Thank you so much. Can we move to the next item? The next item was going to do, we are dealing with the submission by the MKP. MKP, do you have anything to say on your submission?
Thank you, Chair. On our submission for us, we hope that it will be accepted as it is. Thank you, Chair.
Okay. Can we now take comments, ANC, on the submissions of the MKP?
Chair, can you hear me?
Yes, Honorable Ntuli.
Yes, no, thanks. We don't have a major problem with those 3 points from the MKP, except that 5.2, which says findings shall be grounded in a probative record sufficient for rational parliamentary recommendations with reasons recorded. We can do without it. But if the feeling of the meeting is that it has to be there, the ANC will really not stand on the mountain against it. But the reason why we say we can do without it is because we believe that it will be inconceivable for the portfolio ad hoc committee to make decisions and recommendations that are not rational. So the way it comes across is as if it's a condition because we may not be capable of being naturally rational in our submission. But as I said, Chairperson, it's not a matter for us that really is fundamental. We are just making those observations, but it can pass.
Okay. DA, your comments?
Thank you, Chair. I think they're actually good points and no objection. Thank you, Chair.
The EFF?
Can you hear me?
Yes,
Chair?
Honorable Matthys, we can hear you.
Chair?
Honorable Matthys, we can hear you.
Oh, you can. Thank you, Chair. Yes, we support.
Okay, thank you so much. The IFP?
Supported, Mr. Chairman.
I don't know, but I think it's this MK thing which we do.
Honorable Matthys, can you please mute? The PA,
No objection, Chair.
the Action SA.
No objection, Chair.
Thank you so much. MKP, do you have any reply? There has not. Oh yeah, the ANC has commented on your submissions. Can we have a reply from the MKP?
Thank you, Chair. I think we can move forward because all members agreed with our submission. Thank you, Chair.
Oh, okay. Can we then go to the submissions of the DA?
Chair, it looks like the next one is the EFF submission, if I'm not mistaken. Unless if you are not following the screen, you are also checking on outside.
I'm following the parties. Did the DA make a submission here?
Chair, we made a submission, but only towards the end of point of the whole of point 5. So I don't know if you would like us to go through that submission, Chair, or if you would like to wait for us.
We're on item 5.
All right, no problem.
Yeah. Yes. Okay. Do you want to motivate your submission?
Yes, please, Chair. So we if Andile can just go down for us. It's almost right at the bottom. Goes about witnesses, Chair. There you go.
Yeah.
Thank you very much. So we're just speaking about the documentary evidence. I mean, every member must have the right to put questions directly to and receive immediate answers. So that's what we would like, Chair. Oversight cannot be reduced to just a script. We are concerned that in the current format that each MP will not have the right to cross-question witnesses directly, and that it will be filtered through the chairperson, which we do agree that the chair can intervene where members are genuinely wasting time or where it's repetitive, but there must be substantive oversight being done by us, and there must be a distinction between the abuse of time and the legitimacy of the inquiry. And we don't think that it can be at the sole discretion of the chair. So that is our submission. Thank you, Chair.
Okay. Comment on the DA submission, ANC.
Chair, if I may just add, you'll see there that we put in a point of site visits, which is if we may have to visit the police stations, because it is a little bit of obviously a risk for security for us to remove members that are perhaps incarcerated to come to see us. So that is why we've added in the site visit, Chairperson.
Okay.
Chair, can I then proceed?
Honorable Chief Whip.
Yes, Chair. No, we don't have a problem with these proposals, except that I think the first thing is to get clarification. Is this envisaged to be a process before or after we've received some form of evidence presented in the committee? Let me just read the paragraph verbatim so that it can be understood in context. The committee will request and review relevant documents, reports, and internal communications from the SAPS, as well as any other external audits or investigations that may be available, and also with respect to other relevant institutions. So the first point for me is clarification. Is this proposal suggesting that after having had evidence which relate to what we will request, because the document says the committee will request, we will then request the information, or the suggestion is that there is an information we must go and request before we hear the evidence? If we can be clarified on that point. In fact, that clarification, Chair, applies to the 3 points that the DA has proposed: the documental evidence, expert consultation, and site visits.
Can the DA clarify its submission?
Thank you, Chair. Well, I think it's twofold. The first one is obviously General Mkhwanazi made some allegations. So when he does come to the committee, he will come and present documents to us. We can also obviously ask beforehand for documents to be submitted to us. And I think part of, if I remember correctly, the ANC higher up in the document, I just want to open mine where it goes. In the beginning, it says that people should submit evidence in the beginning. And I mean, we do understand that people can submit evidence before they come and see us, but it is more as we go along. So we will need to obviously request what we deem necessary in preparation. We can't just go ahead blindly. So the committee process must obviously guide us, and then we can also request more if needed, because somebody might come to us and give evidence, and then as a person asking questions, you can always ask for further evidence relating to the matter that they've brought up, Chair. Thank you.
Honorable Ntuli.
Yeah, Chair, I'm still not very clear, but where I have no problem with these points is if the suggestion is that once we have had a presentation, okay, let me separate the two. Let me just make a hypothetical example, Chairperson. Let's say tomorrow, let me say next week, Monday, as an example, if we were to decide that we're inviting Lieutenant General Mkhwanazi to come before us, and he confirms that he's coming on Monday next week, I would imagine that we may be interested in him making a written submission to us ahead of time, so that when we interact with him on Monday, we are departing from an informed position. In that context, I think that it should be fine. If that is what is meant by this proposal, then I think that should be fine. But if what is meant by this proposal is that we've listened to what Mkhwanazi has said in public, even if before we interact with the evidence that is meant to come and present before us, once we're done with these terms of references, we can go and visit a police station and say we want the following information. So that is why I was asking a clarity. Now, it seems that the honorable member from the DA partly covers me on the first part of what I said, but the second part of what concerns me, I didn't quite understand what she said.
Okay. DA.
Sorry, Chair, thank you. If I may, I just want to give maybe some clarity. I think in terms of the documentary evidence, Honourable Ntuli, or to Honourable Ntuli's question, it goes both ways. So the one is in preparation. So say, for example, General Mkhwanazi, as you correctly said, gives us some kind of a document or briefing, something that we can use for preparation beforehand. Then that would be included in this specific paragraph. That's what we mean. Or if through the process we get to a point where we realize that we would, for example, need to consider a report, and I'm just using this as an example from, I don't know, 2021, that was then presented by the National Commissioner to Parliament or something like that, then obviously we would need to go and source such a report to aid us with whatever we are busy with. So that explains that. But I think furthermore, just in terms of site visits as well, if, let's say, in terms of the 120 dockets that are missing, if they say that there's a problem that some of these dockets supposedly or allegedly went missing at a specific police station, let's say in the middle of, I don't know, Kimberley or something, then it would, and there's a reason for the committee to have to go there for some other reason, then we can do that. Or if it might be a matter of forensic evidence of some kind. So I think the point is that if there are specific facilities that need some kind of oversight during the process, then it would be included in this definition of site visits. Thank you, Chair.
Okay, then Chair, in that case, I'm fine. We'll support it. With this explanation by Mr. Cameron, it's much more clear. Thanks.
But then it means it has to be refined so that it means exactly the explanation that they have given.
I agree.
MKP,
Agreed, Chair.
EFF,
Chair, we agree, but in terms of the site visits to correctional services, I don't think it would be necessary because correctional services generally transport prisoners, whether it's to hospitals or to court. So it might be an unnecessary thing to do, but I guess we can make a decision based on whatever is before us. And then on the documentary evidence, it seems that the DA submissions are dealing primarily with the issues of SAPS, but our scope is not just dealing with SAPS, it's also the NPA, it's the metros, it's the I did say the NPA and also correctional services. So I just think we need to just be cognitive of that as well.
okay. IFP,
Supported.
PA,
We support you, thanks.
Action SA.
We support you.
Thank you. Except for the ANC, which you clarify, Honorable Cameron, I have not had any statements except the part that was mentioned by Honorable Matthys. Do you want to reply?
Chair, I think Honourable Matthys' point is very valid. I think it was we should actually say it should be the relevant institutions because she correctly says that it might include a correctional facility or a court of law. So it should be considered within the criminal justice space. We can better define it. Perhaps the legal team will know the perfect wording. But I think it's a very valid point to just make sure that it covers all of the institutions that we would be responsible for during this committee's process. Thank you, Chair.
Okay. And you agree that your submission should be refined to mean exactly what you have explained here?
Absolutely. 100%, Chair.
Thank you so much. The next submission is the EFF. Honorable Matthys or Honorable Malim, do you have any motivation or a comment to make on your submission?
If we can just pull it up, Chair, it's not... It was really just speaking to 1.5 in which we made...
5.1.
It was just fixing the wording from 1.5 that we are bringing over here. So I think it's quite self-explanatory. If any members have anything to ask. But it's just talking about exactly that, including all the entire justice system, not just the SAPS.
You are happy with the way it is kept
Yes.
Up? Okay.
Yes, thank you, Chair.
Comments, ANC.
Thank you, Honorable Chairperson. As the ANC, we have no objection to the EFF submission.
your support?
We support it. Thank you, Chair.
Okay. MKP?
No objection, Chair. Support.
DA? Democratic Alliance?
We support, Chair.
Thank you. IFP? Honorable Mnwango?
Yes, we support, Chair.
Thank you so much. PA?
We support, Chair.
Action SA?
We support, Chair.
Thank you. Can I check IFP and PA? Do you have submissions that you made on item 5?
We have no submission.
No submission, Chair.
Action SA, do you have submission on item 5?
Yes, Chair, with regards to witnesses, if I
Okay.
may.
Do you want to motivate or comment
Yes,
on
Chair.
your submission? Thank you. You're welcome.
Yes, Chair. All witnesses should be required to submit sworn written testimony in advance of the appearance before the committee, accompanied by all relevant evidentiary documentation. This procedural safeguard will ensure that the committee deals solely with matters of fact and verified evidence, thereby precluding the admission of hearsay or unsubstantiated claims. However, this requirement should not obstruct the committee's ability to explore further evidence presented by any witness should new information arise during the inquiry.
Okay.
Thank you.
You are done, Honorable James.
Yes, Chair. Chair, I'm just, as you're going through this, I'm getting a bit lost and confused because 1 minute we're on page 12, we're at the beginning of section 5, and then when we look again, we're on 2021, and then we pass the submissions that we've made to the previous points. So I'm not sure how we're doing this. We're scrolling back and forth.
We're dealing with item 5 as a whole, like we dealt with the preceding items. So you will find that the submissions of individual members or parties do not appear on one page. So it means if we deal with the submission of the EFF, we will go to another page where it appears.
Okay.
Yeah.
Thanks, Chair.
Can I then rotate the parties to express their comments on your submission? The ANC?
Me, I'm lost, Chair. I'm trying to catch up with this Action SA point.
Yeah, they are making a submission on witnesses.
On the witnesses. So this is under what? 5-point bar or 6? Where is this?
Yeah, no, we are still at 5.
At 5, so.
Yeah.
It's 5.3.
5.3.
Yeah, under witnesses.
Oh, okay.
You see, Chair, I told you you are confusing us.
No. You can, if you are tired, you must just say no. It has been a long. No. Listen, we when we came back to deal with item 5, and remember, you are the last party that we are dealing with. All parties have made their submissions. They have commented on their submission without any hitch. So I understand it has been a very long day, Honorable James, but let's stay the course.
Okay, Chair.
No, Chair, the ANC is fine with this submission. We were, when we were looking at it, is covered already somewhere above, but the repetition is not going to harm anything. It's okay.
I think where there is repetition, all of us agree that that should be cleaned. For as long as the submissions of all the parties are carried. Can we go to the comments of the MKP on the submission of the Action SA? Any comment, MKP? Okay, we will come back to them.
Chair?
Hello?
Yes, Chair.
Yes, you have any comment on the submission?
You are talking about our submission.
No, your submission we dealt with. I mean, the submission of Action SA. Do you have any
Yes, we
comment?
don't have a problem with that. No
You
problem.
support?
No. Thank you.
Do you support?
Yes,
Thank
Chair,
you.
no problem.
EFF.
EFF supports.
Thank you so much, Honorable Matthys. IFP.
IFP supports, Honorable Chair.
Thank you so much, Honorable Mngango. PA, Honorable Sols.
We support the version as it is stated originally there, 3.1. Action
Thank you
SA
so much.
is a repeat, it's just longer, but there's no material difference. So we support the initial one.
Thank you so much. Action SA, do you have any reply?
No, Chair, we're fine.
Thank you so much. So, honorable members, can I check, is there any party that still has a submission which was not dealt with at item 5?
Okay, you missed the DA when you asked about the Action SA submission. You went from the MK. I think perhaps you just missed us. But we do. It's all right.
We give you a chance to express your comment.
Thank you so much, Chair. We really appreciate it. Chair, we would like to insert a new section under the last point, which is 5.7.4.
No. First of all, do you support the submission of the Action SA?
We support the submission of the Action SA, and then we would like to bring in a new section, please, Chair.
Yeah, then let's go to, we're still at item 5 now.
That's correct. It will be the last point on item 5. We had it as 6. I see it's been included in 5.
Yes, let's hear your motivation.
Thank you, Chair. It's on the confidentiality and protection of whistleblowers. And it's basically to protect whistleblowers in our country, Chair, and to make sure that all individuals that testify are given the appropriate protection, that whistleblowers and other sources do come forward with sensitive information and they're looked after. As we know, whistleblowers in our country do tend to meet untimely deaths in our country, and we would like to protect all whistleblowers going forward with this addition. Thank you, Chair.
Okay, so this submission is married to the earlier submission that was made by the MK party, if you remember, on the protection of witnesses.
Thank you, Chair. This is specifically on the confidentiality and protection of whistleblowers.
Yes. Whistleblowers are witnesses, isn't it?
Well, Chair, there are witnesses, but they're also not witnesses because obviously not everybody knows who a witness is. So I think there's a little bit of a difference.
No, it's fine. I will accept it the way you present it. Members of the committee would know we have dealt with a similar matter like this one. I don't think we should have a problem accepting it, but let me hear the comments of the parties. The ANC.
Thank you very much, Chairperson. And maybe just to reiterate your point that we have already dealt with a matter of this nature. And I think the issue that the Chief Whip had raised during the discussion also arises in this case, because the submission from the DA seems to expect that the committee has powers to be able to do this. I don't think that we disagree with the sentiment, but Chair, there is if I'm not mistaken, I may get the name of the act wrong now, but I think it is a protection of protected disclosure or protection of whistleblowers act, and there is an office that deals with the protection of witnesses, which is in the Justice Department. I think our recommendation, Chair, would be perhaps a reformulation like we had suggested with the last one, so that the committee is able to direct to the relevant authorities, where there are senses of intimidation, need for protection, and so forth. Because as we agreed earlier, us as the committee do not have the capacity to do that, but we fully agree with the sentiment to ensure that the required protection is afforded to whistleblowers and any witnesses who may require such. And I think such assessment, as we had also said earlier, the SAPS is fully capacitated to be able to do security threats, but we do agree with the sentiment. We think it may be an issue of reformulation. Thank you, Chair. But while I'm on the platform, Chair, I'm sorry, I just needed clarity, because there are other submissions, for example, from Action SA, which are still in Section 5. I think they dealt with the first one. I'm not sure if we're coming to the others. Thank you very much, Chairperson.
Okay, we will come back to them if they still have. We must deal with 5 exhaustively. So the ANC support the spirit of the recommendation, and that the guiding legislation should be taken into cognizance. Can we then move to hear the comment of the MKP on the submission of the DA?
Chair, I think I've dealt with that matter earlier about that. Perhaps it's coming back now in another form, but I think the issue of whistleblowers, I've dealt with it in terms of how the protection should be, and there's gaps there. I've cited some issues on that one, but I think I've already dealt with that matter.
The MKP supports.
Yes, sir. Yes, as I said, that it's coming back. The same thing which I said. So we support that. We support that.
Just say where there are commonalities, they will be integrated.
Thank you, Chair. You sum it up nicely.
Yeah. And then can we move to the EFF?
Chair, we support, but I just want clarity, because the DA is saying that they want to insert a new section, but what they're proposing is already here on page 22. Is it the same thing? Because it's not necessarily new, because I was raising my hand to say this is not the time for us to be adding, and we had concluded on making our submission. So it's the same thing. Am I correct? On page 22.
Yeah, look, that's why, if you understand, Honorable Matthias, we say we support the spirit within which the recommendation is made. It was part of it was earlier discussed, and it has been accepted by the meeting. So where there are common areas, they will be matched with those on page 22.
Okay, no, that's fine. I was unclear, because the DA said they wanted to make a new submission or insert a new submission, but it's already there. So I just wanted to make sure it's the same thing. Yes, we support, Chair.
Thank you. The IFP?
Supported, Chair.
Thank you so much, Honorable Mngango. The PA?
It's not a new submission, it's a repeat. We have already
your support.
No, it's a repeat. It's already there. Don't support in addition.
Yeah, but are we together in spirit?
Yeah, as we agreed, the spirit is already articulated in the draft.
Thank you. Thank you so much. do you still have something further to say?
No, Chair, thanks.
Thank you so much. Honorable James.
Supported, Chair.
Thank you so much. Any reply from the DA? Any reply from the DA?
No, Chair, thank you very much. We covered this. It wasn't a new submission. It was in the original submission, but it was just a new paragraph. Thank you. We appreciate the support.
Oh, okay, the drafting team will note that and go and make a comparison to check similarities between this and the other section that we previously dealt with, so that the document can be properly organized. There must not be items that repeat themselves. So it means the organization of subheadings must be in such a way that when we deal with witnesses or protection of witnesses and whistleblowers, whatever classification or categorization we want to make, let's deal with their protection in one section. And in that way, we are going to avoid repetition. Action, Honorable Sango. No, the person must come in, Honorable Mnango. Can I check, Honorable Sangon? You spoke about the submission of Action SA, which is still outstanding on item 5. Action SA, do you still have outstanding submission on item 5?
Chairperson,
Honorable
I humbly plead. Yes, I do. I humbly plead with you to make reference to which point of 4.5. Because right now we are going back and forth from different pages. And please, I am not tired. I'm saying to you, this is not the way you conducted the previous meeting, where we literally took every paragraph that was numbered, we unpacked it, we took changes and we took submissions, and then we moved on. By you saying section 5, we move from 5.1 to 5.3, and we have things overlapping, and it sounds like repetition. And this is why I can actually sense that members aren't clear in terms of where we are. So the fact that we were on witnesses, we are now on questions to witnesses, 5.4. And our submission is specifically towards 5.4 on questions to witnesses. Because there are various subheadings when it comes. So when you move and you say we are dealing with section 5 and we are all over the place, I read from the first point, I give the submission, and then we go through it until we get to the next submission. But the way we are doing things right now is very confusing, and I'm not tired. Let me make our submission on 5.4 questions to witnesses. Action essay.
Before you make your submission, Honorable James, when we go to the next section, which is item 6, when we request your party to speak to your submission, you must speak to all the submissions that you have made on item 6. You can now proceed to make your submission. Is this the last submission on item 5? Honorable James?
I'm paging through this document, Chair. I'm having to page through to make sure and having to look at the numbers, because we are now not being guided by you in terms of the numbering. No, it is not, Chair. I will read all of them and then we can just discuss all of them, dear Makar. Anyway, Action SA proposes Action SA proposes that committee members be allocated a minimum of 20 minutes for direct engagement and interrogation of witnesses. Furthermore, the format should permit members to question witnesses directly, rather than clustering questions for response only at the end of the session. Following the evidence leader's initial examination and probing, committee members must be afforded the opportunity to pursue further lines of inquiry independently. Are we going to engage on that, Chair?
Are you
now,
done with your...
or I'm done with this part pertaining to questions.
What is the other submission?
The other one is Action SA's submission regarding the appointment of forensic investigator. That is on page 21.
Yeah.
Okay. Action SA proposes that the committee considers engaging a forensic investigator to complement the evidence leader's expertise and to assist with the technical and evidential complexities anticipated in this inquiry, particularly insofar as they relate to criminal investigations and the work of crime intelligence.
Okay. Do you still have
Now,
other
now it feels like we're just rattling, Chair, to get done.
Do you still have other submission?
Yes, Chair.
Let's go to your submission.
Regarding the committee's role in facilitating the consideration and processing of evidence related to crime intelligence, including the need to protect identities of witnesses. In this context, it is imperative that the committee ensures that evidence pertaining to crime intelligence is not effectively obstructed or excluded, given the interconnected nature of the allegations, allowing a fragmented approach that isolates certain aspects, risks undermining the integrity and comprehensiveness of the inquiry. Such fragmentation would be detrimental to the committee's mandate. Accordingly, we, Action SA, submit to that the committee proceed to fully consider and process evidence related to crime intelligence while simultaneously taking reasonable and necessary measures to protect the identities of witnesses who may be serving operatives or involved in ongoing COVID operations. I'm just checking if that's it. Yes, that's it under section 5G.
Okay. Honorable members, there are 3 submissions from Action SA. Number 1, on the questioning of witnesses. Number 2, on the appointment of a forensic investigator. And number 3, on evidence related to crime intelligence. Can I rotate the comments of the parties, the ANC?
Thank you. Thank you very much, Chairperson. Let me thank also Action SA for their submissions. Chairperson, on the first issue of the 20 minutes, we hold the view that it's not necessary to be prescriptive in the terms of reference on the number of minutes to be allocated per member. And the reason we say that is because we hold the view that the committee can determine what is reasonable under the circumstances. And we think that the chairperson should be able to make a determination based on the facts before it at that time and the line of questioning. So we think that rather than prescribing a specific amount of time, rather we should look at reasonableness, which allows members to engage. And part of the reason we say that chairperson is obviously linked to the resolution that had been adopted, or at least the recommendations of that had been adopted by the National Assembly, that this process must be member-led, informed by our oversight mandate. So we don't want to say, you know, this process members should be gagged in any way as they partake in it. Chairperson, on the second issue around the forensic investigator, you will remember that when we spoke earlier on and we wanted to get a common acceptance of what we mean by an investigation. It was largely because we knew that this point would arise at a particular point. Now, as the African National Congress, we hold the view that we are not an investigative body. I mean, when we are seeking to appoint a forensic investigator, and given perhaps our limited understanding of the work of a forensic investigator, which to a large extent the Oxford Dictionary says it's to examine crime scenes, gather and analyze evidence, provide expert testimony in reference to criminal investigations. What is it that we believe, and maybe here, let me ask it as a question for clarity. What is it that we believe a forensic investigator will be able to bring to this process, given the fact that we neither have the authority, mandate, or the powers to conduct a criminal investigation? We do not believe that that is the role of Parliament. Chairperson, on the last one, which is around, it is on issues of criminal intelligence. Chair, the laws of the Republic, I don't think they can be flouted by the committee. And this is coming yet once again when it comes to issues that are related to the intelligence function. We think that there needs to be very clear authority, whether the rules or the legislation or legislation in general empowers us to delve into matters of intelligence. We think that the powers that this committee has are in terms of the rules of the National Assembly, especially Rule 167, and they do not necessarily appropriate upon us the responsibility to handle matters of intelligence in the way that it is proposed. Let me stop there, Chair. Maybe just to mention that it's Rule 167 read together with Rule 253, which says that an ad hoc committee has those powers as only listed in Rule 167 and only as specified in the resolution or establishing the committee. Now, in the resolution that was establishing this committee, we're not given the mandate to deal with intelligence matters. Rather, the resolution of the House had accepted that the Joint Standing Committee on Intelligence was dealing with those matters. I think that is our submission, Chairperson, on the Action SA's submissions. Thank you, Chair.
Thank you so much, Honorable Sangweni. Can we go to the MKP?
They've given up.
The MKP.
Thank you, Chair. Am I audible?
We can hear you.
Yes, Chair. We support the submission that has been made by the Action SA. Chair, our view is that maybe 30 minutes would not be enough to be allocated to each person, maybe during an inquiry or during the interviews. I think it's too limited, Chair. Maybe if we can take it to 30 minutes rather. 20 minutes is not enough. So our view is that maybe if we can take it to 30 minutes, or maybe we agree that there will be no time limitation, because we don't want to leave it to the discretion of the chairperson, because we know that chairpersons, when you give them too much discretion, they end up running meetings depending on their mood, not depending on on principle. That is why we are of the view that let's prescribe 30 minutes rather, not 20 minutes, because remember that within the allocated time, there are responses, and sometimes some witnesses chow more time during their responses. So we're of that view. And then, Chair, with regards to the forensic investigation, we just wanted to get more clarity from the Action SA, because we don't want to disagree with their proposal while it is maybe made from a genuine perspective and while it will assist the committee. So we just want to get clarity from their understanding that what kind of information maybe would be in their thought investigated by forensic investigators, because I disagree with what has been said by the latter speaker, that forensic investigators largely deal with criminal investigations. It need not be criminal investigations. There are other investigations which can be done by forensic investigators. Section 106, for instance, of the Systems Act requires the MEC to appoint, when necessary, a forensic investigator and forensic investigator on corruption, on allegations of corruption and maladministration in municipalities. So I'm saying there are many areas wherein forensic investigators fit, but we are interested in knowing that, in their view, because they are better placed to explain, since they authored this recommendation, how will the forensic investigator assist the committee in exercising its responsibilities? If we can be clarified in that aspect, Chair, maybe we can support Action SA in that regard. But on other aspects, we do support them. Thank you.
Okay. The EFF.
Thank you, Chair. I thought Honorable Malema will take this, but no problem. I'll do it. In terms of us capturing the format and how we're going to question witnesses, I think it's highly administrative. I'm not sure if it needs to find expression in the terms of reference, but we're not opposed to it being here. It's not necessary for us to set a time allocation of time, right? Not in a terms of reference. I think it's just too much information. So we don't support that on allocating a time. I do share the sentiment of giving too much power to the chairperson. I mean, we've witnessed in Parliament over and over again how chairpersons suppress questioning, whether when the executive or whatever the case may be, and you can even go through previous inquiries that we've had from ESCOM to SABC. So we would like this committee to be as transparent and as free as possible, and parties to be able to do their work that they have been mandated to do under the Constitution. So let's just be cognitive of that, because at the back of our minds, we don't want to, you can't ask that question. This question is not in line with that. And we end up degenerating in there. I agree that we just need to get more clarity on Action SA, but what it means when they talking about criminal investigations and crime intelligence. Perhaps it's just something that needs to be reworded. As it's written right now, I do think it is outside our scope, but let's allow them the opportunity to explain what it is that they envisioned, and then perhaps we can reword it. Thank you, Chair.
Thank you so much, Honorable Matthies. The IFP.
We support the proposal, although we are not entirely comfortable with the prescription of time, because circumstances will differ. But the principle is okay.
Okay. The PA.
Chair, we support the time frame matter. The wording reads minimum 20 minutes. We agree with minimum 30 minutes. It doesn't say in our understanding that it is only 30 minutes, but to say that a minimum of 30 minutes, and it can be more. So perhaps we should reflect that to say that it can be more than 30 minutes, but what is the maximum? Because one can also not go on forever. So it can be a minimum of 30 minutes of interrogation or questioning to and fro, with a maximum of whichever the committee decides. But there should be a feeling or a sense that that members are not limited in dealing with relevant matters. On the issue of forensic investigation, there should just be an addition of if required, because I think the issue there is whether such expertise would be required. So if required, then that option should always be open. And then the last one on the processing of evidence. We support the first part that speaks of the non-obstruction or exclusion of evidence that would come about that pertains to crime intelligence. There should be no obstruction. It should not be excluded, which would then result into fragmentation. We support that. The last part is a repetition of what we've just discussed about what the DA has proposed. We have dealt with the protection of witnesses earlier, and we supported it. So the last part, we feel that it's a repetition again, but the rest we support. Thank you.
The Democratic Alliance.
Thank you, Chair. Just in terms of the time limit, I think that is something that may change. It's not something that is necessarily can be bound to just an X amount of minutes throughout. I think it's important that the discretion of the Chair is also allowed during that. Just in terms of the forensic investigator, that's not a parliamentary, that's not our mandate, Chair. The mandate of the ad hoc committee is not to conduct a criminal investigation. We have to just plainly exercise oversight. We can test evidence placed before us, and we can make recommendations from that to the National Assembly. And obviously, we can follow that up, as we said earlier, through the relevant committees afterwards. I think bringing in a forensic investigator can risk blurring the line between Parliament's oversight function and other investigative bodies. So just to emphasize that, we do not agree with the forensic investigator point. Apart from that, Chair, we are comfortable.
Okay. What is the reply of Action SA?
Thank you so much, Chair. Thank you for the input from the members. The problem with not being prescriptive with the timing of the questions is what we saw, the nonsense of the chairperson of higher education who abused his discretion and gave members 7 minutes to interrogate and cut members off while they were busy probing the line of questioning. So yes, we are open to changing maybe, saying to 30, but if we're not prescriptive about this, we then leave it up to the chair. So this is why we actually put the time frame in there. And then on crime intelligence, I'd like to also agree with Honorable Sauce, if required, right? What we're saying is that when evidence related to crime intelligence inevitably comes before the committee, we can't just close, just because it's not our mandate, Honorable Cameron, we can't just close our eyes and ears and say, no, we can't deal with it. We need to have a plan and we need to be guided. And this is why we've made that submission. I think that clarifies it, Chair.
Yeah. Thank you so much. The only matter where there is no agreement is with regard to forensic officer. So the other points are accepted by the meeting, correct?
That's fine. Yes, Chair.
Thank you so much. And we can now move to the next item, which is item 6.
Excuse me, sorry, Honorable Chair, my hand is up.
Honorable Sangon.
Honorable Chairperson, when you were giving parties an opportunity to present their submissions, you did not give an opportunity to the ANC to present its submission. And we do have a number of submissions that we had made on item 5.
Okay. No, I thought you had submitted it fine. You can go along with your submissions.
Thank you very much, Chair. I'm going to start from in the document. it is numbered as 5.3, which is on witnesses. So the ANC proposes that we add there on the witnesses that we may, upon a reasonable request, grant permission for any anonymous persons who wish to appear as witnesses before the committee, or where such evidence will be instrumental in achieving the objectives of the inquiry. I think that this point is closely related to the issues that have been raised around protection of witnesses, so the committee should be able to use its discretion if anybody should seek to make any anonymous inputs. We've also said that, and this is in line with the issues around the rules when summoning anybody, well, inviting any witnesses to appear, just to specify the purpose for which they are called, the specific matters that we want them to deal with. We've also said that the evidence presenter shall, subject to the committee's approval, determine the extent of the sensitivity of evidence at a given time and make a determination on the relevance of such evidence and how it will be held or dealt with. I think we're amplifying the point that sensitivity is subjective, and we would obviously need the committee to approve what is considered sensitive and how it must be dealt with. We've also, I won't go through all of that because they are there, Chair, for you to go through. But we've said that witnesses may also request assistance with the drafting of sworn statements. And in this case, we hope that Parliamentary Legal Services will be in a position to be able to assist and have the necessary capacity where witnesses require assistance with the drafting and preparation of statements. Then, Chair, we've also introduced the issue of privilege, that we should, in accordance with the Powers, Privileges and Immunities Act, be able to, and in line with Rule 168 of the Rules of National Assembly, that all witnesses must obviously have read to them the privilege. That the information that they will be presenting before the committee is privileged, and this also links again to the issues of self-incrimination. So before the chairperson reads a witness in, they must be able to read to them the issues relating to privilege. On the, I'm coming to a conclusion, Chair, the sequences of witnesses, we did propose that the chairperson can determine the sequence of witnesses and how they, when they will be called to give evidence. Again, this is not to gag anybody, but for the orderly functioning of the committee, that the chairperson may have discretion in terms of how the witnesses are sequenced, but also obviously making sure that all witnesses are afforded an opportunity to appear before the committee. Chair, then our last one, which I think though would have fallen away, had been our submission around the role of the evidence leader, which we spoke about it being the collecting, organizing, and presenting evidence. We had proposed the Constitutional Legal and Services Office would be doing that, but I suppose it falls to the outside person now. And then, our next point also falls away because we had said if the legal office was doing it, then we could seek an external legal opinion as and when required. So our main submissions, Chair, are on the issues of privilege and how we need to ensure that witnesses, as they appear before us, they understand, the law and their rights as it relates to privilege. I have comments on similar matters that are raised by another party, being MKP, who has not yet presented them. Thank you, Chair.
Okay, so now in your submission, you exclude the part that deals with internal legal services.
Yes, that is correct, Chair.
Yeah. It must be understood that it does no longer form part of the submission. Can we then move to the MKP to hear their comment on your submission?
Yeah, Chair.
Hello.
Okay, no, before Honorable Skosana comes in, I just need some clarity, Chair. I think there's an area where the honorable member spoke about the statements, sworn statements of witnesses to be assisted by the internal legal services. Does she also omit that aspect now, considering the fact that we have discarded the internal legal services during the inquiry?
Honorable Sangoni, are you modifying it to the external legal service appointed?
Sorry, Chairperson. Sorry, I was struggling to unmute. Chairperson, I am not sure. And you know, when you spoke about earlier, and I'm not reopening that point, you had wanted us to get a sense of the specifications, and I even want to say the briefing patterns. I'm not sure if members are saying that if all witnesses need support, they want to get the external counsel to do so. But I would think that on the issue of putting together a sworn statement, hence I made the point that I trust that legal services at least would be able to do that, because the witness would essentially be providing their version. Legal services did say that they have drafting capacity, but if members are of the view that it is something that should be done by external counsel, given the fact that the committee has taken a decision on legal counsel, we can do that. But we truly think that something of this nature can be handled by legal services. Thank you, Chair.
MKP.
Yes, Chair. A follow-up question, Chair, and it's out of curiosity. Can I continue?
You are allowed.
Yes, I want to have the correct understanding, Chair. So when she refers to witnesses, which witnesses? Witnesses from the public and witnesses from the departments?
If I may respond through you, Chairperson. You will remember, Honorable Chair, that part of the submission that had been made at some point by the EFF was that there may be witnesses or people who appear before the committee who may, for example, require legal aid. I'm making an example. Now, in the event that there is anybody who appears before the committee and needs assistance with the drafting of their sworn statement, then we are saying that we should be able to avail parliamentary legal services to be able to do so, because some people may not have the capacity to on their own put together a sworn statement. And as you know, I mean, the type of information that could come up in such statements could perhaps be self-incriminating, so they must at least be afforded that opportunity. Legal aid, as we were advised by the legal team, legal aid is not just open to everybody. There's a means test there. Now, if somebody just needs a sworn statement and they need assistance, at least we are saying that our parliamentary legal services should be availed to assist them. Thank you, Chair.
Can I add something very small on that?
Okay, Chief Whip.
Yeah, just to say that we premise this approach, Chair, from the understanding that witnesses are coming to help Parliament. That's our attitude. These are not people who are coming so that we can find crime against them. If in our findings there is something that is somehow adverse to one of the witnesses, so be it. But these witnesses, we want them because they must assist Parliament to ascertain the veracity of the information at our disposal. So that is where the issue also comes from, of saying, where somebody says, I'm a witness, I want to come before you, or you have invited me, but I'm unable to put together the statement in a way that is appropriate, legally sound and appropriate. Please help me. I have information that I want to be recorded, but I can't put it together the way that is required. Our view is that we should not say to them, well, go and look for a lawyer. We should be able to say, well, we've got the legal department, meet with a legal person there who can help you to draft your statement. So that is essentially a part of what motivates that position.
Thank you so much, Chief Whip. Can we then get to revert to the MKP for their comments.
Thank you, Chair. I just wanted to say on this matter, I guess from our input on this matter, we said it very clear. The issue of we witnesses, the legal representative role, which the witness can indeed, in a short adjournment, being advised, on privilege, on classification matters, they should be allowed. And in fact, the issue of, because I think I'll go back a bit, where there was a matter which was raised about anonymous witnesses, which is dangerous as well. I mean, if we get over 1,000 of these people sending and saying we are afraid of coming up, what hour are we going to deal with these matters? Because even me as well, as a member, if I'm dishonest, I write to you because I don't come up clear. I think people must come up very clear. Those who want to be protected, there should be a way of us as members knowing them, but we can't have those people sending things to us and saying we're going to deal with matters. Otherwise, we are inviting a lot of them. People just write and say, no, I don't come to deal with this matter irrespective. So I think we have to rethink about that to say how best can we accommodate such witnesses. If you look at the state capture commission, remember there were such things, and if my memory serves something, it was discouraged because really it opened a can of worms. We end up finishing this thing, after two years. Thank you, Chair.
Do you support or what? Honorable Skosana.
Chair,
Okay.
if I may come in,
yes or no?
Honorable Skosana is back.
No, I'm struggling. You can finish. I don't know what's wrong with it. You can finish up.
Yeah, no, Chair, we reserve our right here. We're not supporting or we're not rejecting.
Okay, DA.
Comfortable, Chair, thank you.
Thank you so much. EFF.
Chair, thank you. On the issue of the evidence leader making a decision on which witnesses must appear before us and who mustn't, I don't think we must allow that much power to be given primarily to the evidence leader. I do think they have the capacity, obviously, to determine whether the witness is going to provide to the committee is necessary. But we must also, as members of the committee, be able to engage the evidence leader and also for the evidence leader to give us a report or tell us in a meeting, we have excluded this witness because of X, Y, and Z. It can't be that the evidence leader is going to lead in that regard and members of the committee have no say, or we don't even know that a particular witness has come forward and the evidence leader has disregarded them. So there just needs to be some form of reporting that, for example, 10 people came forward and wanted to be witnesses, and out of these 10, we don't think 6 is appropriate for that, and just have that level of engagement with the committee members in the interest of transparency. Also, Chair, we don't want Parliament staff involved in this process of even witnesses, and it's for exactly the same reason why we do not want them to be evidence leaders. We want this process to be independent. Parliament does not have a reputation of being independent. The legal staff answer to the Speaker of Parliament. The Speaker of Parliament is an ANC member, whether we like it or not, and that is the truth. So if there are any witnesses that need assistance in drafting statements, as a committee, we need to make means available, as we do for many other things in this country, and this is something that is very important. Again, we raised the issue that we are spending 700 million on some dialogue that has collapsed, and now we must say that we must use staff, Parliament legal staff, to do something as critical as this. And then when we conclude this ad hoc committee, we are going to end up with lots of going back and forth, and the committee is going to lose its credibility when we issue our findings. So it's a big no from the EFF of having any of the Parliament legal staff to be involved with witnesses. Obviously, they give administrative support, but definitely not to be taking statements from witnesses. And as a committee, we must make means available to do that if we are actually serious about this mandate that we have of rooting out corruption in our criminal justice system. Thank you, Chair. So no, we don't support it.
Thank you so much, Honorable Matthijs. The IFP. The PA.
Chairperson, I think we must not always seek to blow things out of proportion. We should rather seek to ask clarity, like I would now. My understanding, and I just want to make sure, because of the submission of the EFF now, I just want to make sure that I understand it correctly. So if the ANC can assist. My understanding on the submission of the evidence presenter shall subject to the committee approval, shall subject to the committee approval, determine the extent of the sensitivity of the evidence at a given time, and make a determination on the relevance of such evidence and how such evidence will be heard or dealt with. I'm not sure if that's the submission that is being referred to. If so, my understanding of that is that the process is subject to committee approval. So the committee is involved in that process. And the assistance of assisting witnesses that doesn't have access to professional assistance for written documentary evidence and the format it should be done in, to assist, to avail parliamentary services, in addition to which other alternatives there are available to these witnesses. So it doesn't come across to me like there is a prescriptive model given here to say that witnesses must make use of parliamentary services. Rather, it is saying in addition to whatever is available and witnesses have access to, they can, whether it's legal aid, whether it's their own attorneys, but in addition to, Parliament also avails such a service. So it doesn't sound to me like it's prescriptive. But before I make my input or give the whether we support or not, may I please get clarity on whether my understanding of the submission is correct. Thank you, Chair.
Can I come in, Chair?
Honorable Chief Whip.
Yeah, because Sango's got a bit of a problem with network. Unless if Honorable Cameron also comes with a question, because I see his hand is up. Maybe with your permission, if it's a question, I can wait for him and then answer all together. I don't know. You will advise.
Honorable Cameron, is it a legacy or an old hand?
No, Chair, it's a comment, so I will wait for after Honourable Mthuli, because maybe it does give clarity to me as well.
Okay.
Yes, Chair. I mean, as you can see, what the sentence, how the sentence is worded, where witnesses require assistance, where witnesses require assistance. This accommodates a situation where witnesses are unable to get support anywhere else, but want to be assisted in order for them to prepare for their statement. Our suggestion is that the illegal division of parliament, this is the parliament of the people of South Africa, Chairperson. Never mind that, and it has always been the case, the parliament will have a speaker who's not coming from mass, is a member of a particular political party. But the legal division of parliament is a legal division of the parliament of the people of South Africa. So to make them available as an option to witnesses, we don't think that is a problem. It's not a prescription, it's an option. Lastly, what we also want to guard against, Chair, which I hope all members will be conscious about, is a situation where the legal people who are going to be hired by Parliament, whatever the number of those, are going to be heavily immersed in the preparation of statements for different witnesses that are going to appear before us, and then be diverted away from the primary task that they would be hired for, which is to give us a support, physical support in the meetings of the committee when it listens to evidence, processes, whatever information that is presented before the committee. So it is not a prescription, but we're of the view that it should not be a problem to make the services of Parliament also available for in such circumstances. Thanks.
So, with your permission, Chair. So, Chief Whip, you are saying my understanding is correct?
Yes, it's absolutely correct, Honorable Souls.
Okay, thank you, Chief Whip. Then, Chairperson, we support.
Okay. Honorable Cameron, do you still want to ask?
Yeah, sorry, Chair. No, I just want to say I slipped up slightly earlier. I just want to say one part that we are not comfortable with, and that is the specific part regarding the role of the evidence presenter in terms of determining the whether something should be presented or not, whether it is relevant or not, etc. So that's very important to us. I don't think it must just be the sole responsibility of that specific individual. And then just in terms of Parliament's legal services, I want to concur with Honourable Matthys regarding the role of Parliament's lawyers to people from the outside. I don't think that is their role, and I think it's important that they stick to their mandate as we should stick to ours. Thanks, Chair.
What is the point about the external persons that we shall have appointed? Honorable Cameron, you want them to be the one that help witnesses who may want to make some statements.
Chair, thank you. I think if the way that Honourable Mthuli described it, that it is an option to them and legal services are able to do that, I guess we can't object to that. But I certainly don't think it should be the only way to do it, because if they want their own counsel of some kind, they should have the opportunity to do that. My most important comment regarding it, and that's why I added what Honourable Matthys said, is that we mustn't fall into a space where they only have access to parliamentary legal services. I just think we should be careful of any kind of a conflict of interest. Thanks, Chair.
Okay. Can we get the reply of the ANC?
Oh,
Okay.
Chair, my hand was up. My hand was up.
Before Chief Whip, can we get the Action SA?
Thank you, Chair. I see you are tired now, but okay. In response to the ANC, we can live with this submission, but we can't support the submission regarding the chairperson's discretion in determining the appearance of witnesses. I'm just looking at page 17, the last submission. Chairperson shall be empowered to determine the sequencing in which witnesses are called to give evidence. We reject that. It has to be the committee. Witnesses questioning is to be subjected to reasonable limitations. We also reject that. It must be the committee. And then also the ANC's last point about time limitations to be determined by the chairperson. We've already dealt with that when the committee agreed to Action SA submission. So it is then automatically discarded, I would think. No need to consider it since we're going back and forth now. Also, can we also please avoid the chairperson from deciding? Instead, it must prioritize facilitating, the chairperson must prioritize facilitating joint decision making, given the nature of this committee. Thank you, Chair.
Okay. Whose hand was up?
It's myself.
Mine, Chair.
Ngola, Chair, also.
Okay, let me take Honorable Nomvalo.
I just wanted to draw my actions from what has been presented here, and which I do not have a problem with. That I think we must persuade the ANC to discard this aspect of saying that the legal team, the parliamentary legal team, can assist witnesses, because I think
Is it me, Chair? I can't hear anything.
No, it's not you. I'm also listening.
Very bad, because not everybody. Chair.
Honorable Nomvalo.
Yeah, I can hear you very well.
That is the only time we start hearing you now.
Where did you lose me, Chair?
All the time. Hello, Honorable Nomvalo.
Okay, Chair, I want my action from what has been presented here. Chair, I can hear you very well.
Yeah, Chair, but what I'm saying is that we struggle to hear the point that you wanted to make.
Yes. Yes, Chair. Am I audible now?
We can hear you now.
Chairperson. Hello. Chair.
Honorable Nomvalo.
Yes, Chair. Am I audible?
We can hear you.
Can I continue, Chair?
You must start from the point where you wanted to make your submission.
Yes, Chair. Chair, I was saying I think I am going to draw my submissions from a precedented practice here, which I agree with. which has been presented by the chief whip of the ANC, of persuading people to discard some of the aspects. I want to persuade the ANC comrades that they discard this one of saying that the Parliamentary Legal Service can assist witnesses, because, Chair, not only people that are going to assist us as the committee will be called before the committee. We're also going to call people who are implicated through the evidence that has been accused before us. And some of those people take against some of those people. I mean, adverse findings against people, they just become creative and want to point, I mean, they want to capitalize with minor administrative mistakes. We do not want to a situation where the legal parliamentary team will be blamed in future. If the matter, for instance, is taken to court, where you will find people who say, I was ill-advised legally. So I'm saying, Chairperson, we must not look it from a perspective here that people who will come to the committee are people who are going to assist us. It's not only people who will assist the committee who will come before the committee. It's people who are going to be called because they are implicated to a certain extent, and to a certain extent, some might refuse, and we might subpoena them. Now, to use the resources of Parliament that is investigating to assist such people will be suicidal, and it might backfire in future. I think the EFF chair was making a very good recommendation when they were saying a person can be legally represented by a legal person of their choice or the legal aid, because if you do not afford the lawyer, you go through a means test at the legal aid. We do have an institution here in South Africa which assists people who do not afford financial. So there is no need to divert the work of the parliamentary legal service team, to people who do not qualify to be assisted by it. So I'm saying, Chairperson, I persuade the ANC to discard this. They must look at it from different angles, not at an of people who will come the only case. Thank you very much.
Thank you. Can we get the reply of the Comrade Honorable Nhlanhla?
Oh. Thank you very much, Chair. I think I cannot overstress the issues that have been explained. That what becomes the intention of why we think that the Legal Services Unit of Parliament can help at the time of need. It's not a compulsory provision. It's when one can be able to solicit their own legal services practitioner to help them to construct some statements and stuff. And I'm sure Honorable Mkhwanazi knows, because he also serves in the Justice Committee. On the workload legal aid has as we speak. We've been discussing for quite a very long time on the one practitioner versus the files they are dealing with. So I'm not quite sure if we want to overstress legal aid as well. But beyond that, the doctrine of separation of powers, this is a legislative approach to the allegations leveled by General Mkhwanazi. Now, we are establishing, as a legislative arm of government, our own process. Now, in that process, remember, we've even made decisive remarks on that the work of the Judicial Commission is an executive work. Now, we still want now, because legal aid is part of the executive. Now, we want to take that portion of the executive to be part of our own legislative process. I'm quite not convinced about that. Secondary to that, Chair, is that The list of witnesses is actually a committee work, is actually a committee product. So what merely the work of the evidence leader is to compile from the allegations, come and brief the ad hoc committee and say, out of these things that were said in the public, there and there, we think that these persons are persons of interest. Now, we want, therefore, the ad hoc committee to call them to come and testify before the ad hoc committee. So it still remains the work of the ad hoc committee to say, no, remove this one, enter this one, or don't remove anyone, enter that one and that one. So it still remains our work. So there is no issue about it, Chair, because their work is only to compile the work and assist the work of the committee. Whoever is being called to the ad hoc committee testimony is actually an agreed upon person by the ad hoc committee. So as we're trying to convince each other, Chair, I'm saying let's leave it like that. But beyond that, Chair, we're going to have a problem if I've never seen, Chair, anywhere where in a guiding document we put minute limitations. Let's have confidence, Chair, in you to guide us. I may take 5 minutes. Or Nomvalo can take an hour. I know it always does anyway, in a lighter note. So let's give that work to you, Chair, and not stretch ourselves and put that in the terms of reference, the time frame period, and allow you to guide us as the chairperson that we elected and opposed in our inaugural meeting. Thank you very much, Chair.
Sorry, Chairperson, I had my hand up, if I could, before the Chief Whip comes in.
Okay, Honorable Sangoni.
No, thank you, Chair. No, I just wanted to clarify something that has been said in the meeting, Chair, that our submission says that the evidence leader would choose who comes before us. I want to read verbatim our proposal. It says the evidence presenter shall subject to the committee approval. So firstly, the evidence leader subjects to approval by the committee a determination on the extent of sensitivity. So we have not called on the evidence leader to tell us who to bring, not bring, and what as it was presented here. We said earlier on that there are matters of a sensitive nature. We all agreed that sensitivity is subjective. Then we said, so what we are proposing is that once the evidence leader has collated the material, like we are saying, they may advise the committee that they are sensitive matters. The committee can choose to agree or not agree whether they are sensitive, and then the committee itself would then make a determination on the relevance of such evidence and how such evidence would be heard or dealt with. We are not in any way proposing that it is the evidence leader that determines. Similarly, nor are we proposing that it is the chairperson. The requirement, or in our submission as it relates to the chairperson, we talk about the sequencing. Now, the sequencing is a program which the committee anyway would present to the committee to say that we are suggesting this sequence of witnesses. And if the committee feels that C must come before D or come before A, but somebody has got to do that work. And that is why we had put it to the committee. My last issue, Chairperson, we really want to do as MK is saying, be persuaded on certain matters. But it seems incorrect, Chairperson, that we would want to persuade one another on limiting options for people who may not have means. We did say that legal aid is an option. Legal services in Parliament raised the question of whether people will be able to access legal aid because legal aid has got its own requirements. You must be, not indigent, but if you earn a salary like me and you, but I cannot afford legal representation, like I know I would not be able to afford legal representation, then legal aid is not an option for me because I will fail the means test. Now, why would we want to take away an option an option for people to say, if you are unable to pay for your own lawyer, you fail the means test at legal aid, then you have an option to approach Parliament to help you put together a sworn statement. That is not legal advice. It is not guiding a witness on what they must say, and whether they are there to be helped or they are being incriminated or what. When you put together a sworn statement, you just basically tell your version of the statement, and people do need support in being able to put such a sworn statement before the committee. I don't think that anybody wants to go there and just having written a statement. So it's an option that we are saying for those who may not afford legal representation, who may not be able to get legal aid, this is another option they may utilize. Thank you very much, Honorable Chairperson.
Before we take, which are the avenues that are available for people to be assisted with sworn statements?
Chair, I've raised my hand for a very long time, and Sangoni came in before because I don't know, maybe you see our hands or not on your side.
Okay, I will come to you. I'm asking a question here. Which are the avenues that are available for people to be assisted with sworn statements?
Chairperson, I'm not sure if that question is directed to me, but from my own knowledge, it will be legal.
The legal team must respond to the question.
Chairperson, if I get you, you're asking a question of what options do people have, and I think in part we've said legal aid, Chairperson, has got its own means test. I mean, in assessing, the financial viability of a person. And of course, if I look at our own experience, Chairperson, even with regard to Section 194, I know for a fact that the evidence leaders were assisting people with drafting written sound statements. I don't want to say, Chairperson, we must also be an option because you can see we're being lynched, Chairperson. So members must decide. I can't say we must do it ourselves. I think members must decide. Thanks very much.
Okay. Honorable Skosana.
You are a lifesaver, Chair. You know, the legal department, what they said now, I wanted to say that. Section 194 core committee, the evidence leaders helped the witnesses who were called in that committee. Two of them distanced themselves from some of the statement which were put into their statement, sworn affidavit. I just wanted to caution this committee that the evidence leaders who went to write statement for witnesses, unfortunately, it backfired because those two witnesses, Samuels from Free State and Puta Ditseho, if I remember the word well, distanced themselves. Just want to say that we are going back to the same people. So all those witnesses, I feel pity for them if we agree that their statement will be written by the evidence leaders. Thank you, Chair.
Okay. Your reply, Chief Whip.
Chair, thanks, Chair. I think Kusela has clarified to a larger extent what we were suggesting. It would be very strange that because some among us, because not all of us, some among us have lost confidence entirely to the legal service of Parliament, we also want to impose that position to people who may be assisted by the legal services of Parliament. I don't think that is the best way to handle the issue, Chair. Our view is that after all said and done, if a person is unable to acquire assistance to prepare their own statement or whatever statement, it should not be our business that the person decided to go to the legal division of Parliament and obtain the statement. Our view is that we still have to retain it as an option. It's not mandatory, it's an option for South Africans who may not have the same low level of confidence and trust as others among us have towards the legal service of Parliament.
So the final submission is that South Africans may use legal avenues available, recognized legal avenues available to make SON statements without us prescribing where they should go. If, for instance, I come before the ad hoc committee with a SON statement, is that a problem?
No, it should not be a problem, Chair, because we are not prescribing where you must go and get.
Yeah, that is exactly why my feeling would be that for as long as a committee or as an institution of Parliament, we recognize the avenue where the SON statement has been made. Those who qualify to go to legal aid, let them go there. And those who qualify to go elsewhere, let them go there without, like you say, Chief Whip, without being prescriptive or mandatory. So long as the document that will be presented before the committee is acceptable as a SON statement. Does it make sense?
Oh, Chair, as I said, when you raise hand, perhaps you don't say it. For me, for Umkhonto, and for the people of South Africa as well, because we are representing them there. The issue, as I said, I don't think there's any problem if somebody comes there on his own, in my own view. But the issue which I've raised now here must be recorded. Evidence leaders wrote affidavit for 2 on section 194, which the legal advice there from Parliament was mentioning it now. And the 2 witnesses distanced themselves. I'm talking about qualified people. Samuel is a lawyer by profession, and Purechevo was holding an LLB degree. But I don't know why those affidavits were done by the evidence leaders. But they misled them. Hence, they had to distance themselves from those affidavits, those sworn affidavits. So I was just saying that, Chair, they can go there because the chief whip said that we should not lose confidence because some of us here, we don't have confidence in the legal. Yes, we don't have. I must put it very, very clear. We don't have. Thank you, Chair.
Honorable Skhosana, do you agree that let us not be prescriptive on this matter? It must be the choice of an individual where to make a SON statement.
Chair.
I agree, Chair. I agree, Chair, on that. Thank you, Chair.
Chair.
Okay.
Chair.
Let me check with.
It's me, Julie.
Honorable Maliam.
No, I want to raise a concern. If you allow Honorable Skhosana to behave the way he's behaving, it's going to make mockery of this place. And some of us don't want to participate in such things. I mean, we all are raising hands here, and you don't recognize us. And we don't keep on pushing. I mean, he has been speaking here alone. And it's unacceptable that. It's not done. We must treat each other with respect. And we must know that sitting here amongst others, they are party leaders here. So this treatment that we've been subjected to, we thought at some point we are going to be very firm on it. And secondly, which is the point I came in for, is that the summary you are giving is reconciliatory. Because there is nothing mandatory that says you must go to Parliament. It is one of those options that are there, and people must choose for themselves, not by us forcing them to go and choose. And if they go later and say, those people of parliament did not advise them properly, but it is your own choice. No one dictated to you to go and choose from parliament or from legal aid or anything of that sort. So I really think that your intervention is taking us somewhere. But the fact that you are being so reasonable and accommodative and trying to get everybody else to speak, it must not be allowed to a point where it looks like your authority is being undermined as a chairperson. Like to a point where we just feel like we are useless, we can't do anything. We just sit here and listen with a hope that the sanity will prevail at some point. This is going to be a committee that is going to enjoy a lot of attention from our people. How it conducts itself and how its own members conduct themselves. That is what will build confidence in our people that indeed we're going to find them justice. Thanks, Chair.
Thank you so much, Honorable Malema. You know, I raised that point before that the members of this committee must know that they are representing the Republic of South Africa. And I left it there. I did not want to elaborate on it. But my understanding is that the political parties in Parliament have sent to this committee the people that they regard as the best from where they are coming from. And I hope that we will keep that standard and that expectation from the people of South Africa. And it's not being said for the first time. We said it in many occasions in our committee meeting that, you know, South Africans have lost faith in our institutions. And we now have been given a chance to restore the faith of South Africans in institutions that must represent them. I hope that we will not come back to a matter like this one again. Thank you so much. Honorable Nomvalo.
Yes, Chairperson.
I see your hand is up here.
No, it's a legacy hand, Chair.
Thank you so much. So, honorable members, we have come to the end of this discussion. We will not compel or prescribe or mandate witnesses who will be coming before this committee where they should obtain sworn statements. There are avenues in the Republic where people can go and obtain those statements, either through the use of legal aid or through the use of private legal counsels or any other institution that is capable of administering that. So long as any document that will be appearing before us from the guidance and the advice that we'll be getting from the external legal services that would have appointed, the document is deemed valid, the committee will have no reason not to recognize it. Can we move to the next item? The MKP, did you still have submissions to make on item 5?
Chair.
Hello, Honorable Skosana.
Chair, I'm a bit lost because sometimes when we raise hands here, you can't, it's very rare that you pick our heads up. Because I was listening and I was in fact not sure what the last statement which you were saying, that you said to members they must behave themselves, they bring the best of the best. I'm not sure what was all the complaint about. Can you please clarify before you pass there? Because I don't want to lose anything.
Which statement?
Say you've already said, Honorable Malema said something about he doesn't want to be part of, so I wanted to find out what was the problem. Because I only heard when you close to say that you've been talking to members that the public has lost confidence. What was the problem?
He raised concerns here on how committee members sometimes conduct themselves.
Well, it was a general statement. No, it's fine if it was a general statement. Because remember, when we raise our hands here, then if you don't notice us.
It was not a general statement. It was a statement directed at you. It was not a general statement.
No.
I don't make general statements.
Yeah, but Chair, no, we can't. You can't allow that, Chair.
You're calling my name. You're calling my name. You want to know what I was saying? I'm saying to you, we're not going to be disrupted by you here.
I'm saying,
just
Chair,
budging in the way you want.
Recognize people first before they talk.
But you have been budging into this meeting the whole day.
No.
We have been budging into this meeting the whole day. And then you want us to accept that.
No, I'm not going to accept that too. I have to be respected when I raise my hand.
No, you must behave. Stop harassing us like we're owing
you are the one who's.
You are harassing us.
Can I
Keep him quiet.
come in there?
No, I'm not going to accept that. If a person wants to direct to me, he must say, he must mention my name.
Order, honorable members, order.
Please prevail on this.
Order, honorable members. No, there is no need to prevail. We have prevailed a long time ago.
Yeah, Chair, can I come in?
No, listen. We need here is for you as committee members to tell me how much hours you need. I will give you. And then when we are ready, we will proceed. What is the amount of time you need so that I can give you, and then we will resume the meeting at the time when everybody is ready, that the meeting should now go ahead. If we are ready to proceed now, you can say, no, we are ready to proceed. Let's proceed. You are members of parliament. We can't keep on reminding you that you are members of parliament. You are the highest institution in the Republic of South Africa. And only one person can speak at a time. Please, we can't continue like this. We have not even got to the business of this committee, which is to conduct proceedings. I don't know what is it that we are wrestling for now when we are not even in the proceedings. The matter which was at hand has just been concluded. No, honorable members, we can't go on like this. We can't. And that is why, as the chair, it is not my work to restrain your conduct. My work is to bring items on the table. Can we move to the next item? And I said I wanted to check with the MKP if you still had an outstanding item on number 5. That is the matter we must deal with.
No, Chairperson, we have no addition to item number 5.
Okay, thank you so much. So, honorable members, we must now move to item number 6. All the parties have been rounded up on item number 5. We must now move to item number 6. And if honorable members need a break, there is no problem for you to suggest that we request a break. You need a break of 1 hour, you need a break of 2 hours, it's okay.
Chairperson, clarity, please. My hand is up.
Honorable Sangon.
Thank you, Chair. No, I just wanted to check if MK says there's no additions, they do have submissions on section 5 that we have not considered. So I just wanted clarity in them saying that there's no submissions, as in we can now comment on their suggestions. They do not have further motivations, Chair.
Can I respond, Chair?
Honorable Nombalo, yes, you can respond.
And Chair, this is the way you are going to come in, because when we raise hand, you don't see us. I don't know where the problem is.
No. I'm looking at the board now. The only hand that is up is the hand of Honorable Sangon.
No, but I'm saying it has been a case since we started, Chair.
Okay, no, it's fine.
Yeah, but to directly respond, Chair, to Honorable Sangon's question, we thought we are following the same sequence that we have been following, of allowing a party that made a submission to either motivate or make some additions. So we're saying we're happy with the manner in which it has been included here, and we don't have any further additions. So we're hoping that maybe after, then it will be engaged, and then we come back at a later stage.
Okay, can I check? Because the submissions of all the parties have been exhausted and or motivate the submissions that you have made on item 5.
No, Chair.
Is it you, Honorable Nombalo, or Honorable Skosana, who is confirming?
Yes, Chairperson, you'll forgive me. I'm on the road, so I keep on losing you. I couldn't get your response, Chair, to my inquiry, to my question. What was your last statement?
I wanted to check if you are by any chance motivating or commenting on your submission.
No, we're fine with the manner in which they are appearing, Chair.
Okay, so now we move to take the comments of the parties. And Honorable Nombalo, I just want to satisfy myself. Is all the comments that you made on item 5, isn't it?
Yes, Chairperson.
Thank you so much. Can we start with the ANC?
Thank you very much, Honorable Chairperson. I think the items that appear at the beginning of section 5 we have already dealt with, but on the MKP submission 5.4.2, there's an insertion there from the MKP that says that a topic matrix will be circulated to members at least 48 hours prior to each hearing. Now, I think as the ANC, we're just asking for clarity what that means, because our understanding is that the statements, the sworn statements, and any supporting documents will be shared prior to the appearance of witnesses. In fact, we had said, if I'm not mistaken, 7 days before. So what exactly is this topic matrix that must be circulated to members, and who is expected to develop this topic matrix? Then the point afterwards, which says that where a witness raises classification or privilege questioning shall pause pending a ruling by the chairperson. Now, we had submitted, and it was accepted by the committee chairperson, that in terms of Rule 168, the chairperson will obviously read to the witness, what is this thing? Rule 168, which says that prior to a witness giving evidence before a House or committee, the chairperson shall, in accordance with Section 16 of Powers and Privileges Act, inform the witness of their rights, including privilege and so forth. So we are not sure why then there's a need to pause, given the fact that the chairperson would have indicated to the witness what their rights are in that case. That builds on a point, chairperson, which says that it's on the next page, I think. The committee will avoid questioning that foreseeably prejudices pending prosecutions unless necessary safeguards are applied. And then now our question is, if you apply Rule 168, and you look at Section 16(2) of the Powers and Privileges Act, it says that a person who's being examined under oath may be required to answer any question put to him or her in connection with the subject of inquiry, produce any document, and we believe that it would be irregular then to say that there are areas that the committee must not venture into, because what then is the point of this? I think members have been saying over and over again that we need to ensure that this process is as thorough as possible, and we think that there may be a problem with putting limitations on the questions that the committee must ask. And it would be incorrect for us when the Powers and Privileges Act is very clear that anything that is raised before a parliamentary committee cannot be used in criminal investigations. However, I mean, I think members know the Powers and Privileges Act. So we have a problem with the limitation of the committee in terms of questions that they may pose to witnesses. And we think that that is going to be problematic. Chairperson, I think, if I'm not mistaken, our last contention on the MKP suggestion is the one that is inserted in 5.6.4 that says a witness's legal representative may note concise procedural objectives for the record limited to scope, privilege, or undue prejudice. Now, this links to what I was saying again, that the last thing we want is for people to be coming to the committee with the intention of either evading answering of the questions or delaying us in the work that we need to do. We've already said that legal representatives would not be presenting evidence on behalf of the witnesses. It would be the witnesses who would raise issues. And we think that keeping that in there would be open to abuse. So legal representatives should not be speaking in the committee or even seek to raise points in limine. We're not in a judicial system here, and we think that the committee must be allowed to undertake its work as effectively, as transparently as possible. The other points, Chair, I think I won't go into, we've already covered them, like the issue of the minority reports, objections, but also we've already spoken to the need to uphold the odi alteram principle. So let me stop there, and thank you very much, Chairperson.
Thank you so much. Can we get clarity from the MKP?
Chair, I'm going to speak because you've recognized me, and I'm saying on the matrix issue, on the matrix issue, because we've already agreed that it will be 7 days, not 48 hours. That can be taken off. 5.4.4. Because already we have agreed about 7 days circulation to members.
So the topic matrix, you are now removing it.
Yes, I mean, it won't make sense because already we have already agreed that it will be circulated within 7 days.
Okay.
Prior to each hearing.
Okay.
And then the other issue which is raising the issue, we understand exactly what ad hoc committee is all about, and I'm not going to say, what is the interpretation, no one wants to be lectured about that. We know exactly what is in front of us. So when we raise these issues here, that the witness shall be informed of their constitutional right against self-incrimination and processes for claiming such a privilege. In the previous, like you, I think, was it not you? It was the legal advice. You mentioned the SABC. If I remember, the ad hoc committee. If you go back and get that report itself, I mean, we have to make sure, Chair, that the constitutional right of any witness is a priority for our witnesses. They should not be prejudiced at all. And the last point, which it was raised here again, the issue of the matters which are before court. I think the understanding which we understand according to this Western law, this Dutch Roman law, is that we have to take into cognizance, Chair, that the matters of this committee with the sensitivity, people should not be put into a gallows or like in a where they'll incriminate themselves, that at the end of the day their matters are still in court, and we as a committee, we want to debate those issues. And I think in one of the early, I think it was on 4 point earlier, I think we discussed that matter, that if a witness comes in to the ad hoc committee and say, I'm not going to say anything, this matter is classified, what are we going to do as a committee? I think this from us clarifies that, to say we have to give our witnesses protection as well, in terms of their constitutional right. I think my colleague will take over from that. Thank you, Chair.
Okay, do we still have any member from the MKP who will still want to clarify further?
Chair, Nomvalo is having a problem. I don't know what's wrong with the network, but be that as it may, I guess I've made our inputs and clarified.
Honorable Skosana, you have spoken, isn't it?
Yes, I'm just saying that Nomvalo's got a problem, Chair. I'm just reporting that to you as he reported here, because we've asked if we still have another member of MK. Thank you, Chair.
Okay. The ANC, do you want to comment?
Yes, Chair, I think Kusela, she's there.
Thank you. Sorry, Honorable Chairperson. No, Chair, I think we've heard what the Honorable Member from MKP is saying, and perhaps we must listen to the views of other committees, but we still hold the view that we should not be trying to build safeguards that people can hide behind. This committee must be transparent in doing its work. It is not for the committee to go and protect people. There are laws that protect people. One of those is the Protected Disclosures Act, the Powers and Privileges Act, that indicate that information that is before Parliament, how it should be treated, and what privileges, powers, immunities there are. So for us, in our terms of reference, to want to then put in clauses, phrases that people can then use not to give the full information to the committee is problematic. So we are not supporting these additions at all. This committee must be transparent and it must dig deep into the issues without people hiding behind technical reasons of privilege, because the law already covers that. Thank you very much, Chair.
7.5's input by MK, right?
Can we go to Honorable James? Can you please mute yourself? Can we go to the Democratic Alliance?
Thank you, Chair. Just very briefly, we don't mind most of them. The two ones that we are just cautious about is that the relevant safeguards that MKP have proposed mustn't delay or dilute any of the questioning. So it's important that that just be noted. And then the other one was on the topic matrix, but seeing as they've asked for that to be removed, we submit. Thanks, Chair.
The Economic Freedom Fighters.
Thank you, Chair. We share the sentiment of not including in the terms of reference matters that are going to halt transparency or, not ensure transparency from the witnesses. And as there are mechanisms in place to ensure that witnesses are protected. And then we note the withdrawal also of the MK on that one section. So we're fine with that.
Thank you, Honorable Mnwango.
Well noted, Chair.
Honorable Sols.
Honorable Chair, the MKP submissions is a contradiction to what we want to do here. It also limits our scope of questioning and the ability to properly interrogate, scrutinize, investigate, as outlined in our objectives. So no, we do not support.
Honorable James.
Thank you, Chair. 5.2A, we reject. 5.2B, we support. 5.34, we support. We support. And the rest we have no view. Thank you, Chair.
Okay. Can we, Honorable Malema, I see your hand is up.
No, Chair, I wanted to align with the ANC's view on this because it is very clear that the way it is framed, it's problematic. It looks like it's trying to hide some people behind certain things. And those people are all well protected by types of laws we have, powers and privileges. And those people are going to be told even before they do anything of their rights and then take an oath. Certain things that they say in Parliament may not even be used against them in those other cases where you're saying they're going to self-incriminate and all of that. So there's just a concoction of confusion there, which I don't want us to align with. I think Honorable Khosela captured it very well. Thanks.
Can we have the reply of the MKP?
Chair, thank you very much. And I guess that the issue of that clause, that input, if members are not comfortable with it, there's nothing to hide, Chair, because we've got a lot, which we think that it will come to the committee. If that clause is not comfortable with the majority, can be taken out. No squalms about it. We don't want to cast aspersions to anyone. There's nothing to hide here. In fact, we can't wait to begin this work as Umkhonto Wesizwe Party. Nothing to hide. There's no one who's going to be protected. People who are protecting people will be exposed in no time. And I can tell you now, we did not put that because of any other nefarious reason. and I understand if people are not happy with that. And Mkondo Wesizwe, it's not like the sun is going to go down because of that clause. It can be taken up now. No issues about that. No one must hide anything. In this committee, every member who's going to come and witness here, as General Mkhwanazi has said, and I think people are ready to come and testify and expose all these issues which concern South Africans. Because it's not only about us, it's not about members of parliament, it's about the people of South Africa as a whole. Thank you, Chair.
Thank you so much. I think honorable members were in agreement that submissions that will potentially constitute an impediment to the committee accessing information or diligently probing are not going to be part of this terms of reference. We had this debate earlier in the morning, if you remember, when we debated the protocol on access to classified information. So the same spirit that prevailed during that debate is the same spirit that must once again pervade our discussions here. So we are in agreement that those parts, Honorable Skosana, will not be part of the terms of reference. And the rest of the submissions which committee members have expressed happiness will be included. Agreed?
Agreed, Chair.
Agreed, Chair.
Thank you so much.